No. Bail. Hearing matters we are not adding further. We can't reach these matters also. Thank you. Bill in connection, we will take. Call. Yes.
Milord, I'm for the appellant, Milord.
Yes.
But this is an application, Milord, for suspension of sentence.
Other side is not there.
My mistake.
Yes. Here.
This is
Please
the
take your
affidavit of service.
Mr. Chakraborty, you can take your seat. We'll just see.
We have also, Milord, served the victim, Milord. It is
Oh, good. Affidavit of service. Yes. What is the matter? POCSO.
POCSO, Milord.
See.
Milord, at the very inception, I'll like to take your lordship with some timelines. Milord, the incident.
First, tell us, Dr. Chaudhary, how long you were in custody?
Milord, I'm in custody for almost 3 years now.
3 years. And excluding whatever period you were out?
No. I was never out.
Never out. All right. And your age and the victim's age?
Milord, I am now, Milord, I am a septuagenarian person, 75 almost.
At that time?
That time 3
years. 60s. Very well. And the victim?
Victim is 14 years old.
That's very well. What is the matter?
Yeah.
What is your case?
Now, Milord, the timelines is, Milord, January 2022, Milord, the incident happened. Milord, FIR registered on 5th of June 2022, Milord, almost 5-6 months. Milord, charge sheet submitted on 2nd of August 2022. Milord, charges framed on 16th of August 2022.
Yes.
Milord, after that, PW1 and PW2 examined on 25th of August 2022. 10 days, 9 days after the charge. Milord,
2024.
2022, sorry.
So all are 2022.
Yes, all 2022.
Yes.
Milord, 3, 4, 5, 6, 7, 327 on 26th August, next day.
So good for you.
No, Milord, I'll come to that. Why, Milord? This is actually a hurried trial, Milord. I did not get any time to bring my defense. Milord, 8 to 11 on 29th August. So, Milord, within a period of 3 consecutive days, witness number 1 to 11 were examined on this order. Examined, Milord, within 3 days. Milord, the victim was examined on 25th, Milord, that is the first day of examination. Milord, without any notice to me, because victim was not a charge-sheeted witness. Milord, she was brought to the court, 311 application was given, it was allowed then and there, and she was examined. So, Milord, without any opportunity for preparation, on the very same date, Milord, I had to cross-examine the witness as well. So, Milord, on this aspect, Milord, this is actually a hurried trial, Milord, where the defense did not get opportunity to bring its case on record.
Did you bring any witnesses?
I brought a defense witness, Milord, after, but that is not relevant. Because
so after so you say regarding cross-examination also did not get time?
No, Milord, same day, yes. No notice was given.
3 days, 11 witnesses, so did not get time.
All vital 11 witnesses.
Did you actually cross-examine?
Milord, I did cross-examine legal aid.
Without preparation.
Legal aid counsel, Milord, he was asked to cross-examine by the court, he had to.
Very well.
Now, Milord, on this aspect, I will be, Milord, referring to a judgment of the Honorable Supreme Court.
Yes.
Milord, para 21 onwards.
No, this 16th of August 2022 is the entire. No.
16th August, the charges frame. Milord.
Charges. Yes,
para 21. It's Anokilal versus State of Madhya Pradesh. Page number 28, paragraph 21.
Para 21, yes.
Yes. So it says, in the present case, the amicus curiae was appointed on 19th of February 2013, and on the same date, the counsel was called upon to defend the accused at the stage of framing of charges. One can say with certainty that the amicus curiae did not have sufficient time to go through even the basic documents, nor the advantage of any discussion or interaction with the accused, and time to reflect over the matter. Thus, even before the amicus curiae could come to the grips of the matter, the charges were framed. The provision concerned, that is section 227 and 228 of the code, contemplate framing of charges upon consideration of the record of the case and this document submitted therewith, and after hearing the submission of the accused and the prosecution in that behalf. If the hearing for the purposes of these provisions is to be meaningful and not just a routine affair, the right under the said provisions to denied to the appellant. In our considered view, the trial court on its own ought to have adjourned the matter for some time so that the amicus curiae could have the advantage of sufficient time to prepare the matter. The approach adopted by the trial court, in our view, may have expedited the conduct of trial, but did not further the cause of justice. Not only were the charges framed the same day as stated above, but the trial itself was concluded within a fortnight thereafter. In the process, the assistance that the appellant was entitled to in the form of legal aid could not be meaningful. Milord, next page, para 26. Expeditious disposal is undoubtedly required in criminal matters, and that would naturally be part of guarantee of fair trial. However, the attempts to expedite the process should not be at the expense of the basic elements of fairness and opportunity to the accused, on which postulates the entire criminal administration of justice is founded. In the pursuit for expeditious disposal, the cause of justice must never be allowed to suffer or be sacrificed. What is paramount is the cause of justice and keeping the basic ingredients which secure that as a core idea and ideal. The process may be expedited, but fast tracking of process must never ever result in barring the cause of justice. In the circumstances, going by the principles laid down in Bashira, we accept the submissions made by Mr. Luthra, the learned amicus curiae, and hold that the learned counsel appointed through Legal Services Authority to represent the appellant in the present case ought to have been afforded sufficient opportunity to study the matter, and the infraction in that behalf resulted in miscarriage of justice.
Dr. Chaudhary, in this case, do you have any records when your counsel was appointed? No.
Not to that effect.
Very well.
Yes.
So this is the main ground of your.
No, not this. Well, this is one of the grounds.
Yes.
Milord, apart from that, Milord, my case rests on the DNA report. Now, Milord, the supplementary charge sheet, Lordship has seen 29th August.
Section 6 is penetrative.
Yes, it's penetrative.
Aggravated penetrative.
Yes. Milord, Lordship has seen 29th August was 11th witness was examined. On 6th of September, Milord, a supplementary charge sheet was filed, placing the DNA report on record. Milord, almost at the fag end of trial, when 11th witness was examined, and after that, two dates, Milord, the trial prosecution witness was already over. So, Milord, at that time, the DNA report was.
Now, what are the 3 days when the prosecution witnesses were examined? The dates?
25th, 26th, 29th.
What? August?
11 witnesses examined. Thereafter, 7th September and 19th September, Milord, trial closed.
7th and?
7th and 19th.
All right.
Now, Milord, the main contention is, Milord, the author of the DNA report, the scientific expert, Milord, she was not summoned as a witness, neither she was examined, Milord. The contents of the reports were not proved in the court.
All right.
Milord, to this aspect, Milord, I will be referring to a very recent judgment of the Supreme Court, Milord, which I have erstwhile also I have relied upon. And this Honorable Court, Milord, your Lordship sitting with Honorable Justice Prosenjit Vishwas, Milord, had taken, Milord.
ট্রায়াল কোর্ট শেষ করে তারপরে সাপ্লিমেন্টারি চার্জশিট ফাইল হচ্ছে।
This is a
DNA supplementary charge sheet. What was your argument on that? It was filed on 25th.
It was filed on 6th of September 2022. And Milord, at the fag end of trial, it was placed.
Yes.
Milord, the scientific expert, Milord, who has prepared the report, was not
Not that you have said. Yes. Yes.
So, Milord, in this aspect, Milord, this is the coordinate bench judgment.
Yes.
Milord, para 2, Milord, we have relied on a judgment of Rahul versus State of Delhi, Milord, where the relevant portion was extracted by your Lordships. Milord, then para 4, Milord. Para 4. And para 7 is the relevant contention, Milord, I am raising. The scientific officer who authored the report and conducted the examination was never produced as witness. And as such, not only was the DNA report not properly proved, the appellant was deprived of the opportunity to cross-examine such scientific officer in order to elicit certain facts which might have gone in favor of the appellant.
All right. Let us hear the answer.
Yes.
Yes, Mr. Jakut.
Total 15 prosecutions there. And Milord, 1, PW1, PW2, PW3, PW9, 11 and 12. Total 1, 2, 3, 4, 5, 6. 6 witnesses, my lord. This is highly corroborated. PW1 is a victim. PW2 is a complaint, mother of the victim. PW3 is a sister of the victim. She first identified the victim was pregnant. At the time of institution of the matter, my lord, he was 20 weeks pregnant. And thereafter, my lord, DNA test has been occurred, report was positive. And my lord, the other thing, my lord, the medical legal doctor, his deposition, both are highly corroborated.
Mr. Chakraborty, incident is of January and June FIR because you discovered the pregnancy after that.
My lord, my lord. My lord, this is a
What are your answers to his 2 points? One is hurried trial and second is DNA.
and there is no any whisper regarding that. That maybe they can apply for the re-examination. So
We have-
that is not.
The difficulty of
Yeah.
this bench is, Mr. Chakraborty, you have a strong confidence on legal aid. That's meant to be sarcastic. That's meant to be sarcastic. That is the difficulty. Now, legal aid defense counsel, some are very good.
And the child, she was only 14 years. She deposed all these things. The present petition are repeatedly raped.
That is the risk, Mr. Chakraborty.
Yeah.
14 years
Once
complaint lodged after she became pregnant. We don't know whether this person was victimized. Aggravated sexual assault, 70-year-old man. We have some doubts. You overdid it probably, prima facie, by putting in section 6. Could have been gone a little slow.
Was also not brought to light before the trial court regarding potency of this process.
Was there any potential test or something like that?
But that medical, not valid for that.
Victim statement is very much sufficient. He knows that who is the actual father of the child. DNA is not.
Mr. Chakraborty, why will a 14-year-old girl wait till her pregnancy is discovered? If it was a little child, we could have understood. 14-year-old, she is sufficiently mature to tell her parents or whoever. Why waited for 5 months till the pregnancy was discovered? If the pregnancy was never discovered, this allegation would not come. So pregnancy seems to be a stimulant. Doubt is there. Mr. Chakraborty will grant bail, will say that he will not. Was there ever any antecedent complaint? Any? A single one? Will grant bail. The present bail application has been filed in connection with a case where the appellant was convicted primarily under Section 6 of the POCSO Act. So next para, learned counsel appearing for the appellant/petitioner places reliance on Anukhilal versus State of Madhya Pradesh, reported at 2019 20 SCC 196, to argue that in case where there is extreme haste, HAST, in concluding trial, without giving adequate opportunity to the defense to place their case, justice is often buried. First up, next para, learned counsel points out that in the present case, about 11 prosecution witnesses were examined within a short span of 3 consecutive days. First up, next para, that apart, although the offense allegedly took place in the month of January 2022, the FIR was registered on June 5, 2022. First up, the charge sheet was filed on August 2, 2022, and charges were framed on August 16, 2022. First up, the victim herself was examined on August 25, 2022, and thereafter the evidence took place. First up, subsequently, on September 6, 2022, an additional charge sheet was filed. First up, the way in which the trial proceeded, it is argued, invariably shows that the defense did not have adequate time to cross-examine properly the prosecution witnesses and present their case. First up, next para, learned counsel further argues that the DNA report which was exhibited and formed one of the basis of the conviction, comma, was never proved by its author. Full stop. By placing reliance on a coordinate bench judgment in Muskan Tamang Supra, reported at 2024 SCC Online Cal 10345, comma, Learned Counsel submits that the same vitiates the trial. Full stop. Next para. Upon query of court, comma, it is ascertained that the present appellant stroke petitioner was almost 70 years of age at the relevant juncture when the incident took place. So next para, learned APP appearing for the state vehemently opposes the bail. Full it is submitted that as many as 6 prosecution witnesses categorically corroborated the prosecution case. Full stop. There were 15 prosecution witnesses in total, and during trial, comma, it was never pointed out or objected to by the defense that the trial was proceeding without giving opportunity to the defense to place their case. Full stop. Next para. Learned APP further submits that the victim girl was 14 years old and her statement as well as her evidence sufficiently clinch the issue against the convict. Full stop. Next para. Upon a careful consideration of the nature of the offense, comma, we find that undoubtedly, comma, the allegation is serious. Full stop. However, comma, the very seriousness of the offense justifies adequate opportunity to be given to the defense to have an educated opportunity of presenting their case and cross-examining the witnesses. Full stop. In the present case, comma, the substantial majority of the prosecution witnesses were examined within a span of 3 days. Full stop. Secondly, comma, since the victim girl was 14 years of age and it is submitted that the complaint was prompted by discovery of her pregnancy 5 months after the alleged offense, comma, we find that there is some possibility of doubt as to whether the appellant is sought to be made a scapegoat. Full stop. Next para. Secondly, comma, as held by the Supreme Court in Anokhilal Supra, where the amicus curiae did not have sufficient time to go through the basic documents, nor the advantage of having any discussion or interaction with the accused, and some time to reflect over the matter, comma, the hearing loses its character of being meaningful and becomes just a routine affair. Full stop. In such cases, comma, the rights under the relevant provisions being sections 227 and 228 of the code become are denied. Full stop. In the said case, comma, the Supreme Court observed that the trial court on its own ought to have adjourned the matter for some time so that the amicus curiae could have had the advantage of sufficient time to prepare the matter. Full stop. Next para. Thus, the approach adopted by the trial court in being extremely hasty in concluding the trial was did not further the cause of justice. Full stop. Next para. Moreover, comma, in the coordinate bench judgment in the matter of Muskan Tamang, comma, the judgment of Rahul versus State of Delhi Ministry of Home Affairs was quoted, where the contours of collection and preservation of evidence were stated. Full stop. In the said case, it was held that the scientific officer who authored the DNA report and conducted the examination was never produced as witness, and, comma, as such, comma, the DNA report was not properly proved. Full stop. In the present case, comma, we find that the DNA report formed one of the basis of the conviction. Full stop. The same, comma, in the absence of being proved by the author, comma, could not be relied on as sacrosanct, comma, at least on a prima facie footing. Full stop. Next para. That apart, comma, we cannot lose sight of the fact that the appellant was represented by the legal services authorities. Full stop. We are not unaware of the ground realities, comma, since in such cases, comma, the quality of representation is not always superlative. Full stop. Particularly in the facts of the present case, we find that very little time was granted to the defense lawyer to properly cross-examine the prosecution witnesses. Full stop. Next para, the extreme haste in which the trial court proceeded also casts some doubt on whether the principle of audi alteram partem was meaningfully granted to the defense. For some next para, lastly, we cannot but take note of the fact that the that the appellant was almost 70 years of age, and keeping in view the nature of the offense, stronger proof ought to have been produced, uh, at least having the DNA report proved by the author thereof. Full stop. In view of the above circumstances, we find sufficient justification to grant the benefit of doubt in favor of the appellant. Full stop. Accordingly, SCRAN 1 of 2025 is allowed, thereby granting bail to the appellant on condition that the appellant deposits, appellant furnishes bond of rupees 10,000 with two sureties of like amount each, one of whom must be local. Full stop. Next para, the appellant shall, throughout the pendency of the appeal, not leave the territorial jurisdiction of his residential police station, and shall not, in any manner whatsoever, attempt to contact or approach by whatever mode, the victim or her family, near family, and stroke out the witnesses of the case. Full stop. The appellant shall also make himself available as and when so directed to by this court during the pendency of the appeal. This much.
I'm grateful to.
প্রথমেই affidavit of service filed today be kept. Next. Yes, thank you. Yes.
When this POCSO matter I served, it was not statements intimate the victim.
What statement?
I served, it's not completed.
Service not completed. When should you keep it?
On Wednesday, can state may intimate the victim.
Learned counsel for the petitioner submits that although the state has been served, the de facto complainant stroke victim has not yet been served. First of next para, on the prayer of the petitioner, we direct the state to take adequate steps to ensure that service of notice and a copy of the application for bail be served on the be completed on the de facto complainant stroke victim at the earliest. Full stop. The matter shall next be listed on July 30, 2025. Please communicate formally to the state.
Time for the.
Yes, sorry.
I'll
Yes.
come before your lordship court
Yes, yes.
for the consideration of suspension of sentence, my lord.
You have served on the state? You are for the state?
My lord, these convicts are in the custody around 8 years, my lord.
What is the offense?
302 with 34,
In custody for?
almost 8 years.
8 years.
Since.
Life has been granted.
Yes,
Given.
right.
Now, what are your mitigating circumstances apart from 8 years?
My lord, in the meantime, my lord, they got bail during the trial, my lord, for a few months, but they didn't misuse the liberty, my lord.
They didn't
Misuse the liberty granted by the court.
didn't misuse the law. 3 months they were out on bail.
For 3 months. My lord, there are 4 people, my lord, working in the tea garden, my lord. One is a driver, another is tea workers in the one of big tea garden. And this.
Driver also in the tea garden itself.
Yes. And the woman is having 3 daughters, whose age are marriageable, my lord. And Bole has got 4 daughters. And marriage of their age is there, my lord, and talks of marriage are going on, my lord.
Both of them. Both that.
Both, my lord.
Yes, what do you say, Dr. Chudhary?
September 2024 and December 2024, there are 2 rejections by this honorable court with detailed observations. So, my lord, that is only September 2024 is very detailed, my lord. Page 9 onwards. No, my lord, even Kashmir Singh was distinguished.
Kashmir Singh just quoted, were distinguished.
Lord, third para, page 10.
Shows the distinction.
Lord, it says in Kashmir Singh Supra, the initial conviction under section 323 of the Indian Penal Code 1860, with the accused there being acquitted of the charge under section 302 thereof. On appeal, High Court convicted the accused under section 302 of the IPC 1860. It is in such context, Supreme Court granted suspension of sentence. One of the conditions taken into consideration by Kashmir Singh was that court was not in a position to hear the appeal expeditious. But here,
We are also not in a position.
I have the paper books. I am ready with
You have the paper books, but we don't have the time.
That is.
My lord, to count,
The accused person, the appellants are in custody for about 8 years, full stop. It is submitted by learned counsel for the appellants stroke petitioners that during trial they were enlarged for 3 months on bail and they did not misuse the conditions of bail. Full stop. Next para. While arguing on extenuating circumstances, learned counsel submits that one of the petitioners is that submits that both the petitioners work in the tea gardens are and come from the marginalized sections of society. Full stop. The petitioners do not have strong financial means. Full stop. Next para. One of the petitioners is a driver in the tea gardens and the other is a worker at the ground level. Full stop. Next para. Both of them have marriageable daughters, talks of whose marriage are going on. Full stop. It is submitted that unless the liberty of bail is granted to the petitioners, the said prospect of marriage of the daughters may also be jeopardized. Full stop. Next para. Learned counsel appearing for the state opposes the prayer for bail and submits that in September and December 2024, the similar prayers of bail were rejected by coordinate benches. Full stop. By placing particular reliance on the order of rejection dated September 24, 2024, learned counsel for the state submits that the cases of Kashmir Singh versus State of Punjab reported at AIR 1977 SC 2147 and Mulakala উচ্চারণ করতে পারবো না দেখে করুন reported at 2024 SCC online SC 275 were distinguished 275 online SC 275 এখানে পেয়ে যাবে পেজ 10 হ্যাঁ were distinguished. Full stop. Next para. Similar to the as such, it is argued that the in view of the gravity of the offense, no bail ought to be granted. So next para, we find several mitigating circumstances in the present case. So first, the petitioners are already in custody of 8 years and, as per the consideration of Kashmir Singh Supra, the bail, this court is not in a position to hear the appeal expeditiously. Full stop. Although the state submits that the paper books have already been prepared, mere preparation of paper books does not equate with hearing. Full stop. Since the circuit bench is already heavily burdened with other criminal appeals, we find that the prospect of hearing the appeal soon is bleak. 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 Full stop. Next para. Secondly, the consideration of the marriageable daughters and the prospect of their marriage, impending marriages being ruined due to refusal of the present prayer also looms large in the mind of the court. Full stop. More so, since the petitioners come from marginalized backgrounds and do not have the social standing to carry on with their family activities even if they are under incarceration. Full stop. Next para. Keeping in view such considerations, we are of the opinion that the petitioners are entitled to the benefit of bail. Accordingly, CRAN 2(3) of 2025 is allowed, thereby granting bail to the petitioners on condition that each of the petitioners shall furnish bond of rupees 10,000 with two sureties of like amount each, one of whom must be local in each case, full stop. The sureties may be common for both the petitioners. Full stop. Next para. As condition of bail, the petitioners shall not leave the territorial jurisdiction. They are residents of the locality.
Okay.
Yes.
The territorial jurisdiction of the residential police stations throughout the period of pendency of the appeal, and shall uh, be present as and when so directed by this court. So the next para, the appellant shall not, in any manner try to influence or intimidate the witnesses of the case, and or attempt to tamper the evidence or the records in the appellate court in any manner whatsoever. Thank you. Next. গরিব মানুষ।
Five, I am applying for the appellate matter. Under the convictions under section 6 of the Protection of Children from Sexual Offence Act, my lord, the petitioner is all along in custody from the date of arrest. My lord,
What is the period?
My lord, arrest is 2021. My lord, from the date of the, he is all along in the custody, lord.
What is the sentence? Length of this?
No, my lord, the petitioner, my lord, this is the renewal of the prayer, lord.
When was last rejected?
Last rejected lordship
30th
is 20
January.
30th of January
2025.
2025. No, my lord, it's a very peculiar case, my lord, the absolutely false case. The allegation says that the petitioner, being a grocery shopkeeper, he committed the offence upon the two children simultaneously in his shop room. Now, if your lordships, I have annexed all the depositions, particularly the depositions of the PW1, who is the mother of the victim number 1. She, my lord, has stated that we have waited for the money of 2 lakhs. If money has not given, that's why we have lodged the complaint. Now, lordships, the depositions of the PW7, who is the medical officer, who stated, my lord, that there is no injury in the private parts of both the girls. There is no sign of sexual intercourse.
What were the ages of the girls?
11 and 10. Whereas, my lord, the prosecution's case is, my lord, the intercourse happened, and therefore, my lord, the wearing apparel of both the victim girls were soaked with blood, and the blood was oozing from the private parts of both the victim girls. But as per the depositions and the medical report of the medical officer, there is no injury, none of the girls, lordship. Now, lordship, if your lordships kindly comes to the depositions of the PW1, PW2 and PW.
Medical examination was held when? How?
Just after the incident, lordship kindly comes to before that, lordship kindly comes to the depositions of the PW1, who is the de facto complainant. My lord, I have annexed the depositions.
Yes.
That is page 86. Lordship kindly comes to the page 90. The second paragraph, when the accused refused to pay the said amount of 2 lakhs each to the victim girls as per compromise, we filed this case against him. Before that, lordship kindly comes to page 89.
Have you got copies? These are under envelope and envelope টা খুলে দিন তো পেছনে envelope annexerটা খুলে দিন
Depositions of the PW1, who is the de facto and the mother of the victim.
No, we don't understand. Money was not given by whom?
By the accused. He refused to pay money. That's why this FIR has been lodged.
They say that.
That is the deposition. That is-
Policy has been conducted.
That is the depositions of the both the mothers.
Let us see the relevant page 90.
Yes, lordship kindly comes to page 89 first.
Yes.
My lord, lordship here, lordship, the middle of the page, my lord, I
Yes.
did not hand over the wearing apparels of the VG1 to the police. All the, my lord, the.
89.
Page 89, middle part.
Running page, we do not have.
No. Cross-examination by the defense starts there.
No, Lordship, it is the depositions of the mother of the victim girl,
No, this is
From-
page 19 our copy.
page 89 and 90, Lordship.
You are reading from page 90 of our copy.
89 I am reading.
I did not hand over wearing apparel is at page 90 of our copy.
My lord, no.
Please read on, we are,
4, in at page 4.
yes, we are there, we are reading.
Page 4.
Did not hand over.
Although the prosecution cases, the wearing apparels were soaked with the blood, but that wearing apparels
They might
the
not have hand over, they have recovered.
police did not seize the wearing apparels, neither the mother of the victim handed over the wearing.
They were produced by whom then?
Lordship,
They were produced, how they were produced? Those wearing apparel? Police must have seized.
police did not seize. That I am coming from the depositions of the investigating officer.
Then how did they came about? I mean,
My lord, that what to have been, my lord, seized. Now lordship kindly comes to the lordship kindly comes to the the paragraph number and page number 4. It is true that 2-3 years ago there was a dispute regarding the due amount of 700 between the accused and my father-in-law, and the accused had told that he would not give the credit to my father-in-law, but I used to take items from the shop of the accused on credit. So, my lord, there was a dispute relating to the families of the accused and the de facto complainant regarding the credit of the gross.
not sufficient to commit this offense. I mean,
My lord, now lordship kindly comes. Yes, I am coming to the substantial, my lord, point. Now, my lord, the lordship kindly comes to the depositions of the PW4, who is the another mother of the victim number, who is the mother of the victim number 2. That is page 98. I don't. 98.
yes, 98.
Yes, lordship kindly comes to 100.
This is Anjali Namodas.
Yes. Only now.
The pages may not tell you.
Leaving the first page and second page, lordship kindly.
Cross-examination by the defense starts at page 100.
Cross-examination, my page it is 99.
Page 100 here, inner page.
Lordship at page 2, lordship kindly comes to
Inner
page
page
3.
301, yes. Yes.
My lord, the second paragraph.
Hmm.
It is true, if the accused had paid the state money, we would not have filed the case against the accused persons. Now, lordships kindly comes to the state page, my lord, from third paragraph from the bottom. It's not a, yeah, lordship kindly leave it, it is a suggestion. Now, lordships kindly comes to the depositions of the one of the neighbors who is Promila Discharge Nomodar, which is the PW5.
Hmm.
Page 103. Maybe it will be page 104 in your lordships.
Yes.
Yes. My lord, kindly see the cross-examination.
Hmm.
The accused has informed the respectable local people about the theft by the VGs. Since the accused has informed about the theft of the money to the people and the meeting was called for the same, the parents of the victim lodged the false complaint against the accused in order to take revenge. Lordship kindly consider he has not been declared as a hostile. But this is a deposition, my lord, there is a dispute regarding the money. So, my lord, therefore, my lord, this complaint is lodged. That complaint is not corroborated, the allegations is not corroborated by the depositions of the medical officer.
Hostile declare করনি সে অ্যাডমিট করছে যে ওই কারণে ওরা বদলা নেওয়ার জন্য করেছে
And the
what is the age of the accused
10 and 11.
your age
My lord, he is an aged person, my lord, 65 years old, my lord.
maybe
And he all along in custody, lordships, there must be some injury, lordship. Any of the girls, where the prosecution's case is.
let us hear them
Yes.
yes what about the injury not being found no injury and blood stained apparel
Deposition of doctor PW2 is concerned, my lord,
huh
victim. And PW.
no we are asking you a specific question Mr. Chakraborty the allegation is that wearing apparel was alleged to be blood stained not a single injury was found in the private parts of the girls. How do you corroborate the two? This is very palpable. Mother did not hand over wearing apparel, she admits. Ms. Sehanovic is saying we have not ascertained that you have also not seized. It
That
must,
is there in the depositions. of
Caesar
the
list does not,
Investigating officer herself admitted that the wearing apparatus has not been seized. Charge sheet has been filed, my lord, without FSL report.
nothing, কোনো private part সবকটা mention করছে individual. There is no prosecution, no recent prosecution penetration of the. This is under section 6.
Yes, your
Yes, my
lord.
lord. My lord, deposition of PW1 and PW2, my lord,
PW7, who is she?
My lord, PW7 is the medical officer.
deposition, my lord.
She
It-
says there is no detected, no, all the private parts are mentioned, no injury anywhere. And opinion is no recent forceful penetration into the vagina.
My lord, in respect of both the girls' lordship. And whereas the IO investigating officer, he said, my lord, he did not collect the FSL report. Charge sheet has been filed without
Mr. Chakko, this raises sufficient doubt,
supplementary charge sheet, lord.
sufficient doubt. Yes,
The consistent deposition of PW to 15 by law. Although these were not factors, the rules of section 29 of the POCSO Act, which is not sufficient. But so far the opinion of the doctor is concerned, but it's an opinion evidence, my lord. The victim is very much consistent.
section 6 is entirely based on penetration. And that too, aggravated penetration. If there is no penetration corroborated by the doctor, who else can? And there are several witnesses, one prosecution witness admits that you have not sought a declaration of hostility.
Kindly have a look on the deposition of the victim one, that is PW. Kindly have a look.
Running page, my lord, 86, yes. And
What is
91.
what is the maximum sentence for ordinary sexual penetration?
20 years.
20 years.
Maximum sentence, my lord.
My lord, if my learned friend is relying on the depositions
Well,
of the
second-
PW2,
Second.
who is the victim girl 1, my lord, I have something to show before your lordship. It's very contradictory. Lordship, when it comes to page 90.
Let them complete.
Yes, your lordship.
Yes,
On the date of incident, my lord,
yes.
9th standard.
This is VG1.
Yes, my lord.
On the date of incident, yes.
On the date of incident, my parents, both parents had been to.
No, but one of the mothers said that if the money was paid, she would not have lodged the complaint. What does that mean? That was placed-
One Salisi also has been conducted by the Gram authority.
Regarding that.
And that is corroborating, my lord. And my lord, if you peruse the other, my lord, rejection order, previous rejection order, that has also got considered by the coordinate bench, my lord. After considering all these things, my lord, the fail prayer has been turned down.
Let us see that, which page of the application?
My lord, page 22. Maybe 23 in your lordship. Lordships, kindly see.
Wait.
Yes. My lord, the mother can wait for money where, my lord, such heinous offense has been made, alleged offense has been made by the accused lordship.
We don't know the plight of the poor sitting in AC rooms.
That is considered.
They may.
And it's an absolutely false case, lordship. Kindly comes to the depositions of the
This
PW.
is CRAN 1,
Can one? Yes, your lordship.
page 22 you are saying, or 23.
One page, running page 20.
Rejection order of the suspension of the.
No. First annexure. This is CRAN 1 or CRAN 2?
This is.
CRAN 2.
Yes, madam.
My lord, I have annexed the.
Wait, Ms. Hasnam, both of you cannot argue together. No. CRAN 2 টা তো খুঁজেই পাচ্ছি না। এই অনিন্দিত CRAN 2 কোনটা? এটা? এটা তো অ্যাডমিশন অফ অ্যাপিল। এটা তো CRAN 1 পাচ্ছি খালি। দেখুন তো। ওই জন্য ট্যালি করছে না পেজ। এটা CRAN 1। এই তো ক্যান টুটাই আছে, ওয়ান তো এখানে আছে, আমিও দেখতে পাচ্ছি, তার আগে নেই। ক্যান ওয়ান দেখে যাচ্ছি এতক্ষণ। আপনার কাছে ক্যান টু কপি আছে, আপনি ক্যান ওয়ানই দেখে যাচ্ছেন। তোরা এতক্ষণ আর্গুমেন্ট করছে, আজকের লিস্টে কি আছে, আজকের লিস্টে কত নম্বর ক্যান আছে, তাহলে ক্যান টু কি করে লিস্টে থাকে? সেটা গোড়াতে বলে দিলে না কেন? ক্যান টু লিস্টে রয়েছে, আমরা নিয়ে যাচ্ছি, ক্যান ওয়ান দেখে যাচ্ছি। লিস্টে রয়েছে যখন আমাকে ফাইল দিচ্ছ তখন বলে দেবেন একবার, এটা তো বলে দেবেন আপনি ক্যান টু, যে ক্যানটা নেই এখানে। ননসেন্স, আটার ননসেন্স। ফাইল লিস্টে রয়েছে, অ্যাপিয়ার করছে, আপনি বলবেন না অ্যাপ্লিকেশনটা নেই? উইল টেক ইট আপ, ইউ হ্যাভ গিভেন দ্য ডেট অ্যাজ 28th in that can, we'll take it up on 28th. No, you have no fault, the application is not appearing, it's our court officer's fault. They didn't even point out that the can is not there. Please come back on 20th, we are sorry.
My lord, I have done enough of it.
Let be called. ফাইল ক্যান আছে কিনা দেখে নিন, ক্যান আছে কিনা দেখে নিন, যেটা অ্যাপিয়ার করছে সেটা আছে কিনা, প্রত্যেক ম্যাটারে দেখুন, এটাতে থাকতেই হবে ক্যান ওয়ান।
Service has not been completed because it is POCSO.
Service has not been completed as per submission of the petitioner's counsel, which will let the matter stand over till July 28, 2025. Next.
And item number 7.
My lord, in this matter,
7.
this is item number 6, my lord. In the judgment, when the judgment was pronounced, my lord, the
Previous one,
previous one, the accused was asked. My lord, thing is that the accused said he wants to.
6 years,
No, no. Now I've asked him whether she appeared for the legal aid because the matter has been sent to the legal aid by the judge counsel.
No,
So
my
now he has filed, I think.
they will consider that when you take up the application. Yes, 7, who is appearing? Yes. Lord counsel for the petitioner submits that the service has not yet been completed on the de facto complainant. The state shall ensure that such service is completed at the earliest. Let the matter stand over till July 29, 2025.
And for the appellant lordship. The charge under section 302, life imprisonment. FIR was registered by.
You have given a notice to the state?
Yes.
Yes. Life imprisonment 302? Yes. What are the mitigating factors?
Initially, the charge was framed under section 498A and 302. However, the petitioner has been acquitted under section 498A and convicted under section 302. So on according to the FIR story, lordship, on the death of the wife of the appellant, the FIR was registered by the appellant against the appellant as a sole accused person, pursuant to a letter of information lodged by the father of the deceased. And subsequently, charge sheet has been submitted against 2 accused persons, there is the appellant and the one Poncha Kovidach. Because on the which name was come up in the 161 statement of the daughter of the petitioner, However, lordship, that Kancha during the course of trial has demised. Now the petitioner alone has faced the trial. Now what happened, lordship? According to the FIR.
Were you related to the deceased? Any relations?
No.
Very nice.
Now what happened, lordship, that the FIR, that the charge sheet has cited as many as 24 prosecution witness. However, the 22 witness has been examined. Now the star witness, I am coming on the star witness, that is witness number 14, who is the daughter of the petitioner, whose statement under section 164 was recorded, and according to her statement, lordship, that
Daughter of the petitioner?
petitioner.
She adduced evidence against him?
Yes, lordship.
She adduced evidence against him?
Yes, yes. Her statement has been recorded. She has stated that আর কিছু বলতে চাও? I'm quoting the relevant portion. কাঞ্চা কবিরাজ বাবাকে গাঁজা খাওয়াতো আর বলতো বাবাকে বলতো কি মাকে মারতে হবে। কাঞ্চা কবিরাজ বাবাকে নষ্ট করে দেয়, ওর সাথে থেকেই বাবা এরকম হলো। দিস ইজ দ্য পার্টিকুলার দ্যাট
বাবাকে বলতো মাকে মারতে হবে means the victim was
induced her father to kill his mother.
therefore this is the victim is the wife of the the
Yes,
petitioner.
petitioner.
That is the first question we asked you. What is the relationship between the victim and the
Victim and the petitioner is the husband and wife.
that is what we asked you.
Sorry, Lord, I couldn't understand.
Yes.
Sorry, Lord.
So daughter, what is the age of the daughter at that point?
At the time of statement, recording of statement, she was at about 11
Age.
years old. 11 years. So this is the.
So what is your mitigating circumstance?
this is
কাঞ্চা
the-
গাঁজা খাওয়াতো বলতো মাকে মারতে হবে।
Only this. This is the only statement that she has stated against the petition. Nothing else. Then
There is no other no
Nothing.
eyewitness here.
no eyewitness in the entire prosecution case. Nobody has
This is her entire evidence.
entire evidence. This is the 164 statement, and subsequently I'm also
No, evidence.
evidence I'm pointing out.
গাঁজা খাওয়াতো মারতে বলতো,
মারতে বলতো।
but nothing regarding the act.
Nothing. This is the PW14 of the witness.
Same witness.
Same witness.
Girl.
Yes. So I would like to draw your kind attention at page 2, internal page 2 of the relevant portion. I marked it.
Yes.
I was staying in the house of the maternal father at the time of death of the mother. That means she was not present at the time of occurrence. Now the next line, I went to the house of maternal grandfather to 10 or 12 days prior to the death of my mother. I did not notice any dispute on the preceding night, on which day I left my paternal house for the house
So
the
she
house
came
of
back
my.
to her paternal house on that date, she says.
Yes, Roshit.
I went to the house of my paternal house.
Paternal
So
house.
she came back on the date of the offense.
No, I came back.
I went to the house of my paternal house along with my
Maternal grandparents, maternal uncle, namely Ranjan
Oh,
Burman.
when
so
we
and-
got information about the death.
Yes,
After.
and when we got the information.
So
about
no
the-
direct evidence.
No direct evidence.
Why was he convicted? Any circumstantially there must have been other witnesses.
Nothing, no circumstances has been
He
changed.
was the sole prosecution witness.
No, other prosecution witness, all are hearsay. All are hearsay. Total 24 witness has been served. Even the mother of the victim has been declared hostile. That is PW number 50.
How long is he in custody? Total?
Total pre-conviction and post-conviction 2 years, 6 months. 2 years, 6 months. During the course of trial, he was released on.
Name is Amol Burman.
Amol Bon.
In your synopsis, you have written 11 years, 11 months.
Sorry, that I.
Copy paste. 2 years, 6 months. So this is your main mitigating circumstance. There is no evidence at all. So how was she convicted? Let us hear Dr. Chaudhary. He must be throwing some light on why he was convicted.
Now, my lord, the evidence of the daughter, my lord, the daughter also says that her father was involved in an extramarital affair with one lady. And my lord, that is one of the reasons, my lord,
For the 302 extramarital affair,
Not-
then so many people would be guilty of murder. We'll have to find out who are not guilty of murder.
says that evidence, she says.
That will be a selection you'll have to make then. If that is a ground of murder, 302, then the courtrooms, the hospitals, everything would be empty. All behind the bars. Dr. Chaudhary, don't go by that. What is the evidence of 302? This is we are speaking of 302.
Circumstantial evidence, that is right, my lord.
If it was a matrimonial suit we are hearing, you are the wife, you would readily get divorced. But no, nothing. This is the, as he said, star witness. We have some trouble with the word star witness. It glorifies, anyway. Prime witness was the daughter. Everybody else hearsay.
Yeah.
How could you get a conviction? He appeared in the trial court also.
No.
We would put you behind the bars. এটা কোনো এভিডেন্স নাই 302 তে ঢোকার মধ্যে লাইফ দিয়ে দিয়েছি একটাও যদি থাকতো আমি বুঝতাম
Not even supported by any circumstance.
of hearsay. The Learned counsel for the petitioner submits that the petitioner is behind the bar for about 2 years, 6 months uh, in total. Full stop, next para. The prime mitigating circumstance as sought to be projected as argued by the petitioner is that the petitioner was convicted under section 302 of the Indian Penal Code primarily on the basis of evidence of his daughter. Full stop. It may be noted here that the victim was the wife of the petitioner. Full stop. The daughter, comma, as prosecution witness, comma, has stated that she was not at the site, at the place of occurrence at the time of the incident, but after getting information had come back to the said place. Full stop. In a statement under section 164 of the Criminal Procedure Code, comma, the said daughter of the petitioner and the victim had merely stated that at the instigation of Kancha was a co-accused of one of the then co-accused persons, comma, the petitioner's father was prompted to commit the murder. Full stop. Next para, about the other prosecution witnesses, comma, all of those are based on hearsay. Full stop. Thus, comma, we find that there might have been a serious flaw in the conviction process itself, comma, since not only is there any eyewitness, comma, we do not find any clinching evidence to convict a person under a serious offense as contemplated in section 302 of the IPC. Full stop. Accordingly, comma, the benefit of doubt ought to be granted to the petitioner. Hence, grant 2 of 2025 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000. What does the petitioner do?
The agriculturist. No, sorry, bus driver.
On condition of furnishing bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, the petitioner shall not leave the territorial jurisdiction of his residential police station throughout the pendency of the appeal and shall present himself as and when so required by this court. Which of next para, the petitioner, comma, furthermore, comma, shall not attempt to intimidate and or approach the witnesses of the case and or tamper the records in any manner whatsoever.
Grateful.
Thank you.
CGM.
To the satisfaction of CGM Alipurduar. Wait.
Grateful.
তন্ময় আগের দু একটা তো বোধহয় স্যাটিসফ্যাকশন দিইনি আগে অনিন্দিতার ক্ষেত্রেই বলছি যে স্যাটিসফ্যাকশনটা ঢুকবে কিন্তু স্যাটিসফ্যাকশনটা মিস করে যেতে পারে ওই দেখে করে দিতে হবে কোন কোর্টের ট্রায়াল কোর্টটা কোথায় ছিল দেখে নিতে স্যাটিসফ্যাকশন তো ট্রায়াল কোর্টেরই হবে CGM হ্যাঁ কনভিক্ট Yes. This is an order for turn matter.
Second
Order for turn? Yes. Yes. What is the matter, Ms. Sarkar? Once, give us half a second. তাহলে যে দুটো তো মিস হয়ে গেছে আমি দুটো অতটা জানে না আপনি একটু দেখে বলুন যে আমি চেক করে নেবো যদি পাই ওটা কোথায় পাবো কোথায় সিজিএম করতে ওরা না বললে বুঝতে পারবো না রেকর্ডে পেয়ে যাবো হ্যাঁ ঠিক আছে আমি যদি নাম মিস করে দিই আপনি সরি টেক ইউর সিট মিস্টার মহাশয় we are more acquainted with Sen Mahashaya in Calcutta for the sweets. Please take your seat. Both courts must be. Ms. Sarkar, you lost in both courts.
What court?
You lost in both the courts. What is the suit about? You take your seat.
It's a case of recovery of possession from a trespasser and for injunction.
What was your defense?
And he is the owner of the property that was, and they have come into the property on they have acquired, he forcefully acquired the property and he claimed for a recovery of
The
possession.
trial court strictly has not, certified copy has not been filed.
My lord, that have been submitted, my lord.
Acha, very good. Please continue. Yes. So they allege that they are the owners, you are the trespasser.
I'm the plaintiff, my lord.
Oh, acha. The plaintiffs lost in both the court, acha. They proved it was held that they are the owners of the property.
They have asked for copy of possession, my lord, and the court said yes, the plaintiff do not have a valid right, and hence the suit was dismissed, my lord. My.
Valid right means you have failed to prove your ownership.
Because it is the case of them that the father of the plaintiff have already sold the property to someone, and from them the defendant has purchased. Therefore the court held that they do not have any title to the position for the property, and hence that
Plaintiffs, you claim to be the owners of the property, exclusive owners. You say that he was a trespasser. That is your case. But the court held that no, he purchased the property from your predecessor.
my lord, the thing is that, my lord, I am on the point of that the learned civil judge junior division of Jalpaiguri do not have the pecuniary jurisdiction to pass the decree. Why, my lord? The thing is that, my lord, this is a case for recovery of possession from a trespasser, my lord. A question was raised with regard to the fact that whether the proper court fee with regard to this case was filed or not, my lord. And the defendant has repeatedly stated that, my lord. It is given in the learned trial court's judgment, my lord. The learned trial court has come to the conclusion that as per 7(5) of the Court Fees Act, my lord, on the amount, on the value of the property, the court fee should have been paid, my lord. But the learned trial court did not determine what is the court fee to be paid, my lord, and has passed the decree, my lord. Even the appellate court has come to a same conclusion that as per 7(5) of the Courts Fees Act, my lord, the court fee with regard to the value of the property is required to be paid. Now, the value of the property over here is a 1.33 acres of land, and that was never determined by the court. And if it is 1.33 acre of land, it is a valuation of around 12 lakhs. And therefore, Civil Judge Junior Division of Jalpaiguri will not have a pecuniary jurisdiction to pass the decree. This is my point, my lord. And without determining the court fee, my lord, the judgment has been passed, and thereafter the decree.
Let us see the relevant portion of the trial court judgment.
Issue number 3.
Where is the trial court judgment? Is filed subsequently? Not here.
Not filed.
My lord, I have filed, my lord, the certified copy of the same, my lord.
আলাদা করে ফাইল এইটা না ওটা তো অ্যাপিল কোর্ট
Not available.
Filed, my lord, the certified copy. I was directed and I filed, my lord.
The State court order is.
পরে ফাইল করেছি এই যে
Okay, tag করেন।
you have given only one copy.
There was a single bench, my lord, so I gave one. copy.
Why single bench? It had
Went single bench, my lord.
to come to the order 41 bench ultimately. Single copy, how will you read? You have got another copy?
My certified copy, but have there, I can.
No difficulty. Then Joseph.
We're returning after the.
Yes. And we won't mark also. Let us see the relevant portion, Ms. Shosha. 3. Yes, 3.
Number 3 relates to the point of court fees involved in the instant suit, my lord. Now, it says that the plaintiff had filed the instant suit for recovery of past possession, perpetual injunction along with other contributory relief, valuing the instant suit at ₹250. As per the contention of para 12 of the plaint, the plaintiff valued the instant suit as per the provision of section 7(6)(a) of the West Bengal Court Fees Act. The defendant repeatedly agitated the point that the court fee paid by the plaintiffs are not sufficient and they ought to have paid ad valorem court fee. Before going into the detailed discussion, let us take a glance at the relevant provision of the West Bengal Court Fees Act 1970. As per section 7(6)(a) of the said act, in a suit for recovery of possession of immovable property from a trespasser, where no declaration, in this case no declaration was sought, my lord, is either paid for or necessary for disposal of the fruit, the court fee is to be paid according to the amount at which the relief sought is valued in the plaint. Moreover, as per the provision of 7(5) of the same act, the suit for the possession of land, building or garden not being suit referred to in clause 6, the court fee is to be paid as per the market value of the land, building or garden. Therefore, section 7(5) is to be read in the light of clause 6 of the same provision in suits for recovery of possession of any immovable property against a trespasser, where adjudication as to title is neither prayed for nor required. The plaintiff is at liberty to pay court fee as per the value of the relief sought by him.
But in cases of suit where adjudication as to title is either paid or deemed necessary, the provision of clause 5 will be attracted, and the plaintiff will have no other option but to pay court fee as per the market value of the suit land. In the instant suit in our hand, the defendant specifically denied the title of the plaintiffs over the suit land. Not only that, the defendant clearly mentioned in his written statement that how the suit land came to be.
Ms. Sarkar, how did you, what was your defense? What is your status in respect of the property?
The defense is that, my lord, the learned trial court should have determined the.
What is your status? What is your defense statement claim? What is your status in respect of the property? In your written statement, what did you state about your status in the property?
I am the owner of the property, my lord.
Did you produce any title deed, anything?
Right.
Any title deed?
Yes, my lord.
You produced your title deed?
No, not title, the title deed of the father, my lord.
No, but father transferred to them.
It is their submission, my lord, but
They must have produced title deeds.
my lord, it was not the evidence with regard to who has actually transferred the property. The father sold the property to someone, my lord. That is their claim, my lord. But they couldn't produce any deed to that fact, my lord.
Let us see that issue.
My lord, that is not my issue, my lord. My issue is only with regard to this pecuniary.
That is our issue. Please come to that issue. Issue number 4. What don't you have?
My lord, with regard to this issue. Oh,
What is happening to you, Ms. Sarkar? Too many criminal matters.
It's telling me that whether I've taken that issue in my
Don't have to hurry. Hurrying is our prerogative. You go slow. Issue number 4.
issue number deals with the right, title, and interest of the plaintiffs over the suit land. The plaintiffs are claiming ownership over the suit land through their father, late Santosh Kumar Jha, who happened to be the original owner of the suit land, having 13 annas, 15 gondas, 1 kara, 1 pranti, share in RS Khotian number 1838/2. On the other hand, the defendant admitted the ownership of the Santosh Kumar Jha over the suit land, but specifically contended that he, during his lifetime, sold 2.33 acre land in 2 plots to Shushila Devi Jha by deed number 5051 dated such and such. Said Shushila Devi Jha sold 1.33 acre land to Porosh Agarwal by virtue of deed bearing number such and such. Thereafter, the said Porosh Agarwal sold total 1.69 acres land, including the suit land, to the defendant by virtue of registered sale deed bearing number such and such. Therefore, the defendant not only denied the title of the plaintiffs over the suit land, but also specifically explained how he acquired the same by virtue of purchase along with the chain of transaction in such facts and circumstances which court finds it necessary to adjudicate as to the title over the suit land. In support of their title, the plaintiff files only one document. That is the certified copy of RS 14 bearing number such and such, which was
Mr. Sarkar, defendant has filed his chain deed. Chain deed has been filed by the defendant.
Yes, my lord. That I totally agree to that.
Santosh Jha's title is obviously admitted because you are also claiming through him.
My lord.
And defendant produced transfer deeds. Now, Ms. Sarkar, if the court fees ad valorem, the court fees payable were more, then what would happen? Your suit would go. So that cannot go in your favor.
Might be, my lord, but the decree which has been passed, the civil judge junior.
For a technical reason, for a question of law, substantial question of law, it has been settled by the Supreme Court. Substantial question of law has to hit the merits of the suit and go to the root of the matter. That is a substantial question of law. That has to have a bearing on the outcome of the suit. Now, it would not have been a different outcome if this issue was held in your favor, and it was held that no, more court fees were payable. Then your plaint will go. You filed the plaint, you did not put in the ad valorem court fees, then your suit would also be dismissed. So conclusion is correct then also. That's not a good ground for you. Sorry, Ms. Sarkar. You have tried your level best. The present challenge has been preferred against a judgment of affirmance whereby both the courts below have dismissed the suit filed by the plaintiff's appellants for eviction of the defendant appellant on the ground that the latter is a trespasser. Full stop. From the concurrent findings of both the courts, we find that the ownership of the property originally of one Santosh Kumar Jha, the predecessor in interest of the plaintiffs, is admitted. Full stop. Whereas the defendant produced transfer deed in his favor by the said Santosh Kumar Jha, nothing to rebut the said evidence was produced on behalf of the plaintiffs. Full stop. Next para, learned counsel for the appellants raises a question as to whether both the courts below erred in law in holding that the court fees payable would be in terms of section 7 within bracket v 7 within bracket small v of the West Bengal Court Fees Act 1970 and not under section 7 within bracket small vi of the said act, comma, since a dispute as to title was raised in the suit and a declaration in that regard was necessary for the purpose of granting the relief sought in the plaint. Full stop. Next para, it is submitted that neither of the courts have ascertained the valuation of the property for the purpose of assessing the correct court fees to be payable, comma, which itself raises a question of law. Full stop. Next para, upon a careful perusal of the judgments of both the courts below, comma, we find that the concurrent findings of the courts below regarding the defendant having been able to establish his title in respect of the suit property, comma, thus thwarting the claim of title of the plaintiffs is unassailable. Full stop. Next para. The technical point of court fees, which is now sought to be raised by the appellants, does not have a material bearing on the outcome of the suit, since even if the same was held in favor of the appellants, comma, the ad valorem court fees payable under section 7 within bracket v of the West Bengal Court Fees Act 1970 would be higher than that put in by the plaintiffs themselves. Full stop. Thus, comma, even in such a case, comma, since the plaintiffs consciously framed the suit without claiming a declaration of title and did not pay ad valorem court fees, comma, the result would be that the suit would have to be dismissed on such ground as well. Full stop. Hence, comma, even if such issue was decided by this court as argued by the appellants, comma, the outcome of the verdicts of both the courts below would remain the same. Full stop. Thus, comma, we do not find any substantial arguable question of law having been raised in the appeal. Full stop. Accordingly, SAT 7 of 2021 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Sorry, sir. Certified copy.
Lord, item number 10, Mr. Bapi Sharkar is appearing advocate, my lord. The matter is
Mr.
under the Bapi Sharkar, my lord. The matter is under the impression of the defective, my lord.
Item 11. Defective.
Lord.
What is the defect?
My lord, I am not even aware with the defect, my lord.
Defect is minor. Sole respondent's name in memo of appeal does not tally with the certified copy of the impugned order. You have to change the name of the respondent in the memo. If he is not here, why did he mention the matter for inclusion?
My lord, we didn't have mentioned any matter, my lord. This matter has been filed on the 22nd.
Automatically.
July, yes, my lord.
You must have
automatically.
given in the computer sheet the dates. Yes.
I don't know.
To be listed on 25th of July. It is listed
Yes,
today.
my lord.
Why is he not here? Why is Mr. Sharkar not here?
My lord, he is engaged with some family issues, my lord. There is
On the prayer of the
offences going to
appellant,
be
the matter
happening.
is adjourned for the day. Leave is granted to the learned advocate on record to carry out the necessary correction to the memorandum of appeal to cure the defect in the meantime. Ask him to cure
Much
it
obliged.
whenever he
My
comes.
lord, one small submission, my lord. Kindly keeps it in the month, in the next Tuesday or Wednesday, my lord.
আচ্ছা তাহলে
There is a
adjourn for the day না করে adjourn
Much
till July 30, 2025, next Wednesday.
Great.
Please give your appearance. Yes. Give your name. 12, this is 12.
11.
Acha, 11. Yes.
Apparently, my lord, I am flogging a dead horse.
Why?
Suit of 2001, which has been, my lord, it was, my lord, a money suit. my lord,
2001.
2001. There is a checkered history. I'll come to that a little.
You're suffering that money suit.
No, my lord, it has been dismissed. I was the plaintiff. This was the first appeal. So, my lord,
Sir, Roman is so happy. It has been. Yes.
my lord, I challenge, my lord, the cancellation of the works contract, imposition of penalty. That was my challenge. That was a declaration in the nature of declaration. I prayed for certain quantum of money on the head of that I have done certain supplemental work outside the scope of the contract, but that was done. So I claimed an amount of money. Now, my lord, my suit was dismissed entirely. So far as, my lord, cancellation is concerned, the court held there was no infirmity. So far as, my lord, my
Extra work.
claim of the supplemental work is concerned, that has been dismissed on the ground of lack of evidence. Now, my lord,
Lack of evidence that you did the work.
lack of evidence that I have actually undertaken the work.
Actually
And what are the
performed the-
documents?
That is an addition to the.
Yes, yes, understood. Now, was it decided whether it was within the scope of the contract, whether you could claim that?
The court observed that there is no evidence that prior to undertaking the work.
No, there
I
are two
have-
components of this, Mr. Ghosh.
Yes.
One is that actually you did the work and you were entitled to that.
Yes.
That is the factual component.
Correct.
The other legal component is whether you are entitled at all, even if you did the work, whether you are entitled to that extra work, whether that was sanctioned by them.
My lord, on both counts, it went against me. The
Acha.
court said there is no evidence that while undertaking the supplemental work, I took the approval of the authority.
So what sort of application have you filed now?
My lord, my application, my lord, is a stay application only to bring on record the evidence. Now, my lord, before that, my lord, this has a little bit of, my lord,
No, we cannot
history.
take up the appeal now.
Your lordship cannot. My lord, I have a proposal subject to your lordship's
Acha,
approval.
yes.
My lord, I am placing this, my lord, this is a civil divisional application which was filed in course of the suit. Now, my lord, the entire record with the original documents was lost. This honorable court directed reconstruction of the entire file by taking photocopies. Now, my lord, from the client's file, whatever documents have been handed to me, my lord, so far as the supplemental work is concerned, my lord, to me, my lord, it appears that under Order 13, Rule 1, my lord, an application was taken up, a list of documents for the supplemental work, the measurement sheet, etc., was probably filed before the law court. This is there in the file. Now, my lord, whether how this was considered, and my lord, also an application I find, which, my lord, is a notice to produce documents, because whether I've
But
actually
whether
done-
these were exhibited or not.
I, my lord, so, my lord, I have, my lord, subject to lordship's approval, my lord, to this limited extent, if this can be remanded back with the specified timeline so that I am able to adduce documents.
Is any evidence reflected in the
Nothing,
judgment?
nothing. It has nothing been, it has not
Nothing.
been
Not
reflected.
been reflected. in any
It
of
has
the-
not been reflected.
any of the
Lord,
witnesses.
my lord, alternatively, your lordships grants me a leave to take out an application under 4127. If either of the ways, my lord, subject to consideration, my lord, if this is remanded back. only to
The
this
trial court
limited
says no evidence
no
was.
evidence, nothing of that sort. But, my lord, I find,
Already
my
record what is.
lord, I find, my lord, a bunch
Mr.
of
Raman, if there are
documents were
some
there.
documents, I mean.
But,
what you say?
what has been.
Yes, you are right. If you will be submitting that, not on evidence, but then now this have some evidence, whatever they have.
They are saying now they're coming up before the appellate court and. this is
Yes,
the first
that you
time.
may, that is what we say, that their latches cannot be filled up, permitted to fill up, but order 4127 B also comes in, because court feels that because no evidence was given. Now they have some documents.
No, pertaining to these documents, no evidence was there.
No, that is what they have now. That is what they,
they're-
but are these originals?
I showed the order of the revisional application.
Reconstruction.
It records that file along with documents has been lost. So I suspect, my lord, the original which was probably lying with the file has also been lost.
No, but Mr. Ghosh, if they were exhibited, they would be reflected in the impugned judgment. Might have been produced,
I
but
don't find that it was
marked
like-
as for identification
So,
maybe.
my lord, this appellant is, my lord, a senior citizen, my lord, in the fag end of his life, little bit of money, at least, my lord.
What
we
is the
should
age?
Feel that justice has been.
What is your age?
My lord, he's a senior citizen, above 60.
Senior citizens are not too aged nowadays.
He's
But at least,
he's
my
a
lord,
professional.
my lord,
actor.
at least someone should feel that, my lord, he has been granted an
Is it
opportunity. to-
rich senior citizen or poor senior citizen? All these have to be gone into.
A poor senior citizen, otherwise for 15 lakh rupees.
No, what is the? No, what is the age? I mean, just we want to know
My
the.
lord, I'll just,
Just for curiosity sake, since you said
74 years.
so,
My lord,
what is sufficient? Yes, Mr. Rahman, what do you say? Why don't you?
These matters were never reflected in the evidence in any of the witnesses concerned.
Mr. Ghosh, you file a formal order for Rule 27.
I will.
So that they can file an opposition and we
Yes,
can adjudicate it.
Yeah.
Do that.
I'll do that.
Do that. Do
But the deficit court fees has been put in.
Acha, deficit court fee, it is submitted by learned counsel for the appellant that deficit court fees have been put in, full stop. The document evidencing the same is filed in court today. Full stop, the office shall furnish a revised report in that regard. Full stop, next para, learned counsel for the appellant contents that by an order dated August 25, 2014, passed in CO number 2059 of 2014, a learned single judge of this court had directed the records of the suit to be reconstructed. Full stop. Next para, it is submitted that the entire file, including all papers of the suit in connection with which the present appeal arises, were misplaced. Full stop. Next para, learned counsel for the appellant submits that the appellant has been able to find out some documents. Full stop. Learned counsel submits that although such documents are lying with the appellant, it does not appear that those were exhibited in the trial court. Full stop. Next para, learned counsel for the respondent argues that the impugned judgment and degree was passed by recording the documents which are exhibited, which does not include the present documents. First up, we find from the impugned judgment that a list of the exhibits finds place in the said judgment, to be more precise, at page 7 of the impugned judgment. First up, next para, since learned counsel for the appellant submits that the documents available with him were not included in the said list, on the prayer of the appellant, leave is granted to the appellant to file an application under order for Rule 27 of the Code of Civil Procedure for leave to produce additional documents. Full stop. As and when the matter shall go out of the list, with liberty to the appellant to mention as and when the said application is filed. Full stop. A copy of the said application, when filed, shall be handed over to the learned advocate for the respondent to use an affidavit in opposition thereto, to which a reply will be filed by the appellant. Full stop. Next para, such application, liberty to the parties to mention such application as and when filed for inclusion in the list.
A certified copy of the revisional application of the.
That has not been made part of the record.
That is
No, this is. We have just referred to it.
Copy gave you. Better how it should.
What?
Item number 12.
Lordship 12, I appear for the petitioner's virtual lordships.
Yes.
Statement.
Yes.
Lordship, I had completed my arguments on the last occasion, lordships.
Yes, you
And,
had also
my-
filed written notes also.
Written notes was filed, and also, lordship, the legal provisions
What?
relevant compilation.
কি
My-
উত্তরটা দিচ্ছেন না, নোটটা আমার নোটটা ওনাকে দিচ্ছেন, ওনার নোটটা আমাকে দিচ্ছেন। ওইটা প্রজেক্ট Yes, would you just please
I have
divide?
also filed,
Yes,
lordships,
just
lordship. Lordship,
one is
the
that.
issue,
Yes. Yes.
the mandatory nature of section 54 lordships, whether the 60 days time limit prescribed under section 54 to process a refund, as well as whether the time limits prescribed under Rule 89 to Rule 92 to issue the acknowledgement, and under Rule 92 sub Rule 3 to give at least 15 days time to reply to the show cause notice was complied by the department, and whether a 2-day delay can vitiate the entire proceedings. And the appellate authority goes one step ahead and says that 2-day delay happened because of Saturday, Sunday, which in the technological driven GST regime, everything is on the portal. Even on Sundays, we are receiving appeal orders against which appeal can be filed. So that Saturday, Sunday delay is there. Lordships, on the the export fund, we had furnished all our shipping bill copies. And the section 16 of the Customs Act, Lordship, the LEO copy of the shipping bill is a proof of export. Now, Lordship, department says you bring the proof of export from Kingdom of Bhutan. Lordship, how does export works? I export the goods, I file shipping bill. Customs issues me LEO copy, that is a proof of export. Now, the importer in Bhutan files a import document with the Kingdom of Bhutan, which I cannot bring on record. There is no allegation cast on me that I have not exported the goods. The customs documents are there. But the appellate authority goes one step ahead and says, no, customs officers are very busy. So they are just passing all these shipping bills without actual verification. That's
Yes.
an apprehension cast by the appellate authority, Lordships, which I pointed to your Lordships.
Right.
Lastly, Lordships, the issue was regarding whether when we came, because there was no GST tribunal form, we came before the learned Red Court, Lordships. The Honorable Red Court only dealt with the point of whether the 60 days time limit under 54 is mandatory. As regards the merit of the case, a one-liner order was passed that there is nothing in the merits, and therefore the entire application under 226 got dismissed, Lordships.
Very good.
Our point is, Lordship, the appellate authority has improved upon the show cause, which was the allegation which was never in the show cause. The appellate authority has improved on those things.
That Saturday, Sunday,
apart, Lordship,
Saturday, Sunday improvement.
Improvement. And Lordship, also,
Yes.
certain new findings have come in the appellate authority, which was not in the show cause at all. They have not disputed those things. Now the appellate authority goes one step ahead and Lordship, I was a first-time exporter. I have a new GST registration. I was a first-time exporter. I exported this. There were 11 shipping bills total involved, out of which the appellate authority cast doubts over 4 or 5 shipping bills. So he could have given me refund of balance, but he rejects the refund claim.
Very good. Yes. Thank you, Mr. We remember. Now, yes,
Grateful,
Ms.
grateful.
Sarkar, what is it?
Lordship, I'm not able to hear my
Please
learned
use the
colleague.
microphone, otherwise online it's.
He has stressed on certain points, my lord. Firstly, he said that he has filed a return. The return which he an acknowledgement was given to that score by the department, my lord. Thereafter, a show cause was issued and a refund order has been given by the department. Now, my lord, first, I like to pinpoint on the definition of acknowledgement in Rule 9.
GST একটা লাগে চেম্বারে ফাইলটা আছে নিয়ে এসো তো বইটা ব্রাউন রঙের যেটা যেটা বাঁধা আছে যেটা সেভই করা আছে ডিকটেশন দিয়ে দিয়েছি You'll be relying on which rule?
Rule 90, ma'am.
আচ্ছা thank you.
Yes,
Sir.
ma'am. Rule 90,
No, 9 to went.
page 353.
Of this?
Yes, ma'am.
I have also, I have given separate legal compilation also. It is then.
Oh, it is there also. Acha, very well.
Yeah, Lordship. Page 13 of the compilation of the
will see from
legal provisions.
Yes, thank you.
Rule 90, my lord.
Yes, Mr. 2, yes. Thank you for this compilation.
Lordship, Lordship,
Yes, Mr. 2.
Application for refund, other than claim for refund from electronic cash ledger, shall be forwarded to the proper officer, who shall, within a period of 15 days of filing of the said application, scrutinize the application for its completeness, and where the application is found to be complete in terms of sub-rule 2, 3, and 4 of Rule 89. An acknowledgement in form GST RFD 02 shall be made available to the applicant. So the completeness is to be found with regard to the completeness in the term of 89 Rule 2, 3, and 4.
Right.
2, 3, and 4 speaks about what are the documents they are supposed to file, my lord. Now, 89.2 says.
Page 6.
Thank you. Yes.
My lord.
89.
Yes, my lord. My lord, they are supposed to give a statement containing the number and date of invoices along
Yes.
with other evidences.
তুলতে ভুলে গেছো নাকি?
My lord, the documents on which they
সেটা ভুলে গেছো?
statement.
Tell us. Yes.
Yes,
Two,
madam.
2, 3.
B, madam. Two B, madam.
2B, yes.
A
To small b. A statement containing
Number, date of shipping bills, bills of export, number and date of the relevant export invoices in case where the refund is on account of export of goods.
will come back.
I wrote a next circuit for it. No.
Yeah, there was, right.
Then only acknowledgement is expected to be given that.
You asked for those documents in time.
If they file for a refund, they're supposed to give certain documents.
If they don't give, then what happens? You scrutinize. Yes, you are verified.
Lordship, I cannot hear my learned friend. Can
Yes,
he
Ms.
can use
Shakar.
mic?
That is,
When they,
take it a bit closer to down. Yes, yes.
so when they file for a refund,
Achha, please take your seat. Yes.
when they file for a refund, my lord, they have to file some documents.
Yes,
on
understood.
which-
Scrutinize.
So they have to file those documents as per the rule 89, my lord. So as per which they file the documents, my lord. So an acknowledgement to that effect was given. Thereafter, my lord, as per provision of rule 92, my lord, the order sanctioning refund, my lord, if your lordship goes to rule 3 of sub-rule 3 of rule 92, my lord will find, my lord, that when the proper officer is satisfied for reason to be
Page
recorded.
50.
May I, my lord? May I read?
You continue. He's just giving the page numbers. Yes.
That the proper officer is satisfied for reason to be recorded in writing that the whole or any part of the amount claimed as refund is not admissible or is not payable to the applicant. He shall issue a inform GST RFD 08, that is a show cause notice, to the applicant requiring him to furnish a reply in form GST RFD 09 within a period of 15 days of the receipt of such notice, and after considering the reply, make an order in form GST RFD 06 sanctioning the amount of refund in whole or part or rejecting the said refund claim, and the said order shall be made available to the applicant electronically, and the provision of sub-rule 1 shall mutandis apply to the extent of refund is allowed. Now, my in this case, my lord, what has happened? Now, if your lordship comes to page number 53 of their paper book, my lord.
Yes.
They filed the documents, my lord. So as per 89, an acknowledgement was given, sir. These invoices, as per 89, you have submitted all the invoices. Now, they verified those documents, my lord. And after verification, a show cause notice was given on 8/2/2022, my lord. Which is after 50, the acknowledgement was given after, when they filed the refund. After 15 days, the acknowledgement was given as per rule 90, my lord.
So 8th of February, the acknowledgement was given.
The acknowledgement was given on 10/1/2022. They filed the refund on 24/12/2021. And after 15 days, the acknowledgement.
Wait.
Yes.
Filed for refund on?
On 24/12/2021.
Yes.
And after 15 days, they gave an acknowledgement on 10/1/2022.
You give an acknowledgement?
Yes, I. Sorry, my lord. I.
Yes.
And thereafter, my lord, after 48 days, the show cause notice was given.
When? Date?
That is on 8/2/2022.
Yes.
My lord. And if your lordship sees, the show cause notice reason is forged claim of zero rated supplies.
Where is that? Show cause
That
notice?
is page number 53.
Achha,
The
yes.
paper book. It says forged claim of zero rated supply. Now, my lord, page number 54, it says that you are directed to furnish a reply to this notice within 15 days from the date of service of this notice. So the due date of reply was 23/2/2022. That is 15 days from the date of show cause notice, that is 8/2/2022. So after 23/2/2022, 15 days notice. So complying the provision of 92 rule 3. Thereafter, my lord, page number 55. 55 is a detailed show cause notice. Why the show cause notice was given, my lord?
Yes. So you did not adhere to the timelines they're saying.
I adhered, my lord. The document showed that, my lord.
After 48 days, you have given that. But the 60 days timeline, where do you find that?
After 48 days, I gave the show cause notice. Now I have given a detailed show cause notice. The reason, my lord, page number 55, showing clearly, my lord, the RTP applied for refund for the first time. My lord, page number 55, my lord.
If you have is the order.
Yes, it's not the order, my lord. It is a show cause notice, my lord.
Very.
Detailed one. So it says that he had applied for refund for the first time. Hence, a field visit to his place of business was made. During such field visit, it was seen that the RTP runs business from a tiny place inside a tea garden where no metal road exists. The room identified by the RTP as godown was a small room. Till the end of the period for which refund was applied, the RTP disclosed turnover of inward supply and turnover of outward.
Need not read the entire thing because they are on the timelines.
So that is what I wanted to show. And thereafter, my lord, the information was availed from the back portal, revealed that RTP obtained whatever, my lord. The relevant portion is in 56, my lord. 56, my lord.
Yes.
The first para, my lord. It is seen in the said reply that the item for most of the cases for the item exported was not pan masala, but something else. For 2 cases, item export were pan masala, but both the quantity and value widely differed from what was shown in the statement 3, the statement of export. For instance, thereafter they refer stating the document number where there was a discrepancy found, my lord. And my lord, the statement 3 is attached as annexure A. The information which they sought from the custom of the Bhutan, those were attached in the show cause notice, my lord. My lord, the comparison of annexure A and B is attached as statement C. All whatever document the revenue relied on were given to them for reply in the show cause notice.
Ms. Shortcut, is there any timeline for giving the initial acknowledgement?
Timeline 15 days that has been added, my lord.
No, Lord.
No, 24/12 they had filed for refund.
Yes, my lord. 24/12/2021.
15 days means
15 days.
7,
8th of January.
8th of January. What? No, no,
8th
no.
of January.
Date of acknowledgement is 10/1/2022.
24th they filed for refund.
24/12.
24/12.
Yes, my lord.
15 days is over on 8th, not 10th.
My lord. But as per the
So
show
2
cause-
days after you did that.
Yes, my lord. 2 days after.
So there you missed out on 2 days, by 2 days.
My lord, actually what has happened, my lord, this person over here, my lord, has applied beforehand also for the same year 2 times for refund,
Maybe that's a
My
previous incident.
my lord. And thereafter, 3rd time they were applying, my lord.
Maybe.
And thereafter, the date of acknowledgement was given on 10/1/2022 as per the document, my lord.
So you were late by 2 days in
2
doing
days,
that.
my lord. But that is not a mandate, my lord.
You don't have to give it within 15 days.
My lord, it says, the book says that, the statute says that, yes, within 15 days, the acknowledgement is required to be given, my lord. But there was a 2 days delay, as per the records, my lord. So what has happened, my lord, the show cause clearly showed, my lord, there was a detailed show cause notice along with the documents on which the department relied, all the Bhutan documents, to show the discrepancy in their invoices, my lord, and they did not reply, my lord. They have taken time for the same, which is in page number 58, my lord.
So when did they file this reply?
They filed it on extension. They have filed on 23/2/2022.
So they filed on the correct date.
Yes, my lord.
So
We require time, file the reply, my lord. But as per the provision of law, within 6
23rd they had filed.
23rd, file request, my lord, that they require time to file reply for show cause notice.
And ultimately when did you granted them that extension? That was refused.
My lord, the order was passed. Within 60, there is a timeline of, my lord, as per section 54, my lord.
Yes.
Section 54 gives a timeline, my lord.
60 days.
Yes, ma'am. What does it say, my lord? It says that the proper officer shall issue the order under subsection 5 within 60 days from the date of receipt of application complete in all respects.
This is you are reading 54. Which subsection? Very well.
5.
And the timeline for giving acknowledgement within 15 days is at page in which rule? 90 itself.
Also says that this 60 days period, my lord, has to comply with the provision of subsection 5 of section 54, which speaks, my lord, if on receipt of an application, the proper officer is satisfied that the whole or part of the amount claimed as refund is refundable, he may make an order accordingly and the amount so determined shall be credited to the fund referred to in section 57. So the word satisfied is there, madam. If he is satisfied.
You
then
gave him beyond 60 days.
60 days order refusal. Fund is refused. madam.
Si- That they were delayed by 2 days was a reason for rejection.
Was the ground was that they filed fake documents. That was their the ground for it.
But they have taken a point that you effectively gave them 13 days because 60 days is over on 15 days, but that 15 days acknowledgement was issued 2 days late. So the entire timeline gets extended by 2 days. You are late in giving the acknowledgement. They say that that acknowledgement is also vitiated.
That is mandatory.
That is mandatory in nature, and for that you had to give an acknowledgement within 15 days. But by your acknowledgement, 15 days, now you give them a time for filing reply which was beyond 60 days itself. Beyond 60 days. The 62nd day you fix the date for filing reply. You first of all did not adhere to the timeline of that 15 days for acknowledgement. So you are 2 days late there yourself. And naturally, you also gave them 2 days further beyond the 60 days. So that why is not that process not vitiated? Where do we get that?
56, my lord. 56 speaks, my lord, if the refund is not paid within time, my lord, I have to pay an interest on it. 56, my lord.
Yes.
Interest on delay, any tax order to be refunded under subsection 5 of section 54. If they are satisfied and if they give a refund order, where any application is not refunded within 60 days from the date of receipt of an application under subsection 1 of that section, interest at such rate not exceeding 6% as been specified in the notification issued by the government on the recommendation of the council can be payable in respect of such refund.
So very well. So the timeline non-adherence to 60 days does not vitiate the process, but only the sanction is that you have to pay interest on that. Very well. Anything else? Yes. And what about the other point? LEO copy was given, but you insisted on Kingdom of Bhutan's documents. First of all, those copies were not probably given to him. Those LEO, those are not available to him. Those Kingdom of Bhutan papers, they imported.
Department relied, my lord. They have annexed it in the so-called notice, my lord, and that is clearly stated in the detailed order of the so-called notice, my lord, which is in page number 54, 56. my lord. Your lordship, come to page number 56, my lord.
Yes.
The last paragraph, my lord.
Huh.
The statement fee is attached.
The information is attached there.
Information, sir. On
So-
part-
So therefore, it was provided. Second point is, even if it was provided, those could not be relied on by you because the importer at their end, there's this taxation is on export. Export customs, whatever the customs says, LEO is sufficient.
Tan water and the custom officer, Indian custom office, there is a distance of 1.5 kilometers. So what they are doing, my lord, they enter by taking the seal of this custom and they are what do you say? They are
Delaying them at.
no, they are not taking those goods into the Bhutan territory, my lord, and they're dropping those goods within the Indian territory. So the goods do not cross the Bhutan border, my lord.
But why is the custom? Isn't a presumption raised when the custom gives a letter?
Bhutan custom. This document.
So you rely on Bhutan custom more than our own customs.
The Indian customer not seeing whether those goods are passing into.
Then you
the-
take steps against the customs authorities. You lodge complaints. But that does not that cannot raise a presumption. We have to go by our country's customs authorities. Export duty, the premise of this export duty is our customs certificate, not somebody else's. How do you know the Bhutan one is authentic? Bhutan may be trying to save money by saying that those were not important by them at all.
They're saying, my lord, that they are exporting pan masalas, my lord.
But right, we get your point, Ms. Sarkar, but isn't the custom authorities giving that certificate, supposed to give that certificate whenever the commodity leaves the border of the country, crosses the border of the country?
Countries, my lord. The custom office is near the borders, my lord. But in the Jaigao, my lord, what is happening is that there is a distance of 1.5 kilometers from the Indian custom office to Bhutan custom office, my lord. 1.5 kilometers, my lord. Distance.
Between the two customs office? No, between our customs office and the border.
That is why not only the SGST department, the CGST department is also verifying that fact. And there are crore of rupees refund claims which are being made by us. And it's a big scam, my friend.
All right. Very well. And 11 challenge, you have disbelieved 5 invoices. What about the rest 6? Why didn't you pay refund for them? That is another point.
Take invoices, my lord, and which the information they receive from the Bhutan border, my lord.
These are in respect of 5.
As per the show cause notice, my lord, the document which they have relied, the department, my lord, they specifically specify the documents, my lord, 24/5/2021. Another document is of 22/6/2021.
So they say that
It's pan masala, but it was not pan masala.
out of 11, 5 were refused, they're saying. Is that correct? So what about the other 6? Why didn't you refund those?
Department did not rely on the veracity of such documents, my lord, and that's why.
On what basis?
Fake documents, my lord.
How do you say fake? Fake is a serious allegation. Bhutan government gave those certificates regarding all the 11. Only 5. 5 you have disbelieved. We can understand. The rest 6 you had to honor because LEO is there.
Not fake 6, my lord, so I do not have any instruction on that. But I have instruction that they were relying on fake documents and based on which they were claiming for the refund.
So where is their reply? Where they claim? You say they have prayed for extension. Where is that extension prayer?
Page 58 of the paper booklet.
Yes. Under the law, can they ask for extension?
It's on the portal.
Pardon?
In the portal, in the GST portal, I can apply for extension.
But the law provides for that. Outer
Lordship,
limit
so
is 60
the law
days.
provides a 60 days. So, Lordship, in this case, they issued a show cause, they kept it tight, and they issued a show cause on 48th day. The law, in fact, provides, Lordship, within 60-day disbursal is to be done. Kindly appreciate this, Lordship. Otherwise, interest, my learned friend rightly pointed out. If
we can understand that, but first of all, we'll come to you. In reply, we'll come to you. Yes, Ms. Sarkar, anything else? This is all. Yes, Mr. Kanodi.
Lordships, 2 points first. First, my learned friend had shown you the provisions of acknowledgement, which the law prescribes that it should be issued within 15 days. Now, because in my case, it was issued only 17th day. No
Yes.
justification given as to why it was issued beyond that. Consequently, after that, Lordships, the law prescribes that 60 days disbursement has to be done. Otherwise, after 61st day, interest is payable. That is what the law is. Now, in my case, they keep the show cause notice pending with them and they issue to me on the 48th day.
Yes.
So ultimately, the question of disbursement, the question of me getting the natural justice time to reply or to attend a personal hearing. And Lordship, what they have done on the same day, the last day that they give to file a reply, on that day they have called me for personal hearing also. For example, Lordship, I will just take an example. Say 23rd, they have given me personal hearing and last day to file reply. Say I file the reply at 8 p.m. When do I get the personal hearing opportunity, Lordships? And personal hearing, Lordship, under section 75, it is mandatory. Section 75 of the CGST Act, Lordship, provides for mandatory personal hearing. And I can take 3 adjournments I can apply for 3 adjournment. But if they don't give me the scope at all, where should I, where do I go, Lordships? Therefore, I apply for request for adjournment, which the portal allows me to file. I filed on the portal. Now, Lordship, what they say, how did they reject my personal hearing request? Lordship, kindly takes page number 65, last paragraph. They have written why they are rejected. Page 65 of the paper book, Lordship, last paragraph.
Yes.
The due date of reply was 23rd of February 22. The RTP played for extension. The due date of disposal of refund expires today, that is 24/2, which is also beyond 2 days as per they are doing the calculation wrong. There is no provision in the statute to extend the date of reply beyond maximum days, that is 60 days prescribed in the disposal of refund. On the one hand, they are themselves stating no provision to extend beyond 60 days, and they are disposing it beyond 60 days only. So total contradiction. The officer relies on 60 days to reject me a grant of personal hearing because he says I
Now,
have
Mr.
to pass
Kanodia,
an
one
order.
thing, one question we have. Now, as per the
Lordships.
law, 60 days, within 60 days, disbursal has to be made. We can understand that. Now, 15
Lordships.
days is stipulated, mandated by the law. Let us take it mandated under 89, Rule 89.
92.
92. 15 days is
Lordships.
the outer limit within which they have to issue an acknowledgement. Now, let us
Lordships.
theoretically take that you file for refund on a particular day, and after
Lordships.
15 days, they give that acknowledgement. Then 45
Lordships.
days are still left, 45 days.
Lordships.
Now,
Lordships.
on the 15th day, if they gave you that acknowledgement, they had to give you mandatorily 15 days for the reply.
Lordships. Mandatory 15 days. That is
15
what Rule
days.
92(3) says.
And here they were 2 days late.
Lordship, 2 days late, but they issued a show cause on the 48th day. The question is what they were doing from 16 to 48 days.
Now, show cause notice, what
16
is
to
the
48
outer,
days, it was with
what
them.
is the outer, is there any outer limit for issuing a show cause notice?
No, Lordships. The entire refund process is to be completed from my application within 60 days, including personal hearing also.
So theoretically, Mr. Kanodia, they could have given you this notice leaving 15 days for the 60th day. I mean, suppose the acknowledgement was raised, suppose if it was raised on 8th, as
Lordships.
mandated by law, and they could have
Lordships.
taken till 15 days before, on the 45th day also, they could have given you the show cause
Lordships.
notice.
They could have. I don't deny it, Lordships. I don't deny it.
So
But
if that be
Lordships,
so, they gave it
generally,
on 48th day instead of 45th day. 45th day
Lordships,
would
but
be the last limit within which they had to give
Lordships.
it.
But Lordship, the hearing, the personal hearing is also very important here, Lordships.
Right, 3 adjournments opportunities are to be, yes. You get 3
I applied for
adjournment.
adjournment. 3 adjournment, Lordships.
3 adjournments.
On the first occasion, it was denied, saying I cannot do it because it is under the outer limit.
Right. So you
Now,
say that
Lordships,
adjournment could not be refused on the ground that it was the 62nd day because you had overstepped the time. 60 days is over.
Lordships.
That could not have been because they themselves overstepped by 2 days. But suppose if you had filed that,
Lordship, I would out.
if you had filed that reply, suppose they gave you the date of reply as the 60th day instead of 23rd, say
Lordships.
21st. Then could
Lordships.
you have the leeway? Theoretically, under the law, they could have done that.
They could have done that, but Lordship, then it would have been again a violation of natural justice because on the last day itself, they cannot call me for personal hearing and pass an order. Because Lordship, when they say the last day, 68 days, the due date to file a reply, that
Right.
means I can file that at 9 p.m. also at night. It is not that I have to file it in 2 p.m.
Yes.
in the afternoon.
Yes.
It is the whole day I am getting Lordships. So that also vitiates the process and it's a violation of natural justice.
So according to you, Mr. Kanodia, what could be the last day from the date of
There
filing?
is no reasoning.
Yes. What could be the last day when they
Lordships,
could have
that is
given
what the
this
board has
notice?
clarified in one of the circulars. So, Lordships, in fact, there is a board circular, Lordship, where the board categorically says that the entire process of refund should be completed within 45 days so that 15 days is remaining for disbursal. This is what the CBIC says.
Hmm.
That, okay, you complete everything in 45 days, 15 days you keep for disbursal so that interest is not liable. That is what the board thinks. Of course, every situation is not the same. I don't say, Lordship, that every situation it has to be completed in 45 days, with due respect, Lordship. But what is the logic, Lordship? What is the reasoning given by the department that 16 to 48 days they kept it with them? Now, Lordship, coming to the point that in the show cause they say this. They write this annexure, but nothing was given to me. Nothing uploaded in the portal. No Kingdom of Bhutan details was given to me.
difficult. No, they say with the show cause notice, it was served on you and
Lordship,
that
that is what, that is what, Lordship, kindly comes to the show cause notice.
yes. Please
Show
come to
cause
that.
notices, Lordship, page number 61. Page 61, my Lordships, is there?
Yes, 61.
Oh, Lordship, so 61 is the order, Lordship. I
No,
apologize,
this is
Lordship.
the
Show
order.
cause notice is at page 53.
53.
53. Yeah, Lordships.
And it's accompanied by page 55. That
55. So
there is
only page 55 and 56 is what is uploaded in the portal, nothing else.
So page 56, please come there. Page 56. The last
Page
last
56.
paragraph, penultimate paragraph says the information received from Revenue and Customs Authority is attached as Annexure B.
Lordship, there is nothing in the portal.
But they say that it has been
There's
annexed
nothing
as
in the
Annexure B.
portal, and Lordship, in fact, Lordships, I'm audible, Lordships.
Yes,
Lordship,
we are hearing you. Yes.
they saying it is there, it is attached. Lordship, they say it is annexed. I say I only get these two pages, 55 and 56 in the portal.
Yes.
And Lordship, if at all, for the sake of argument, Lordship, if suppose it would have been attached in the portal, then Lordship, it's a third-party document. How can I reply to a Kingdom of Bhutan document? It is not under my control. They have not taken from my possession. Lordship, Section 16 of the Custom Act then has to be stated to be ultra vires the GST Act. Section 16 of the Custom Act, in that case, will have to be read down as ultra vires Section 16 of the IGST Act, Lordships. Because the GST law everywhere specifies that 16 of the Customs Act is the date of export.
Right.
And Lordship, all my export documents, kindly takes Lordship. What are my export documents? It starts at Lordship, page number. In the paper book, Lordship, may kindly take page number 18 onwards, 18 of the paper book. In fact, 19 onwards. All shipping
Yes,
bills. LEO copies of
Wow.
shipping bills from 19. 19 is the Indian Custom Media System, LCS Jagaon. Let export order copy. And Lordship, I would like to submit before your Lordship as an officer of this court that all these vehicles which are going through LCS are being photographed by the customs, videographed and photographed.
Very well.
Now, Lordship, all these, I have attached all my export documents. I have given all my purchase of pan masala documents. You come up with a third party evidence to state, no, you have not exported the goods. That means Indian custom documents are of no relevance to the state GST authorities in that case. Where, Lordship, I don't say that a racket is not going on. Maybe some unscrupulous person are doing it. But for some unscrupulous person, everybody cannot be tainted with the same logic. Unless you bring certain records
So
to
according to
prove
you, Mr. Kanodia, what should be, even if we allow your this challenge, then what should be the
Lordships.
stage where we should go back, according to you?
Lordship, Lordship.
No, what is the
This is
best
something-
order you can get and what is the worst? Worst order is obviously dismissal of your appeal. Let us forget
Lordship,
that.
Lordship, in that case, I may be remanded back to the original authority, the
At
first
what
authority,
stage? That is what we are
at
saying.
the show cause stage. At the show
Okay.
cause stage.
So show cause
So that-
notice has to be issued afresh, according to you.
Afresh, it has to be issued, but and Lordship, with certain directions that my export documents has to be first challenged by them. They cannot rely on
No, the
third
rest
party
of the
export documents.
observations, rest of the things we will be considering. But
Lordship.
no, we are not saying that we will grant that through you. We are
No,
asking
Lordship, I'm
what
just-
is the best relief you are expecting. Now,
Lord-
another aspect of the matter, these 15 days
Lordship.
for giving acknowledgement, is that
Lordships.
mandatory or directory?
It's mandatory, Lordship. The word used in Rule 90 shall.
Right. So that is your argument. Very well.
It
And Ms.
is
Sarkar,
shall,
Ms.
Lordships.
Ms. Sarkar
And that is why,
argues
Lordship, and there's
yes,
a
please.
logic to it, Lordship. There's a
Sorry.
logic. Lordship, the law says if once they scrutinize my application, if they found certain deficiency, they will issue RFD 03, which will relegate back to me to again file a refund application. So seeing that picture also, Lordships, RFD 02 acknowledgement, which they say it is mandatory, Lordship. The time limit is mandatory.
And Ms. Sarkar argues that no, it's not mandatory because interest is imposed. I mean, the sanction given
Lordship,
for not complying is interest.
I have a counter to it, Lordship. So
What is that?
interest is payable in case I get a refund.
Right.
If But what happens? So the law will only envisage a situation where a person is eligible for a refund, a sanction order is given. What happens to a person who a rejection order is given? What is the consequence provided in the statute? No consequence. So, Lordship, statute cannot be only read for a person who is eligible for a refund, who gets the refund, he will get the interest in case of delay, and delay on account of disbursement. A person who is rejected, then the entire proceedings will always, Lordship, in fact, then every proper officer who is processing a refund, he will take his own sweet time of 90 days, 120 days, for his will and wish. Then the entire board circular that you complete the things in 45 days and disburse it within the next 15 days, then that circular is not binding on department itself then.
All right.
Lordship, the logic of Saturday, Sunday. The logic of Saturdays.
Yes. No reply to reply.
Lordship, I'm not a Lordship, my learned steel friend.
You can hear? Now you can hear?
Yes, I can hear.
The thing is that, my lord, they filed an application for refund on 24/12/2021, my lord. After 2 days delay.
Don't repeat things, Ms. Sarkar. We are tired of it. You say what you have to say because we are on reply to reply to reply.
8 days, my lord. After verification of those documents, it was given, my lord. So if after verification, if they were liable to get the refund, the order would have passed on the 48 days, my lord.
Then you are giving a go by to the entire timeline. If you say that's directory.
My lord,
That is one aspect we have to consider in this appeal.
my lord, the thing is that the 48 days, they have passed an show cause notice with a reason for why the refund should not be rejected.
But then if you insist on the 60 days, because 60 days is there, the timeline is there in the statute.
Yes,
So if the refund is to be given in 60 days and you give them the time for filing, date for filing reply after 2 days after that 60 days, when will they file the reply? When will you give them a hearing under section 74, 75? And when will they get the 3 times extension which is provided for in the statute?
In this show cause notice, it also says that hence the refund application is liable to be rejected. They have given their observation in.
You have rejected on the ground, it's
My lord, this show
after
cause-
time.
Yes, my lord. No, on the 48 days, my lord. On the 48 days, they give a show cause notice stating that your refund is liable to be rejected on such grounds. So
The ground is that they have overstepped 60 days.
No, the ground is that they have given false fake documents.
Very well.
They have submitted fake documents, my lord.
The closing arguments. Hearing is concluded. The judgment is reserved in the matter.
Grateful, Your Lordship. Much obliged. It was a
If
pleasure
you
appearing
feel,
before your
if you feel we need some further clarification, if you feel from either party, we'll put it on
Lorships.
notice by keeping it as to be mentioned. Just watch out Monday, Tuesday,
will.
at least. By that time, we'll put it
Lorships.
as to be mentioned and seek the clarifications. Otherwise, we'll go on passing judgments. Yes.
Grateful, Your Lordship.
Thank
It was
you.
a pleasure appearing before your Lordships.
Thank
Grateful,
you.
Your Lordship.
Same here. Yes. এটা staple করে এতে দিয়ে দাও। Dr. Chaudhary, have you prepared any notes of our notes? Just make a Monday, then when will you pass a judgment on this? That is what you're saying.
But I was intending to prepare it, but last night I could not complete it.
No, today by evening, tonight, this evening, can you give it to our officer? Do that. Because you know what you will argue on.
Not on Monday, but thank you.
Monday, if you give it, we won't have, it will be during the week, then it will be very difficult for us to pass judgment on that. That is a difficult. Death reference matter, that is why we are saying.
Well, I'll try to make it a bit convenient for your lordship.
Yes, in brief, complete your arguments, Mr. Chaudhary. Without written notes is difficult because you're referring to several pages. That is the difficulty. এতে কোনো নোট ছিল আমার?
But only the one of the most important witnesses remaining, that is the investigating officer,
Yes.
and my lord Ashok Roy, as your lordship remembers.
Ashok Raj, yes.
But we are continuing with PW 13, my lord Nirod Roy, who was the driver who took Momita to hospital. I mean, lord, the chief was completed, and lord, for better recapitulation, my lord, all I have submitted that in the examination in chief, my lord Nirod Roy did not spoke anything regarding apprehension of the accused persons while they were coming back from the hospital after dropping Momita.
Which page?
My lord, page 78.
Yes.
My lord, the last line of the chief, after admitting Momita in the hospital, we returned back home. Lord, nothing with respect to apprehension, Lord, stopping at Devmali for taking tea and apprehension of Aftab and his associates, nothing, Lord, with respect to that. Now, Lord, the cross-examination. At present, I am working in Kerala as a driver. At the relevant time, I came to my house from Kerala. Police did not seize my driving license. Police never asked to show my driving license. My house situates within 100 meters from the house of Mehtab. I found Momita in injured condition on road within 20 meters from our house. I cannot recollect the registration number of Maruti van. Abul Hossain was the owner of the Maruti van and he resides 1 kilometer away from the house of Mehtab. Seat of the vehicle was stained with blood. I was interrogated by police after 7 to 8 days of the incident in our locality. I stated to police that Abul, Patanu and 2 others accompanied to the hospital. Within 15 minutes, we reached Dhupguri hospital, but I cannot recollect the exact time. I heard that Aftab was apprehended by police from a jungle at Devmali, 3 to 4 kilometers away from the house of Mehtab. While we were returning from the hospital, we got that news after 1 hour. It was Sonakhali forest where the accused was apprehended. So, Milord, entire different story, Milord, from what the previous witnesses has narrated with respect to apprehension of Aftab and his associate. He says the Aftab was apprehended at Sonakhali forest, which is 4 kilometers away. He has heard that. So, Milord, entirely different story comes in, Milord. And thereafter, Milord, general denials, Milord, in next page. I will not reading those.
Others in his van say they saw
Yes.
the apprehension. After apprehension, they met and all.
Yes.
Yes. Then
Then, Milord, the next witness is the treating doctor at Anandolok Hospital.
yes, yes.
PW 14, Milord. I'll not read the entire evidence.
Need-
Not
need-
required. Milord, only the last line of the chief.
Yes.
Page 81.
Yes.
The patient did not disclose the name of the assailant. That's all.
80
Page 81. Last line of the
cross.
Yes, yes.
That's very good.
But he only gives evidence that he has treated Momita and what were the nature of injuries. That's all. Milord. So,
All right.
not so relevant. Next, Milord, page 82.
Yes.
Page 82 is Ashok Roy, Milord. Milord, at whose house Momita has taken shelter. Milord, I know Mehtab Alam and his wife
Yes, you carry on.
and his wife Momita Dash as my neighbor. Mehtab Alam was my childhood friend. Mehtab Alam is not alive. Mehtab was murdered. I knew Aftab Alam since his childhood as he used to reside in the house of Mehtab. Aftab Alam is present in court today on 28 July 2023 while I was sleeping in my house at night and at about 2 to 2:30 at night I heard someone was knocking my door. When I opened the door, I found Patanu Roy and Ranjit Roy. Well, Ranjit was not examined. Was standing in front of my house with Momita Dash, whose wearing apparel was stained with blood. When I asked Momita, she disclosed that Aftab and his 5 friends entered into their house with knife and murdered her husband at
He
about.
corroborates the rest of Momita's thing.
Yes, yes. Then he says, I called his neighbor
Nirodha.
Nirod and those things.
But he says he called his neighbor Nirod to send her to hospital.
Yes,
But previously it was said probably Momita stopped the vehicle,
yes,
isn't it?
yes. Momita stopped the vehicle and thereafter they have called Nirod. So, Milord, this is also in doubt, Milord, who had actually called Nirod.
Raise a hand for help. 10-15 মিনিট দাঁড়িয়ে ছিল বলেছে 20 থেকে 30 মিনিট 20-30 মিনিট দাঁড়িয়ে ছিল তারপর হাত দেখিয়েছে গাড়িটা থামিয়েছে আর এই বলছে নিরোধকে ডেকে এনে পাঠিয়ে দিয়েছে ওর ভ্যানে Anyway, yes.
Yes. My lord, in the cross also, my lord, he says he called Nirod over phone. And the last line, before the general denial, my lord, last line of the cross,
Hmm.
page 83.
Hmm.
After arrest of the accused persons, I
Yes.
saw them. My lord, before the not of fact, before general denials, after arrest of the accused persons.
No, when Ashok Roy, when he saw is not important. That does not either corroborate or go against anything.
But he
The
said
only
after-
evidence was that Ashok Roy sheltered Momita after the offense.
He never went to Devmali, Ashok. But he says, I have seen the
We
accused
don't know
person."
whether he went or not. That's entirely beyond the other evidence.
But no such evidence was adduced by him that. he
Maybe
was-
there's no contradiction.
Fine.
Interruption. Yes. Momita. No, Momita once said 20-30 minutes, waited and raised her hand and stopped the. But this person says he called his neighbor Nirodra and sent Momita. Please come to page 82. I called my neighbor Nirodra and sent Momita to Dhupguri. If Ashok called Nirodra and sent her to by a Maruti van, then Momita did not stop the car, Nirodra's car, and Nirod was the driver of the Dhalai team.
Persons were there. This Ranjit and Patanu is the Halai party. Then they accompanied Momita to the house of Ashok. Thereafter, Ashok called Nirod because Nirod has a Maruti van. To take her-
Nirod was not in the Dhalai party, you are saying. Very well. Get your point. Yes.
Now, my lord, Dr. Bhashwar Bhattacharya, my lord, the post-mortem doctor, my lord, I'll be taking only few points from him, page 84. My lord, in the cross, he says, since 2019, I have experience of conducting postmortem. My lord, the incident of 2023, 4 years, my lord, he had experience. So I'm not going into that. And my lord, page 85, the second paragraph.
Yes.
He says, generally, lungs can be found within 5 inches from the back of a general man. Not a fact that backside of the body is not the vital part to cause death of a person. I also found cathecal hemorrhage on eye. I found clothes of the deceased during postmortem, but I did not mention in my report. Generally, clothes are torn before placing it for postmortem. Cathecal hemorrhage on eye is available when death is caused due to strangulation. Now, my lord, this is very important because nowhere in the records, lordship will find that there was any kind of strangulation or throttling on the deceased person, Mehtabala. But he finds strangulation. And this will, lordship will find some relevance with the 313 of the accused persons, where a story, my lord, defense story has come up, which has never been touched during the entire 4 corners of trial, my lord. I'll come to that. So, my lord, this is one aspect, the strangulation was also there. Well, rest are general things I'll not get into it to save time. And the very important witness is the investigating officer. We'll look the next one. PW 17, page 86 onwards. Look, the first page, normally he explains how the incident happened. But I'll start reading from page 87.
Yes.
Lord, from I know his handwriting and signature of my colleague. First line only. I see after I see.
Yes, yes, yes.
I know his handwriting and signature as my colleague. This is the receiving endorsement on written complaint. Let it be marked as exhibit so and so. Thereafter, specific case being Dhupguri PS case number so and so, dated so and so, under section so and so, was started, and he prepared formal FIR in his own handwriting and signature. This is the said formal FIR. Let it be marked as exhibit 27. Thereafter, the then IC Dhupguri PS endorsed the case to me for investigation at 10:25 hours on 28 July 2023. IC Dhupguri PS informed me over phone that local people apprehended 6 unknown persons. Out of them, 4 were male and 2 were female at Murgi Hotel, Devmali. Immediately, I, along with force, went to Murgi Hotel, Devmali. Their wearing apparels were muddy. Now, my lord, I take a pause here. My lord, the FIR was registered at 10:25 in the morning. And then IC Kotwali, IC Dhupguri PS says that local people has apprehended him. You go and hand over the accused persons, take them in your custody. Now the question is, from 3:30 or 4 in the morning till 10:25, 10:30, my lord, there is no explanation where the accused were, whether they were taken then and there, because the IO says he has taken it after 10:30. So, my lord, from that time till this time, where the accused persons were and when they were actually apprehended, my lord, this is a gray area, my lord, which needs a relook. Then, my lord, on interrogation, they confessed that for the purpose of dacoity, they went to the house of Mehtab and committed murder. They also disclosed their names: Abhishek Masi, Yashab Masi, Sumit Chaudhary, Kriti Shah, Sakshi Misra, and Aftawala. I arrested them and brought them to the PS and recorded their statement under section 161 CRPC. Thereafter, they were forwarded before the court. I made a prayer for holding TI
You can
parade.
read the relevant portions, sir.
My lord.
Yeah, obviously, otherwise would be corroborating the.
Lordship. My lord, I'll come straight away after the MAT exhibit 1 to 3 identified in bold. But after that, I examined available witness and recorded their statements under 161 CRPC. I went to Eviction Nursing Home, Jalpaiguri, and where Momita Das, wife of deceased, was admitted. Considering her serious condition, I requested the doctor to record her dying declaration, and after recording dying declaration, I collected the same. So this was the relevance, my lord, of recording the dying declaration. Now, my lord, I'll straight away come to next page, page 88. The second para on 6/8/2023, my lord. I made a prayer for police remand of the accused persons on 7th August 2023. Police remand for 3 days was allowed. But this is another gray area. Arrested on 29th of July. But police remand was asked on 6th of August. But where these persons were till then, but this is unknown. On 7th, the police
No,
remand
but it
was
says on 2nd of August, TI parade was held at Correctional Home, Jalpaiguri. Obviously, they were there.
Yes, so my lord, why the police remand was asked on 6th of August or whether they were in the police remand?
That cannot vitiate the subsequent trial, because after that evidence came, the trial began, evidence came, and everything came.
No, my lord, this is connected with the recovery of the offending weapon. That is it. Now, my lord, during PC period, he says, during PC period, accused persons gave statement to the effect that they would help me to recover the weapon from the place where it was concealed. As per their leading statement, I went to Sonakhali Forest at 16:25 hours on 8/8/2023. I recovered one black color backpack with Puma printed, one yellow colored nylon rope, one sharp edged knife, one partially torn black colored scarf, one sky colored printed vest, and cash of rupees 3,500 as shown and identified by the accused Aptawalam. I also recovered one iron made knife with plastic handle shown by the accused Kritisha, another knife shown and identified by accused Sumit Chaudhary, another knife shown and identified by the accused Yashab Mashi, another knife shown and identified by Sakshi Misra, and finally another knife shown and identified by Abhishek Masi. Above articles were seized from Sonakhali Forest by me in presence of the accused person and as well as independent witness Abul Hossein and Rafiq Ali after preparing seizure list. PW 8 and PW 9, my lord, two independent witnesses. Now, my lord, I take a pause here also. My lord, the judicial precedent says, my lord, how the recovery under section 27 has to be effected. First, when the accused express their intention of giving a voluntary statement, my lord, it has to be recorded in the police station itself and by calling two independent witnesses. In front of those independent witnesses, the statement has to be recorded. After the statement is recorded, the officer will take them to the place where the where the accused person takes them, and thereafter it will be recovered. After that, my lord, there will be a post-seizure statement also that on the basis of my statement, these articles have been recovered. And the investigating officer has to, my lord, say the exact words what the accused has said during giving the voluntary statement in his evidence. So, my lord, in the evidence of the investigating officer is totally silent as to what the accused has said. There has to be the exact statement of the accused.
All right.
Now, my lord, let us come to the next paragraph. Prior to recovery. Prior to recovery of the above articles, the accused persons gave their statements to me to the effect that they kept concealed one bag containing knife, stolen money, rope, vest, partially torn scarf at Sonakhali Forest. and they would help me to recover the same. This is the statement of the accused Aftab Alam leading to recovery. So, my lord, that statement 161 statement was proved thereafter as Exhibit 30.
Point out the discrepancies, Mr. Chaudhary, Dr. Chaudhary.
Lordship.
Need not read the entire evidence because
Now, Lord,
the
let's
circuit
come to
bench,
the-
that will be very difficult for us.
Lord,
We
let us
can
come to
proceed
the
that,
case example.
that way. Yes.
Lord, 10th line.
Yes.
I arrested the accused persons on 28/7/2023 at about 11:05 hours to 11:17 hours. So no explanation where they were detained till then. I did not seize wearing apparel of the accused persons.
Weren't this apprehended at Murgi Hotel and they were there, must have been there when they came. They were apprehended there by locals. The
Lord,
police came and brought them, took them from there. So they were apparently in the
Lord,
Murgi
the
Hotel.
IO says that I have gone to the place of occurrence and taken handover, my lord, after receiving the FIR and after I was directed by the IC. In chief, he says so. And in cross, he says that I arrested them at 11:30 hours. So, my lord, till the intervening period, my lord, this is still not explained, my lord, anywhere in
No,
the.
he says that he, along with force, he went to Murgi Hotel Devamali and apprehended them.
Yes, after
10:30 was informed, 11:05 to 11 something, the arrest took place.
And the local says, my lord, they were apprehended at 3:30 in the morning. So these 6-7 hours.
How does that make a difference? They
So,
were,
this shows, my lord, whether they were at all apprehended by the accused person, by the locals there, or, my lord, they were subsequently arrested. My lord, this is still a gray area.
all right. Very well.
Now, my lord, the next line. I did not seize wearing apparel of the accused persons. My lord, 5-6 people, my lord, committing brutal murder of these persons using daggers. My lord, locals say that there were bloodstained apparels, wearing apparels. In the hand also handkerchief, there were bloodstains. But he says that I have not seized any wearing apparel of the accused persons after their arrest.
All right. So wearing apparel were never produced.
No,
All right.
not even seized, my lord. Next, I have perused the statement of Moumita Das recorded under section 164 CRPC for the sake of investigation. Next, my lord, very important. I prepared sketch map after visiting the PO, but I did not prepare any sketch map after recording statement of Moumita to identify the window of the room through which Moumita fled away. I did not record statement of Moumita under section 161 CRPC. During investigation, she did not identify the window through which she fled away. I did not find any stain of blood in any of the windows. Next, my lord, there are 2 bedrooms and 1 kitchen in the house of the deceased. The floor of the room was pakka. Local people identified the PO, but I did not mention any specific name. Next, very important, I did not mention specifically the place where the body of Mehta was lying in my sketch map and index. I did not find from the statement of Moumita that she disclosed the incident to Rafiq, Patanu, Nirodray, Abul Hussain, Ranjit Tigga. So, my lord, this is a gross contradiction, my lord, where the version of Moumita in her 161 is not corroborated by the IO herself, because the IO has recorded the 161 statement. As well as the 164 statement, there also, my lord, there is no corroboration. I did not collect any document from Dhupguri Rural Hospital regarding treatment of Moumita. I recorded the statement of the owner of the vehicle by which Moumita was taken to Dhupguri Rural Hospital, but I did not see that vehicle. I cannot say what type of vehicle it was. Ranjit and Patan did not state to me that they entered into the room of Mehta. Another contradiction with respect to their version and the IO's version. I did not seize the wearing apparel of Moumita. Prior to recording her statement under section 164 CRPC, I did not record her statement under section 161 CRPC. Next, I visited, next line. I visited there on 28th July 2023 at about 16:25 hours. I noted it in my CD. Then says it was not mentioned in the CD. So, the visit is also doubtful. Next, during investigation, it came to light that the accused persons entered into the room after breaking open the window. I did not seize any broken window. No broken window was shown in the sketch map. I received information at 10:25 hours regarding detention of the accused persons at Deomali. I recorded statement of witnesses in my notebook and subsequently it was typed in the computer of the PS and obtained signatures of the witnesses at PS. I did not attach said notebook with the CD. Statement of the accused Aptawalam leading to recovery was recorded in presence of witness Abul Hossain and Rafiq Ali. I did not obtain their signatures on the statement. So, this is the violation of the precedent of the Honorable Supreme Court, Babu Sahib order. I'll come to that later. It was not mentioned specifically that the said statement was given voluntarily. I recorded the statement at the place of seizure 8 on 8/8/2023. My lord, he clearly admits that. I did not prepare any sketch map of the place from where the offending weapon was seized.
Yes.
Prior to seizure of the offending weapon, a GD entry was made, but it was not part of the CD. I did not find any stain of blood on seized weapons. I did not produce the seized weapon at the time of post-mortem. I did not obtain any opinion from the doctor after recovery of the weapon. Offending weapons were sent to RFSL on 21st of August 2023. Till date, I did not collect any report from RFSL despite repeated reminder. So, there was no forensic report on record with respect to the offending weapons as well.
Yes, you continue.
Yes, I seized the offending weapon on 8th August 2023. During this period, I kept the articles at PS Malkhana. I did not obtain any receipt from the in charge of Malkhana. I did not explain in the CD for such delay in sending the weapon to RFSL. I cannot say when offending weapons returned from RFSL as I had already been transferred from Dhupguri. So, the chain of custody of the offending weapon, keeping in Malkhana and then sending it to the forensic lab, is also not established, and there is no report. So, the chain of custody, no use of going to the chain of custody. I obtained signatures of the accused persons and witnesses on label. I cannot say whether Sonakhali forest is restricted area, but there is a small village beside the forest and the villagers use the forest. So this contradicts not that there was no house.
At the immediate vicinity of the recovery spot, there might not have been any house.
Yes.
There, he says there is a village beside the forest.
And
Which
the-
side,
yes.
how far off, we don't know these things.
And the
These are
villagers
not
use that
contradictions.
forest. So, there is access of other persons as well.
Yes, maybe.
Yes. It was not mentioned in the statement of Momita that rupees 3,500 was stolen from her house. All seized articles were forwarded to RFSL on 21st of August 2023. After her recovery, Momita did not identify that seized pillow cover, bed cover, and mosquito net. Ashwini Rai was not the charge sheet witness. I did not verify the fact that sons of Mehtab took shelter in the house of Ashwini. I did not collect the extract copy of the hotel register Golden Homestay. Ayan Alam did not state in his statement under section 164 CRPC that he took shelter in the house of Ashwini Rai. Very important. It was not mentioned in the written complaint from whom the complainant received the information about the incident. It was mentioned in inquest report that 6 accused persons were involved in the murder, but their names were not mentioned. So, these are the gross contradictions in the investigation of the done by this investigating officer, and thereafter, general denial starts. Page 91, third line from the bottom.
Yes.
It is a fact that I did not verify the place where Momita took shelter. So, this aspect was also not explored by the was not verified by the investigating officer with respect to the shelter taken at the house of Ashok Rai.
These are peripheral facts, Mr. Dr. Chaudhary. Yes, undoubtedly, but these are peripheral facts, not directly relating to the crime. The other dots can be connected. Local people apprehended, Murgi Hotel, Ayu went there after getting information. There's a broad corroboration of the entire chain of events. These are small things here. Yes, there are irregularities which we'll be arguing on the law also. That absence of signature on the statement, a leading statement being taken, no clarification on that. These things are on law, you will be definitely arguing. But otherwise, the general chain of events apparently was, I mean, one does not remember exactly who was where at that point of time. Local people apprehended. She was taken to hospital by a Maruti van driven by Nirod. One, what this Dhalai party was coming. They were stopped. These things are there. Dhalai party's job was, Dhalai party was stopped by Momita, took her to Ashok Rai's house or wherever, and then she was taken to hospital by Nirod Rai's Maruti van.
Yes.
Might not be by the Dhalai party's car.
No, the car belongs to
Car
Abu.
belongs to, yes, and Nirod was the driver, right? So there is a general corroboration. Till now we find.
But there are lots of these gray areas are absolutely there, Lord.
Light grey, very light grey.
Lord, I'll come to the 330. 313 is very important, Lord, where after Milord has stated the circumstances.
How long will you take, Dr. Chaudhary?
Milord, I will take 30 to 40 minutes more and I'll conclude with the written notes on Monday.
And you will take more or less?
Monday then, written notes will be, sir.
I mean, Monday.
Yes, no, previously you have to serve.
Milord, I will give you a soft copy there.
During the weekend, you give him a serve.
I'll give you.
So how long approximately will you take?
2 hours. 2 hours?
Don't take 2 hours. You will get the written notes of arguments. Make pinpointed arguments. Make pinpointed arguments.
I'll try.
Somebody fill it. Yes, let us pass the order. Heard in part for further hearing on July 28. আর ইয়ে অনিন্দিতা আজকে আপনি দেখিয়ে নেবেন আমার লিস্টটা কোথায় কি থাকবে লিস্টটা ছাড়বার আগে দেখে নেন ইয়েস মিস আগামল
There are death reference and criminal accused pending. In every circuit, the mandamus appeal and other things are taken, but criminal accused are not taken.
we are this does not apply to our bench. From the first day we are requesting advocates to do the death reference matters. Every death reference matter was adjourned on the first day. Every death reference matter we touched every, and every day we are trying to touch death reference. On this, after the second and third day, third, fourth day we could not touch. First 2 days we gave chance. Nobody did the matter. In his matter, time was short, and he started also on the subsequently.
There are two other
We cannot touch death references. How can we do it? Even one death reference we won't.
I've served upon the state as well as the complainant.
Death reference we are already giving much preference. We are not touching the other appeals.
16 and
Only 2
17
GST matters came in between.
No, this is Mr. Orjun's matter. There are two other matters, Milord, 16 and 17.
Yours is which item?
Milord, 16 and 17.
What is the year of that?
And 18. And 18, because it's running in the list. Where is
Item
number? Item number? Yes, 16 and 17, Milord, pertains to the year 2024.
But even this matter, we don't know whether it will be concluded on Monday. How can you take the death reference matters and dispose of?
Milord, your lordship had directed me to prepare the written notes, Milord. I have prepared that. Milord, I have served upon the state as well as the complaint.
Which item?
Milord, 16 and 17.
We'll keep the death reference matters on priority basis. After the
Yes.
applications and order for terms, we'll take up death reference.
That
We
is-
won't take up any matter appeals further. We'll get ready in all the matters. Yeah, don't go anywhere during this weekend. If you are taking away our time, we will also take away your time. Very well. GST ফাইলটা যেটা হলো সেটা পাঠিয়ে দেবেন
In your lordship,
Yes.
this for
Yes.
extension of the interim.
Civil revisional application. Extension of interim order.
Extension gulo, please write extension over the extension matters. Write extension. Yes. Extension, Anindita, extension gulo extension heading এ দেবেন ওপরে একদম ওপরে extension তারপর yes. Yes.
Contested application upon notice.
My lord, this is the second.
Let it come in the list. If you are in difficulty, just mention. Yes.
Second appeal, my lord, the question of law has been formulated, but my lord, there is no direction for the paper.
Appears to be mentioned. Right to be mentioned and hand over, please. Yes.
May I mention to civil revision application?
Yes. Yes. Call on the list.
Item number 1. A.
Yes. Restoration
Restoration
within time.
within time. Before admission, they dismiss for default before admission of the C.
You have not served copy.
No.
Since the application for restoration have been filed in respect of an order dated May 20, 2025, which was passed before admission of the motion, comma, by application of the principle embodied in Order 22, Rule 4 of the Code of Civil Procedure, comma, prior service of notice on the opposite parties is dispensed with. Full stop. Since sufficient reason, what is the reason given?
A medical reason.
Since sufficient reasons for the absence of the petition on the relevant date has been explained, comma, can 1 of 2025 is allowed, thereby recalling the order dated May 20, 2025, whereby CO number 61 of 2025 was dismissed for default, comma, restoring the civil division to its original file and number. Revision, are you ready in the revision? Yes, what is the matter?
Matter is the rejection against the amendment petition. So what was the amendment? Amendment application was filed in page number 21.
Yes. What was the stage when you filed this application?
PW1 was completed. But the reasons for rejecting the application is that 20 page
No,
number.
your original ground was not adjoining owner.
No, it was adjoining.
So what have you
But we
started?
elucidate which are the plots adjoining plot that.
Shows the original paragraph once, para 8.
Original paragraph, my lord.
Para 8,
8. That is 14, page number 14.
page 14.
Para 8.
What is the ground for rejection?
Ground for the new ground is at the at this stage, insertion of new paragraph in the plain describing surrounding plots will amount to give rise a totally new ground.
The petitioner has made out a strong prima facie case for hearing the revisional application on merits. Push up, the revision is directed against an order whereby the application for amendment of the preemption application filed by the petitioner under Section 8 of the West Bengal Land Reforms Act was rejected on the ground that it was filed at a belated stage and that the amendment, comma, if allowed, comma, will give rise to totally new grounds. For sub next para, however, comma, from the original paragraph number 8 of the preemption application, it is clearly seen that the petitioner claimed preemption on the ground of adjoining land, on the ground of contiguous ownership. For sub next para, by virtue of the proposed amendment, comma, only elaborations on the basis of rudiments of the pleadings which are already there in paragraph number 8 of the preemption application have been sought. Full stop. Thus, comma, prima facie, the learned trial judge acted without jurisdiction in rejecting such amendment merely on the technical ground of delay and on the erroneous premise that a new ground will be added if the amendment is allowed. Full stop, the revisional application shall be heard on the above question. The petitioner shall serve copies, both. Let us see. Copies of the application, copies of CO number 61 of 2025 on the opposite parties, indicating that the revisional application next circuit
Next week it can be heard.
can you
I'll
serve in the
serve.
listed on July 30, 2025 for hearing. Full stop. An affidavit of service shall be filed on the returnable date by the petitioner. There shall be stay of all further proceedings in preemption, in miscellaneous within bracket preemption bracket closed case number 05 of 2022 pending before the learned civil judge junior division at Mekhliganj district Kuch Bihar till disposal of the application. Next. Mr. Mishra, for the first time, motion. You are appeal. Transfer of matrimonial suit.
My lord,
Oh, that-
matrimonial suit. My lord, on the earlier occasion, your lordship was pleased to direct the opposite party to file my lord, a short
Oh,
affidavit.
affidavit they wanted. Would you like to use a reply to this?
My lord, reply.
Learned counsel for the petitioner seeks to use a reply to the opposition filed today and kept on record. Full stop, next para. Accordingly, the time for filing reply is granted till
My lord, let there be a stay also, my lord, on 7th of the next date, my lord, before.
till July 29, 2025, when the matter shall next be listed on the listed for hearing.
I beg of your pardon, your lordship, on the second week, my lord, on 29th, my lord, I will leave station, my lord, because of my son's treatment, my lord.
When will you come back?
On the next circuit, my lord.
Very well. তাহলে reply is extended for a week from date. ওই যেটা till 29 বললাম, for a week from date, full stop. The matter shall be listed for hearing in the next circuit before the appropriate bench upon being mentioned by the parties. Full stop. Next para, there shall be stay of all further proceedings in matrimonial suit number 333 of 2024 pending before the learned district judge at Jalpaiguri till September 15, 2025 or until further order, whichever is earlier. Mr. Mishra, whoever is appearing with, yes. Yes, Mr. Ramahasha, are you ready today? Yes.
Yeah.
What is the matter, Mr. Datta? Take your seat, Mr. Ramahasha. Yes, Mr. Datta.
Rejection of the order.
Acha.
Actually, the plaintiff has instance put for partition.
Right. Why 711?
The suit for partition, they never, they denied the co-chairship of the.
Let us see that paragraph.
Page number 67.
17, yes.
That the from para 2, the co-chairship they are. That except the appropriate recorded table, there are no other co-sharers.
But in para 11, they say otherwise. So they are
They define how the plaintiffs and defendant number 1 to 5, defendant number 1 to 5 are the co-sharers. Are the co-sharer and how the matter, the land reform. We are the defendants number 7 to 7 to 8.
so not bar of law, no cause of action disclosed against you. 7 to 18. Any averment in your respect?
But not for some para 14, they say. Then the defendant number 6 to 17 came over this land and.
They say you are claiming to be co-sharers. So that will be decided in the suit. Why 711 stage? Whether you are co-sharers or not. Not 711 case. Sorry. No, cause of action is this. You are claiming to be co-sharers. They say you are not co-sharers, but since you are claiming to be co-sharers, you have been implicated. This question has to be decided. Another suit cannot be filed against you for this. You say you are not co-sharers, we'll record that and say. Learned counsel for the petitioner. Now, the present revision has been preferred against an order whereby the application filed by the uh, present petitioners, comma, who were co-defendants in the suit, comma, কি সেন্টেন্স বললাম মিস করে গেলাম, has been filed against
My lord, one judgment I have made.
judgment ছোট
One judgment of your lordship.
yes, what did I say? No, there it was claimed that these defendants have title in respect of a portion of the suit property.
They are same.
So unless you are co-defendants, co-owners in respect of the entire suit property, then there cannot be a partition.
Point for that. Two things are very.
Where is that paragraph?
Firstly,
Oh, no cause of action.
there are two. That's what further action I have to depend on what.
No, but in para 11 of the present plaint, they have claimed that you are co-owners. In your present suit, they have claimed that you are co-owners.
Page 2 of the. As for further action, even the dependent number, it is argued on behalf of the plaintiff is that since the dependent has claimed to have time.
Achha. Yes, but there they are categorically stated that you are not co-owners. Not co-owners, but in this case, in the present case, if you come to paragraph number 11 of the plaint, they say that plaintiffs and defendants are co-sharers.
That is
14 no, 14 no.
that is the plaintiff and defendants, although they are stating, but they had in.
So if there's a contradictory statement in the plaint, but plaint in the other case, cited case, in the reported case, unreported case rather, they had not averred anywhere that they were co-sharers. Here they have averred somewhere. There may be some discrepancy.
Plaintiff and defendant number 5 are the co-sharers of the suit plot and Sotian, and as such, the suit plot and Sotian haven't been partitioned by basement man among the.
No, I'll distinguish. কোথায় ছাড়লাম, just last wordটা বলো। Comma, reject, sorry, বলো। The present revisional application has been filed. আচ্ছা, যেখানে ছাড়লাম, for now, under order 7 rule 11 of the Code of Civil Procedure, comma, for rejection of the plaint, comma, was turned down. Push up. The learned counsel for the petitioners argues that in the plaint of the partition suit from which the revision arises, comma, the plaintiff stroke opposite parties claimed that the plaintiffs were facing inconvenience in peaceful enjoyment of his share with the defendant numbers 1 to 5, and that the defendant numbers 1 to 5 are co-sharers of the suit plot. Full stop. As such, comma, no cause of action is disclosed in the plaint for filing the partition suit insofar as the defendant numbers 6 to 17, comma, including the present petitioners, comma, is concerned. Full stop. Next para. Learned counsel cites an unreported judgment of this court dated August 28, 2019 in CO number 57 of 2019, where the court had held that merely because it is claimed in the merely because it is pleaded in the plaint that some of the defendants claimed to have title in respect of a portion of the suit property, comma, although their title to the property was not admitted by the plaintiffs, comma, no cause of action was disclosed against the said defendants. Full stop. As such, comma, it was held that the arraignment, ARRAIGNMENT, of the said defendants, comma, against whom no cause of action was disclosed, comma, could not have been impleaded. Accordingly, the plaint of the said suit was rejected by this court. Full stop. Next para. Learned counsel appearing for the opposite parties opposes the contention of the petitioners and points out that in paragraph 14 of the plaint, cause of action has been disclosed against the present defendants. Full stop. Next para. A perusal of the plaint shows that in paragraph number 1 of the plaint, certain persons are mentioned to be the recorded tenants in respect of the suit property, which have in paragraph number 2 thereof, it is further stated that except the said recorded tenants, there are no other co-sharers of the suit plots. Full stop. However, in paragraph number, however, again, in paragraph number 9 of the plaint, it has been stated that the plaintiff and defendant numbers 1 to 5 are the co-sharers of the suit plot and Khotian, and such suit plot and Khotian have not been partitioned by meets and bounds amongst the co-sharers. Full stop. Next para. However, in paragraph number 11 of the plaint, it has been stated that as the plaintiff and the defendants, double inverted with the defendants, are co-sharers, so they are possessing the respective shares jointly by way of amicable settlement. So next para, again, in paragraph number 14, it has been stated that the defendant numbers 6 to 17 came over the suit land and are claiming to be the co-sharers of the suit land by way of purchase from predecessor of the plaintiffs, and on such claim the plaintiffs have demanded from them to show any such documents in support of such claim, which allegedly the defendants have failed to show. Full stop. Next para. In paragraph number 15 of the plaint, again, it has been alleged that the defendant numbers 6 to 17 in collusion with the defendant numbers 1 to 5 are trying to disturb the peaceful share of the plaintiffs and also trying to change the nature and character of the property, suit property. Full stop. Next para. As opposed to the cited judgment, in the present case, a semblance of pleadings are present in the plaint to indicate that all the defendants are co-sharers in respect of the property. Full stop. Although there is some contradiction in the plaint pleadings, inasmuch as in paragraph number 2 and 9, it has been claimed that the plaintiff and the defendant numbers 1 to 5 are the co-sharers, whereas in paragraph number 11, the plaintiff and all the defendants have been claimed to be so, such contradiction can be canvassed at the time of hearing of the suit upon a judgment on trial. Full stop. Next para. The statement in paragraph 14 of the plaint, to the extent that the defendant number 6 to 17 are claiming to be co-sharers of the property, suit property by purchase, has to be read in conjunction with paragraphs 9 as well as 11 of the plaint. Full stop. As such, there is as such, it cannot be said outright, merely because there is a contradiction in the claims, that no cause of action whatsoever has been disclosed against the defendant number 6 to 17. Full stop. Next para. Thus, it would be premature at this stage for the court to reject the plaint by holding that no cause of action has been disclosed against the defendant number 6 to 17. Full stop. In such view of the matter, there is no scope of interference with the impugned order, whereby the application filed by the present petitioners under Order 7 Rule 11 of the Code was rejected. Full stop. Accordingly, CO numbers 42 of 25 is disposed of without interfering with the impugned order, but keeping it open for the parties to argue as to whether the defendant number 6 to 17 are co-sharers of the suit property or not. Full stop. It is further made clear that nothing in the order shall prevent the defendant number 6 to 17 to point out the perceived contradiction in the plaint pleadings in that regard at the time of trial. No orders to pass. Yes.
In their WS, they actually admitted quotients.
711. Orders.
Now, in the trial.
Order 7 rule 11 can be heard only on the plaint.
On Lordship, and Lordship, yes.
That's why you have kept it open for him. Since the suit is pending since 2019, it is expected that the hearing that the same shall be disposed of at the earliest, preferably within 1 year from the date of communication of this order to the learned trial judge. Thank you. It over. Yes, 4. Yes. This is appearing for the first time. You are for the caveat?
Yes, sir. The cable going on.
That's for only opposite party 4 lodged a caveat.
Only 4 is consisting.
In the trial code also. Well, yes. What is the matter, please?
Have been filed by the appellant number 1, petitioner number 1, on behalf of the rest of the petitioners as the power of attorney. Before that, by virtue of that power of attorney, this the suit property has been dealt otherwise. And being the power of attorney holder, he filed the suit. On the very first day of suit, one injunction, ex parte injunction order was passed, page number 68.
Yes.
As a way of status. Thereafter, respondent number 4 appeared before the court and filed the written objection and written statement therein. Lordship. Please come to the page number 74 of the 74, that is the written objection and filed by the written objection and filed by the respondent number 4 to the court. First time, this was given to the knowledge regarding that the share of the power of attorney of the petitioner number 3 that has been revoked by virtue of one registered.
Share of power of attorney?
Share of
Oh, only na plaintiff number 3.
this power.
Very well. Very well.
Power of attorney on first time before the trial. Thereafter, Lordship, the injunction application was heard. The order has an 600. Page number 100.
এই অনিদিত এসিটা একটু আস্তে করে দিতে গরম করে দিচ্ছে
This is the contested order of the injunction application.
Yes.
Page number 100.
First tell us what has been done by the impugned order, then we'll come to that.
Submission of the material back by itself is sufficient ground to declare the disposition of the injunction accordingly. Decision has to approve the court with the clean hand and that without clean hand. This is the findings of the court without clean hand.
And due to this cancellation of that power of attorney by plaintiff number 3.
Filed by the plaintiff for the court below without dealing anything. That the injunction order has been passed only the ground that he didn't come before the court without clean.
39 and 2 rejected.
Yes. 103. This communication thereafter again the denied power of attorney has been done and it has been registered before the
This general power of attorney by the that
number 3. And it is very much written in the power of attorney document. Page number 106, para number 2. Whereas although I had revoked the same general power of attorney being instrument number such and such in respect of my share of land by virtue of registered deed of revocation of general power of attorney being instrument number such and such part, I did not inform the said event of revocation in any manner to my said younger brother. That is the power of attorney. Thereafter, Lordship, due to these changed circumstances and the further development, this petitioners they filed one application.
No, I did not inform the event of revocation. That does not mean he did not proceed with the revocation. He gives another, this power of attorney is on this understanding. Then he gives a fresh power of attorney.
In respect to each
Well, you filed, you did what?
file, 151 of this is the page number 120 lot. In this application, the subsequent event is prayed that that should be considered, and with the allegation that after vacating the exporting injunction order, this particular defendant number 4, he started to construct in and over the property. There is looking opportunity to construct in and over the property, and prayed before the court, to pass the necessary order directing the defendant number 4 not to change the nature and character of the property. Thereafter, the informed order has been passed.
Yes.
Only the ground has stated therein that this is the case for the recovery of the land.
So virtually you wanted a fresh injunction, but in that form you are seeking a recall of that order of vacating.
For the subsequent event,
If it's a fresh cause of action, then it's
the subsequent event, which was beyond my knowledge, that has been incorporated subsequently. When it was came to my knowledge, and in respect of the subsequent,
you cannot run a contradictory case. Either you say that the general power of attorney was never revoked because this person has executed a general revocation document but did not forward it and has given you a fresh power of attorney, and you say that therefore that recall, that vacating was bad and seek a recall of the 39(4) order. Either you do that or you say it's a fresh injunction application. What is the subsequent cause of action? The cause of action is the same as the previous injunction application. So you should have asked for a recall of that 39(4) application. You sought for a new, why has it been dismissed now? On a fresh consideration. If this section 151 is treated as a, yes. Second para?
power to disturb, vary, or aside the given situation to call for, the suit has been filed challenging numerous registered sale deed. There is a presumption of correctness in respect of the same. The plaintiffs have also prayed for recovery of possession and mandatory injunction since admittedly the defendant are in possession of the suit property. The balance of convenience and inconvenience is in favor of the defendant at this stage, and any other injunction may be irreparable loss and injury. Construction of multi-story building. There is no question of the multi-story building. This is the only allegation of the plaintiff that after vacating the injunction order, defendant number 4, he started to.
You have prayed for recovery of possession. You are admitting that they're in possession, but you are asking the court to restrain them from. Right now, you are. Let us complete. You have just asked for restraining him from changing the nature and character of the property. That was the original injunction granted also in this case, in this. Well, let us hear them. Yes, what is your stand in the matter?
My lord, specifically the case has been filed with the plaintiff. In 2002, he executed a sale deed in favor of defendant 1, 2, and 3 on, my lord. 1, 2, and 3 are my vendors. He is challenging the deed which I purchased from defendant 1, 2, and 3 in 2024, Your Honor, my lord.
Yes.
His deed, admittedly, he executed a deed, sale deed, in favor of defendant 1, 2, and 3. His contention for disputing the sale deed is that he has not been paid the amount of consideration. Admittedly, he admits the fact, my lord, that in the sale deed, the amount of consideration which has been mentioned has been issued by him, but he is under this presumption that he should be entitled to a greater amount of consideration, my lord. And the deed which is challenging, actually in the pleadings, if a meaningful reading of the plaint is given, my lord, he is actually he has to challenge the deed of 2002.
Now see, one aspect is there. This is not the first occasion when the trial court is dealing with an injunction application in this suit. Previously, injunction was granted. And
Expert
that
injunction, my lord.
expert injunction, but that injunction was never challenged in an appeal. Or that injunction application, that temporary injunction application is still pending. That has been dismissed now.
No, my lord.
Previously, that has been dismissed on the ground that there was suppression of fact.
My lord, there were a number of grounds, my lord. All the grounds were taken into. 3 hours hearing was done, my lord. The order is 3 pages, my lord. If my order reads the entire order properly, I'll go to the fact, my lord. If the entire order is read down properly, my lord, the court also went into the issue that is challenging the deed of 2002. He has no cause of action. Even today, I filed an application on last date. I filed an application order 7 to 11, my lord, because there is no cause of action. He needs to challenge the deed of 2002. And
Let us see the previous injunction order once again.
Contested hearing, my lord, page 100.
Page 100.
Page 100. So read it out, my lord.
Let us see the considerations
The
of the
constitutional
court.
part, my lord. Yes, yes, my lord.
Page 101.
Page 101.
Yes. On the other hand, such and say.
The learned advocate for defendant number 4.
But if you come to the last part of that, up to penultimate paragraph, it's learned advocate for such and such submits, and it's a narration of the arguments. The last paragraph of page 101 is the reasoning of the court. From
My
top-
lord, my
that
lord,
is the only ground on which suppression of fact 39(4) was allowed and the injunction was dismissed.
my lord, may 101 third paragraph, my lord, may go into once.
Yes,
Learned advocate for defendant number 4 submitted.
that's an argument. That's an argument.
My lord, he submits that
Whatever
plaintiff-
was submitted up to the penultimate paragraph, it's the court is recording the arguments of the party.
and my lord may see the judgments which have been cited, my lord. Schedule Singh is basically on this point.
Maybe.
That
Maybe, but that was not the ground. The only ground given by the court is at the last paragraph of page, internal page 2, page 101. After narrating before that, the previous paragraph, up to that narration of the arguments. Last paragraph, from documents filed by the defendant number 4, it is primarily clear that he has revoked his power of attorney, and so the entire order was vacated
and my lord,
and consequently. But then, on merits, there was a finding previously, it had granted identity model, although identity model is not binding at the final stage. Right. But this temporary injunction application was dismissed only on the ground of power of attorney. And now he has produced something to show that the cancellation was itself in doubt.
my lord,
Why shouldn't that be revisited?
I'm on the point, my lord. When a power of attorney is executed, my lord, in favor of an agent, it is a fiduciary relation between the agent and the principal.
True.
When a significant step is taken, like filing of a case, my lord, the principal is supposed to inform, the agent is supposed to inform the principal.
But there's a subsequent part of attorney where he says that I did not communicate and I grant power of attorney. He ratified his previous power of attorney.
It's obligation to know from the agent.
Might have been, but that is the only ground. Now the fresh power of
The power of attorney of 2002, my lord. The power of attorney,
a fresh power of attorney has now been granted.
but it's already 22 years back, the power of attorney was granted, my lord. And the main part is, my lord, all the caveats which I filed against the plaintiff,
The
my
court
lord.
at least ought to have been revisited its previous order. I mean, by virtue of this, court had previously held at interim stage that there is prima facie case and granted injunction on that premise. That was vacated and the injunction was, application was dismissed only on the ground of suppression.
My lord, may then read the second line. It appears from the record that after the registration of the alleged cell deed, the defendant number 4 mutilated the name in the print LRR. However, considering the whole aspect, the balance of convenience and inconvenience does not lie in favor of the plaintiff, my lord. The main primary issue of the plaintiff is that in 2002 he executed the sale deed, my lord. He's not challenging those deeds. And as per the law, it is established, my lord, if the deed is executed by me, then I need to challenge those deeds.
But this premise is also wrong because he says, the court says here in the previous order of temporary injunction rejection and in the present impugned order also, the premise is that they have admitted that you are in possession and therefore you cannot be restrained. But the injunction sought is not restraining you from disturbing his possession. It's a natural corollary, it's aid in aid of the final relief because he says he seeks title and he also says that you are in possession, he admits, asks for recovery of possession.
My lord.
Now he has asked that so that the nature and character is not changed.
But my lord, the primary issue is one that the sale deed has been executed by him.
But the premise of the impugned order is wrong. The court says, sir, that admittedly defendants are in possession of the property, therefore balance of convenience and such thing. You are in possession, he is not disputing. But all the more a reason, that is all the more a reason for court to grant injunction so that you cannot change the nature and character.
But my
They
lord,
were frustrating the outcomes.
but my lord, with the sale deed has been executed by the plaintiff himself. Without challenging the deed, how can he claim title, my lord? And
That
the-
will be decided in the suit. But on that premise, identity was granted. How can he reopen that? He reopened only on the ground, he recalled that order only on the ground of suppression. That is what is found at page 102. Only on the ground of suppression.
my lord, under
Now that suppression ground goes because this subsequent power of attorney shows that he revoked, but he did not communicate the revocation. There was no revocation in the eye of law.
I'm on the issue of my lord on a bigger issue, my lord. The suit which has been
Bigger
filed-
issue cannot be reopened after having court having granted that in order previously. That order was never challenged. That still remains. unless this suppression.
But my
cap-
lord, it was a contested hearing.
We'll do this. I'll do this. I'll just set aside this order. I'll ask the court, I'll recall that order whereby the final injunction order was finally dismissed on the ground of suppression. Because suppression was the only ground. And I'll direct a fresh hearing, fresh adjudication of the temporary injunction application. Let him complete. He has not completed. We are in the midst of argument. Yes. That is what I am proposing. Because here, the only ground on which temporary injunction was, ad interim was vacated, and temporary injunction could not have been disposed of like this. I mean,
Going to the merits of the case, basically, prima facie case.
39(4) could have been allowed by virtue of that. And the injunction could have been heard on merits otherwise. That was not done. And now he has got a power of attorney which says, which casts a doubt on the previous power of attorney. Revocation, sorry, on the revocation. So therefore, if the revocation goes, then court should revert back to the stage of where the ad interim order was pending.
And here the application on
Here
contest.
the temporary injunction application on contest. Decide it on contest. But that ad interim order should be restored for a limited period. I'll direct written objection and everything was exchanged complete in the injunction. I'll request the trial judge to do it within 4 weeks to decide the injunction application afresh. Till the disposal of the temporary injunction, I'll grant, I'll revive the status quo order. Goes against you, not gullible, but that is the order I propose.
But my lord, the order fails to highlight all the issues before the court.
You just see, your Mr. I'm sorry, your surname,
Yeah.
Mr. Kanodia, here if you see the impugned order also, the court has proceeded on a premise that he has admitted that you are in possession, therefore he is not entitled to grant of injunction, but his injunction is not regarding possession. His injunction is regarding creation of third-party interest or changing nature character.
The last order, my lord, 151 application is order.
Yes.
But my lord, that in that application, the entire order has to be read in properly, my lord.
Let us see that.
Then let's see that.
And any order of injunction may cause irreparable injury as construction of a multi-storied building entails huge expenditure without any finding as to whether, have you started construction even? There was ad interim order previously. How could have started?
My lord, my construction is going on for the last 1.5 years, my lord, prior to the suit.
Yes, but by the ad interim order that was stopped.
Yeah, that is, this order was there, my lord.
That was
In the
stopped.
meantime, in the pending period, it was stopped, my lord. My 39
In your written objection, have you stated that what is the stage of that construction?
My lord, yes, I've said that. My building plan has been submitted, my lord. I've
So
converted.
very well, we'll not decide. We cannot decide the temporary injunction. All these factors will be considered at the temporary injunction stage. But this application under
My lord,
151.
come to paper 2, my lord. The
Yes.
suit has been filed challenging numerous registered sale deeds.
Yes.
There is a presumption of correctness in respect of the same. The plaintiffs have also prayed for recovery of possession and mandatory injunction. Since admittedly the plaintiffs are in possession of the suit property, the balance of convenience and inconvenience is tilted in favor of the defendants at this stage. And any order.
This is where we are trying
This
to
is where
join.
I'm also coming into, my lord. This is where I'm coming into. That he says the order speaks about a sale deed, registered sale deed.
True, but the court says, since admittedly the defendants are in possession, you are in possession of the suit property, balance of convenience and inconvenience is tilted in favor of the defendants.
My lord, you missed
Now-
the line, my lord. Missed a bit, my lord. At the time of
This is an absolutely, perverse way of approaching it. Because you are in possession, therefore balance of convenience and inconvenience, you must understand. Before coming to the court, you know. The balance of convenience has to be on the basis of the prayer made for injunction.
prior to that, my lord.
Yes.
Prior to that, my lord.
Yes.
And just prior to that, this line has not been elaborated in the order sheet, my lord.
Uh-huh.
But the suit has been filed challenging numerous registered sale deeds, my lord. This was the point of argument, my lord. He challenges his own sale deeds, my lord, which is on the ground of fraud. On the basis that actual consideration which he was supposed to get, my lord, that is not be paid to him. That is the reason why he's challenging he's claiming title to property, my lord.
This,
is a matter of fraud
did you
and-
file any written objection to this 151?
Yes, I gave him objection, my lord.
To this 151 also you had filed a written
Yes,
objection?
I have an objection, my lord. May I come to a point, my lord. This is the point which has not been elaborated by the court, my lord. He challenges his own registered sale deed on the basis of fraud, my lord. Fraud is a matter of trial. And the deed which was executed by him is executed on 2, my lord. Executed by himself.
But till then, if you change the nature and character, then nothing will remain in the suit even if he wins the suit.
My lord, how can he, in 2002, the deed was executed, my lord. He knows, he has the knowledge that CS limitation is there, my lord. In a sale deed which is executed by the
Court does not discuss that at all, only says presumption of correctness.
which is argued into, my lord. The order, while passing, I might not be prejudiced, my lord. At the time of argument, all these points are raised, my lord. The judgments were given on the point that that is a sale deed is executed by the plaintiff himself. Then he's supposed to challenge it within 3 years.
We'll go by this order, whatever is the reason in this order only. We cannot read into the mind of the judge.
My lord, while writing the order, my lord, that points should not be written down. I shouldn't be judged, my lord. My construction should not be stopped, my lord.
No, order has to reflect the reasons. The reflected order reasons reflected here.
My lord, the trial court is.
We can do this.
So it's possible, my lord, that while writing the order sheet, some elaborate point might not have been written, my lord. But this was argued into.
Reasons ought to be clear from the judgment.
My
The
lord,
reason is that their
I'm getting affected.
registered sale deed, their case in the plaint has not been considered.
But may I submit, my lord? May I submit, my lord? It is established principle of law, my lord. Your sale deed is executed. It needs to be challenged within 3 years, my lord. On the ground of fraud or whatever it be, my lord. It is established law, my lord. In 2002, sale deed has been executed by him. He doesn't seek the cancellation of 2002 sale deed, my lord. He seeks the cancellation of the sale deed. The person whom he has sold and the person has sold.
None of this is reflected in the order, sir. It is your argument. I am not the injunction court.
Then read my application, written objection, my lord.
It is not there in the order. The reasons are not correct. These are not correct reasons. On these reasons, it cannot be done. It's in a very cryptic fashion.
My lord, the orders look concise in the form, my lord. But actually, what was argued on was on the point that whether that sale deed, because of which my lord, order 711 application has been filed, my lord. On 25th of August, we were hearing on the 711 application, my lord, whether suit is maintainable or not. And today, if I get an order status quo, my lord, where is my position, my lord? I've argued all the cases properly.
Nothing, because your temporary injunction will be decided finally at the after giving a fresh hearing to both of you.
But my lord, the status could not be granted, my lord.
Status quo was there when the injunction was there. It was vacated only on the ground of this power of attorney revocation.
My lord, 2 years have passed. 1.5 years have passed, my lord. After vacation,
Now 4 weeks will pass.
after 1.5 years, my lord. I will give you prejudice, my lord.
No, sorry.
But established principle of laws are there, my lord. The deeds cannot be challenged after 3 years, my lord. What is the explanation from the plaintiff on that part, my lord? Actually, this
We'll reopen at the injunction application. Go and argue in the injunction application. This is not a reasoned order. Learned counsel for the petitioner, revisionist petitioner submits that the revisionist petitioner has filed a suit for declaration of title, challenging certain sale deeds allegedly executed in favor of the defendants, and also sought recovery of possession and permanent injunction and mandatory injunction in respect of the suit property. Initially an ad interim order of injunction was granted. Subsequently, however, the same was sought to be vacated by the defendant stroke opposite party number 4 by filing an application under Order 39, Rule 4 of the Code of Civil Procedure on the ground that the ad interim order was obtained by suppression of the material fact that one of the plaintiffs, plaintiff number 3 to be precise, had revoked the general power of attorney granted to the person who filed the suit, which vitiates the ad interim order and the maintainability of the suit. The learned trial judge, by a subsequent order dated March 28, 2023, accordingly vacated the ad interim order and simultaneously disposed of the temporary injunction as well by rejecting the same. Subsequently, the present plaintiff stroke petitioners furnished a further general power of attorney executed by the same plaintiff number 3, where it was mentioned categorically that although he had previously revoked the general power of attorney on the basis of which the suit had been filed.
The line as the plaintiffs have to prove their case for trial as regards the invalidity of
But
the sale deed.
Had not informed the said event of revocation in any manner to his younger brother. It was reiterated therein that a general power of attorney was being given afresh to the person who filed the suit, for conducting the suit on behalf of the plaintiff number 3 as well. On the premise of the same, pleading change of circumstances, an application, caption to be one under section 151 of the Code of Civil Procedure was filed, thereby seeking a similar injunction as in the earlier temporary injunction application. The same was rejected by the learned trial judge by the impugned order against which the present revision has been preferred. It is contended by the petitioners that the learned trial judge failed to take into consideration that the previous vacating of the ad interim injunction was on the sole ground of revocation of power of attorney by one of the plaintiffs, which ground is no longer valid and now academic in view of the execution of the fresh power of attorney. Full stop. Next para. Learned counsel appearing for the respondent defendant opposite party number 4, comma, which is the primary contesting opposite party, comma, submits that the learned trial judge considered the written objection of the said defendant stroke opposite party at length, and upon passing a reasoned order, comma, has refused to grant injunction. Push up, it is submitted that the suit is not maintainable in the sense that the original transfer deed has not been challenged. Push up, moreover, comma, since the trial court recorded in the impugned order the existence of numerous registered sale deeds in favor of the defendants, comma, sufficient ground was furnished by the learned trial judge in rejecting the application for injunction. Full stop. Next para. As such, comma, it is submitted that the defendants would suffer irreparably if injunction is granted. Full stop. Next para. The circumstances of the case are peculiar. Full stop. At the first instance, comma, the learned trial judge had been pleased to grant an ad interim injunction, although at the ex parte stage, comma, being prima facie satisfied of the case made out in the plaint. Full stop. Subsequently, comma, however, comma, at the time of dealing with an application under Order 39 Rule 4 of the court, comma, the trial court disposed of the temporary injunction application itself, comma, instead of restricting itself to vacate the ad interim order, comma, without considering on merits the respective arguments of the parties, comma, as reflected from the order dated March 28, 2023. Push up, although learned counsel for the opposite party number 4 argues that the entire arguments of the parties were narrated there, comma, I find from the said order that although the arguments of the parties had been narrated at length, comma, the reasoning of the learned trial judge for vacating the order and dismissing the temporary injunction application was restricted to the ground taken in the application under Order 39 Rule 4, and the order dismissing the temporary injunction was passed only on the ground of suppression, inasmuch as the plaintiff number 3 had revoked his general power of attorney. Full stop. Thus, comma, when the subsequent application under section 151, comma, on the strength of the fresh power of attorney was filed, comma, it was the incumbent duty of the learned trial judge to reconsider its order dated March 28, 2023, and or to consider the prayer for injunction afresh. Full stop. Next para. Since the earlier order of rejection, dismissal of temporary injunction application dated March 28, 2023 was premised wholly on the alleged suppression due to revocation of power of attorney, comma, which has now been mitigated in view of the action of the plaintiffs being ratified by the plaintiff number 3 himself by executing a fresh power of attorney, comma, the learned trial judge ought to have decided the temporary injunction application afresh. Full stop. Next para. Also, comma, this court finds from the impugned order that there is no detailed discussion for refusal of the prayer for injunction. Full stop. Next para. The learned trial judge records in the impugned order that the suit has been filed challenging numerous registered sale deeds which carry a presumption of correctness, comma, without going into the details of the arguments of either side on the said issue, or or rendering its own findings on the versions of both the parties. Push up. I do not find the arguments of the parties or the materials on record being reflected in the present impugned order at all. Full stop. It is an admitted position that there are numerous registered sale deeds which, comma, in law, comma, might carry a presumption of correctness. Full stop. However, comma, the present suit has been filed specifically to challenge the correctness of the same by the plaintiffs seeking to rebut the presumption so raised of correctness. Full stop. The learned trial judge, comma, accordingly had the incumbent duty to address on merits the arguments of both sides and the materials on record before deciding the injunction prayer. Finally, full stop. The other ground cited in the impugned order dated May 23, 2025, comma, to the effect that admittedly the defendants are in possession, comma, cannot have any bearing on the question of prima facie case and balance of convenience, inasmuch as the prayer for injunction of the plaintiffs is not in respect of possession of the property, but with regard to change of nature and character, which of the suit property, comma, which might denude the suit of any efficacy in the event the nature and character of the property is altered before the final hearing of the suit. Full stop. Thus, comma, the trial court ought to have tested the case of temporary injunction sought by the plaintiffs on the anvil of the legal yardsticks of prima facie case, comma, balance of convenience and inconvenience, as well as irreparable injury, upon giving adequate consideration to the arguments and materials of produced by both the parties. Full stop. Having not done so, comma, the impugned order is vitiated by jurisdictional error. Accordingly, CO number
101.
Thank you. 101 of 2025 is allowed on contest as against the opposite party number 4 and ex party against the others, comma, thereby setting aside the impugned order dated order bearing order number 24 dated May 23, 2025, passed by the learned civil judge junior division at Jalpaiguri in title suit number 490 of 2022 and directing the learned trial judge to re-adjudicate the application under section 151 of the Code of Civil Procedure by treating the same to be a revival of the original temporary injunction application filed by the plaintiffs, comma, in the light of the observations made above. Full stop. It is made clear that while doing so, comma, the learned trial judge shall not be prejudiced in any manner by the observations made in the order dated March 28, 2023 and adjudicate the application under section 151 of the plaintiff stroke petitioners as a fresh injunction application on its own merits independently of the observations made in the present order or the order dated March 28, 2023 passed in the suit. Full stop. While doing so, comma, the learned trial judge shall take into consideration the respective arguments of both sides and their pleadings in the injunction in the application for injunction as well as the written objection. Full stop. The learned trial judge shall also advert to all the relevant materials on record while coming to its conclusions. Full stop. Next para. In view of the urgency involved, comma, it is expected that the learned trial judge shall proceed to dispose of the application under section 151 of the code by treating the same to be an application for temporary injunction at the earliest, comma, preferably within 4 weeks from the date of communication of this order to the learned trial judge. Full stop. There shall be status quo with regard to change of status quo with regard to the nature and character of the suit property till disposal of the temporary injunction application. Full stop. However, comma, it is made adequately clear that the above ad interim ad hoc order of injunction, ad hoc order of status quo shall not in any manner prejudice the adjudication of the application for injunction by the learned trial judge, and the observations made in the present order are restricted for the purpose of deciding the present injunction application and shall not be binding on the learned trial judge at any further stage of the proceedings. প্রথমে affidavit of choice 5 to be kept on record আর প্রথম লাইনে আরেকটা অ্যাড করে দাও, since the caveator stroke opposite party number 4 is the primary contesting party, comma, service of notice of the revision on the other opposite parties is dispensed.
My lord, application of 151 and 31 wanted to be jointly heard. I mean. Application
151, the previous temporary injunction I have not reopened. That will create complications. I have said this one.
Release and elaborate in 151 petition, my lord.
They will suffer. They will suffer.
And my reply is also not elaborated for that sense, my lord.
আচ্ছা আরেকটা লাইন অ্যাড করে দাও
Both the applications should be decided jointly, my lord.
No, it is made clear that both the parties will be at liberty, যেটা 4 weeks করেছে ওটা 6 weeks করে দাও both the parties will be at liberty to file supplementary affidavits to the application for injunction under section 151 of the Code of Civil Procedure as well as to the written objection thereto to furnish further particulars. Full stop. If so filed, comma, such affidavit shall be filed within 1 week from date in the trial court. Next. 5 years. Yes. Appearing for the first time? Right. What is the matter?
Remove the jurisdiction of the division eviction by filing one suit for eviction of the petition and other eviction. That suit has been finally disposed of and decreed in favor of the opposite party. Against the informed decree and judgment and decree, one appeal has been preferred. First appeal has been preferred before the competent.
No, on what ground? You are a trespasser? That
No.
suit?
Actually, I am
No, actually, whatever you are, what was the decree on the ground?
given the first.
No, the decree was passed treating you to be a trespasser must be, or what? Did you have any prior jurial relationship between before that agreement? Show us that decree first.
I am not challenging the decree order.
Acha, very well.
I
Preferred an appeal, yes, yes.
Stay order has been considered by the appellate authority,
Identity in prayer has not been considered.
not considered. And in the meantime, they filed the execution case and the executing court has started the proceeding.
We'll request the appellate court to decide the your identity in prayer for stay. When did you file this stay application? Just tell us what is the date of filing of that application. Give us the date.
December 2024.
Not heard so long. Why?
Actually, on the very first day, caveat was there. Thereafter, the notice has been served. Thereafter, the respondents didn't start.
The grievance of the petitioner is that an application for stay of an eviction decree which has been challenged in a title appeal filed by the petitioners have not been heard out till date, comma, despite the same having been filed on December 2, 2024 simultaneously with the appeal. Full stop. Next para. In view of the innocuous nature of the prayer, comma, prior service of notice of appeal of the revisional application on the opposite parties is dispensed with. CO 121 of 2025 is disposed of by requesting the learned additional district judge, first court at Siliguri, to dispose of the application for stay filed in connection with title appeal number 24 of 2024 at the earliest, comma, preferably within 3 weeks from the date of communication of this order to the said court. Full stop. For the purpose of compliance of this order, comma, the learned appellate court, first appellate court, as well as all concerned shall act on a server copy of this order without insisting upon prior production of a certified copy. Full stop. The learned advocate on record for the petitioners before this court shall serve a copy of the revisional application as well as a server copy of this order on the learned advocate appearing for the respondent opposite parties in the court below, if any. Full stop. Alternatively, the said copy, server copy of this order along with the revisional application shall be served on the opposite parties directly within a week from date. Disposed of. Serve a copy of this application and serve a copy on the other side within a week. And whenever you communicate within 3 weeks from that, this stay application will be disposed of. Thank you. 6, yes.
Please, my lords, I beg to appear, my lords, for the revision petitioner.
Yes, what is the matter, please?
My lords, this is coming up for the first time, my lords. We are challenging an order by which, my lords, the learned trial judge has allowed an Order 1 Rule 10 application and deleted 2 respondents. My lords, a very short issue. My lords, I filed a suit for specific performance. Defendant 1 to 4 are original parties to the agreement. Defendant 5 and 6 were subsequent purchasers. My lords, during the pendency of the suit, defendant 5 and 6 sold it to certain other third parties. So I filed for amendment to bring that fact on record, and my lord, simultaneously they filed an application for their deletion. Your lordship will see page 19, which is the impugned order. What the trial judge does, my lords, is allows my application for amendment and at the same time allows their application and deletes them because they have sold the property. My lords, it's a short one-page order, my lords. If your lordship
Mr.
sees
Mithuka,
the-
how are you affected? Actually, now they are not parties. 5 and 6 are no longer owners of the property. Some third party, he have included them.
My lords, because in my original plaint, I asked for a relief for cancellation of that deed. And my lords, all the subsequent deeds will have to be cancelled, my lords, if my agreement has to be specifically performed. My lords, if not a necessary party, they are definitely a proper party, my lords.
Right. A prima facie case for hearing of the revisional application on merits have been made out. Push up. The petitioners filed a suit for specific performance of contract. Push up. Although originally the defendants took opposite party numbers 1 to, who are the original ones? 1 to 4.
1 to 4. And
1
5,
to
6
4.
is subsequent, my
Right.
lords.
1 to 4 were the owners stroke parties to the agreement sought to be specifically enforced, comma. Subsequently, the property was transferred to defendant stroke opposite party numbers 5 and 6. Full stop. The opposite party numbers 5 and 6, comma, in turn, comma, transferred the property in favor of third parties. Push up the petitioners, comma, upon coming to know of such transfer, comma, sought for amendment of the plaint to implead the last subsequent transferees. Push up next para, however, comma, by the impugned order, comma, and that learned trial judge has allowed the learned trial judge, comma, while allowing the amendment application of the petitioners, comma, deleted the names of the opposite party numbers 5 and 6 by allowing an application under Order 1 Rule 10 within bracket 2 of the Code of Civil Procedure filed by the said opposite parties on the ground that they were no longer necessary parties since they have already transferred the property in favor of third parties. So next para, the arguable questions which arise are as to whether the defendants took opposite party numbers 5 and 6, comma, despite having transferred the property, still remain at least proper parties to the suit, comma, since as a corollary of a specific performance decree, comma, if passed, comma, the transfer deeds in favor of the opposite party numbers 5 and 6 also has to be cancelled, comma, since the last subsequent transfer is claimed through the opposite party numbers 5 and 6. Which of the second question which arises is whether in view of the subsequent, whether the order, the component of the impugned order whereby the amendment application of the petitioners have been allowed is contradictory to the order deleting the names of the opposite party numbers 5 and 6, comma, since the very premise of the addition of the third parties are their having obtained the property by virtue of transfer from the opposite party numbers 5 and 6. Full stop. Thus, the limited challenge to the portion of the impugned order whereby the Order 1 Rule 10 2 application of the opposite party numbers 5 and 6 has been allowed is required to be considered. Full stop. Accordingly, the petitioners shall serve copies of the CO number 137 of 2025 to the opposite parties, indicating that the application shall next be listed for hearing before the appropriate bench of the next circuit, subject to being mentioned by the parties. Full stop. On the returnable date, comma, the petitioners shall file an affidavit of service to that effect. There shall be, Mr. Mithuka, I'll stay not only the operation of the impugned order, but I'll have
Please, my
to
lord.
also stay the suit. Otherwise, it will be allowing the revision before hearing them.
My
Because
lord,
if the suit proceeds, with them on record, then that is not proper. I'll give it for a limited period so that you have a handle to mention.
Milords, and may I request your lordship may permit me to serve the counsel, Milords, so that I can expedite this, Milords. Counsel on record before the trial
We'll
court.
put that somewhere.
Yes, Milords.
আচ্ছা তারপরে লিখো আরেকটা লাইন অ্যাড করে দিন it is made clear that such service may be effected by the petitioners directly on the opposite parties and or through their learned counsel appearing in the trial court. So next para, there shall be stay of operation of the impugned order dated May 13, 2025, as well as stay of all further proceedings of title suit number 146 of 2011 pending before the learned civil judge senior division at Jalpaiguri till September 15, 2025 or until further order, whichever is early. Thank you, sir.
Please, Milords. Obliged.
Next.
Milords, I'm sorry, the chat box is disabled, Milords. I'm not able to put my appearance. Milords, I thought I'll just notify your lordship.
You're appearing alone in the matter?
Yes, Milords. My junior Milords hasn't been able to reach. Ayush Mitrika, Milords.
এই মেঘনাথ আপনি ইয়েটা আয়ুষ মিত্রুকার নামটা আগেরটা পিটিশনার হয়ে AAYUSH মিত্রুকা MITRUK.
I'm grateful, Milords.
Thank
Deeply
you.
of that.
Good, Dakun. Yes, you are appearing. 7 to 15 board. 14.
Item number 7 to 14, I am on behalf of the petitioner bank.
No, my lord, first 4 is bank is the petitioner.
Right.
The last 4 Jute corporation is the petitioner.
Well, you are selling on the same boat or different boats?
Boat is same, but
On
the
the
color,
same board.
Color is different. Very
boat is same, but the color is different.
Yes.
Water level is also same.
Your color I know. What is their color? We don't know. We will soon find. Oh yes. Now we know. Yes. Who will start first?
If my lord takes up CO 127, I am holding
The
the
grounds
brief
of
order
challenge is same. Mr. Mujumdar. Mr. Gupta, should we hear you first or because Mr. Mujumdar is senior, we should hear him?
My lord, Mr.
Whatever you
Mujumdar
say.
may,
Because you-
Mr. Mujumdar may initiate, he is senior to me.
No, if Mr. Mujumdar is to start, we have to take from the next matter.
Last 4.
Last 4 are yours. Yes, Mr. Mujumdar, what is that? Anybody appearing for the other side, opposite party?
For the farmer. Mr. Srima Sarkar for farmer.
What is the matter about, Mr. Mujumdar?
The revisional application rises out of a consumer order. But let me take your lordship back to the root. Certain jute farmers stored their crop in a godown. And they gave a price to their jute. Subsequently, they walked up to the bank, represented by Mr. Gupta, and sought for a financial assistance, which was given. Then they approached Jute Corporation of India and says, please purchase our jute in this particular rate. Jute Corporation of India says, I can purchase jute on basis of the MSP, not beyond that. And on these 2 grounds, they laid a consumer complaint before the District Consumer Redressal Forum. And it was adjudicated, and ultimately the District Consumer Redressal Forum came to a finding that yes, they are consumers with respect to the bank and as well as this Jute Corporation of India, and allowed their complaint. Against that, an appeal was preferred before the state corporation. The state commission passed an order affirming the order of the district forum. It was carried up to National Commission. The National Commission, surprisingly, my lord, just printed out the District Consumer Forum's order and dismissed the appeal. In SLP, the Honorable Supreme Court said, basing on a particular judgment, that we are not the correct forum, you go to the jurisdictional High Court. There a mistake was committed by Jute Corporation of India. They approached the Honorable High Court of Delhi, who said, no, you go back to Calcutta High Court. In the integral, my lord, I should be pointing out to your lordship that one revisional application was preferred against the original order of the District Consumer Forum before the Honorable High Court at Calcutta. And that point, juncture of point, the Honorable High Court said that you have alternative remedy, you pursue that. This is the circumference of the case, my lord. Now, first question that crops up before us is, in what manner, in which way, under which provision of statute, either Jute Corporation or the bank becomes amenable to consumer forum?
Have you got the Consumer Disputes Act that act আছে উনি দিচ্ছেন?
Lordship, it is 2D.
Yes.
Consumer means any person who buys any goods for a consideration which has been paid or promised or partly paid or partly promised or under any system of deferred payment and includes any user of such goods other than the person who buys such goods for consideration paid or promised or partly paid or partly promised or under any system or deferred payment which such use is made with the approval of such person, but does not include a person who obtains such goods for resale or for any commercial purpose. So the complainants before the district forum did not buy anything from Jute Corporation of India. Rather, it was Jute Corporation of India who was supposed to buy. And bank may have certain grievances against them because of non-payment of even 1 single rupee of the loan.
So insofar as the Jute Corporation is concerned, it cannot be a consumer. That is your.
My submission is that, madam.
What was the finding of the forums below on this? You must have taken this point.
Yes, my lord.
How were you held to be consumers?
My lord,
I mean, how were they held to be consumers?
my lord,
Well, page number 63 is the order.
Mr. Gupta, your page number may not match with.
Yes,
Oh,
right.
I'm sorry, my lord. I'm sorry. I
Yes.
apologize.
Lordship, kindly takes CO number
Which one? Yes.
142 of 2024. My lord.
142 টা দিন তো।
Not supplied. These have not been supplied to us. This 141. That. No, I want to supply for it. Four I have.
You should have pointed out at the inception, then you would not have taken.
The same issue,
Then
because
yes,
it has very limited role to play.
you are the state.
Yes.
You have the only role to play. Let us see. We will embroil it.
Mr. Chaudhary says out of love to me. Very tangent love.
Love is not yet lost because although the colors of the boats are different.
Love will come.
But his vote is multicolored.
It's not multicolored. We will not comment on that. Mr. Mujado, which page? Please.
Lordship, kindly takes page 70 onwards.
Yes.
First, from page 71, the learned forum discusses the case.
This is the National Forum.
No, my lord, this is district.
Oh, you say that it's a copy paste. National Forum is a copy paste. Very well. Let us see.
No, my lord,
No, State Forum independently gave some views.
very short, my lord.
Let us start with the district. No difficulty.
My lord, in one certain places, my lord, kindly takes page 75.
Yes, 75.
Your lordship finds one Jute technology mission.
Found that, yes.
My lord, to assist jute growers by appropriate market support to enable them to get market price, but it is a matter of great regret and depressing to the poor cultivators, jute growers, that the JCIL have neither followed his vision and mission nor cared to maintain his object and service. Petitioners, after knowing the facts of their produce, became very depressed and trying to destroy themselves to get relief from the burden of bank loan, burden of go down rent, burden of other credit in the market. That finding no other alternative, the petitioner complaints at last have come before the learned forum to save them from unbearable and odd situation. It has further been asserted that the written objection filed with OP number 1 to 3 and OP number 5 speaks that they have always tried to hide the actual facts. It has been further stated that JCIL is the safeguard of the rate of jute of the farmers, but JCIL unethically stopped purchasing after 4/11/2010 without any information to the complainants and to the bank, that is OP number 5, and failed to maintain a constant dialogue with jute growers, state government of the jute growing states. Apex Cooperative acting as our agent, consumers, industries, financial institutions, and other their employees while framing policies and programs on raw jute procurement. No sooner had the JCIL stopped purchasing jute with the rate of rupees 3,800 to rupees 4,200 per quintal after 4/11/2010, then the market rate started falling. Report collected from the Assistant Agricultural Marketing Officer, Dinata District, Kuch Bihar, marked as G9. The OPs did not make any arrangement to purchase stored jute from the complainants, and as such, they are deficient in services. So if the Jute Corporation did not buy jute at the prompted rate by the farmers, it was a deficiency in service.
Ms. Sarkar, if you filed, you are for the farmers. If you filed a writ petition, it would be quicker and you have got the remedy against Mr. Mujumdar by now. Mr. Mujumdar and his client by now. No, but yes.
My lord, I candidly admit.
No,
that
the other
226
seems
would have been the proper remedy.
because all of us have sympathy on the grounds which have been stated. We have sympathy otherwise. Definitely, everybody, all of us have. But consumer forum, how is it amenable as far as the jute?
There are that.
Very well. So, any other point, Mr.
My lord,
Munir, let us.
points are there, my lord. Now, I will take your lordship straight away to the reasonings. Lordship, kindly takes page 78. That was very good. Lordship, page 78.
78, yes.
Point number 1. Whether complainants are consumers of the opposite parties. If so, whose consumer? From the discussions herein before, though the opposite parties in various ways have assailed the complainants are not directly consumers to all the opposite parties, but we find that they are invariably consumers of the opposite parties number 1, 5, and 6. According to section 21D2 of the Consumer Protection Act, and hence this point is decided in favor of the complainants. But when the forum is giving the reasons,
There
no
has been a change in the act. Now the sections are different.
I have a
Old act is necessary actually. But this is the new act. Eta ferat দিয়ে দিন. Because
So I
sections won't be tell. একটু old act এখানে কোথাও পাওয়া যাবে? Is it a spare copy? We can use it for the time being. Din. Old act. Yes, yes. D
ওটা ম্যানুয়ালটা দেখো ম্যানুয়ালটা
21D2.
এটা তো নতুন
না 86 ই দিয়েছে 86 ই দিয়েছে
না 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 ও বলছে পিছনে আছে
86 ই তো এটা
হ্যাঁ
In that book also? Very well.
I had read out from the old act.
Yes, we are following the old.
So my lord, the old act definition I have shown to your lordship.
D
There are several subclauses, my lord. Let us look at it.
yes, just
Hires or avails of any services for a consideration which has been paid or promised or partly paid and partly promised or under any system of deferred payment. So my lord, the rest portions remain same. First is buys any goods for a consideration. Hires or avails of any services for consideration. The rest portion are same, my lord.
avails of any services for consideration.
No matter only one service that was availed of was a loan was availed from the bank. And bank had paid the money. And the only money they paid was, I do not know whether actually it is paid or not, to the godown owner.
No, the grievance against you, Mr. Mujumdar, is that you have failed to ensure the rates.
No. I did not purchase jute from the jute farmers at the rate of rupees 3,800 to 4,200. When we were approached, my lord, we had in writing told them that our MSP at that relevant point of time was rupees 2,200 per quintal. Now, Jute Corporation of India being an Article 12 creature, my lord, cannot go beyond this policy, cannot go beyond the MSP rule.
No, what was the basis of their claim? They gave a specific rate. That was the current prevailing.
No, they based their claim on the previous, that was
Oh.
prevailing.
Achha.
And they themselves have in their various communications says after this particular date, the price of jute fell. Even we said that yes, at one point of time it was 3,800 to 4,200. But after that it fell. And there was one division. For commercial purpose it could have been, for other purpose it could have not.
But here also, we prima facie, subject to what Ms. Sarkar says, subsequently, we don't find anything that they hired or availed of any services from you also. Very good. So this is one aspect of the
My
matter.
lord. Then lordship kindly takes point number 3. Now, my lord, until and unless it is shown that the complainant is directed, when complainant becomes consumer under any of the opposite parties, consumer fora cannot attract jurisdiction.
No, that is your first point. We are hearing you on the other points also
Madam,
because we will take a comprehensive reply from Ms. Sarkar.
Now, if your lordship comes to point number 5 in the judgment of
Yes.
the district forum,
5.
the opposite party cited in the, my lord has found it.
Yes, yes.
The opposite parties cited in the complaint rendered deficiency in service by their acts, omissions, negligence, violated various acts, rules, regulations, provisions. From the discussions herein above, before, all of them have involved in such acts and omissions, but all are not liable for cognizable deficiency on the ground that OP number 2, 3, and 4 are the supervising authorities and not directly implementing authority of the vision, mission, etc.
What was your OP number?
I was one. My lord,
2, 3, 4 are your functionaries.
yes, they are my officers. So my officers are not liable, I am liable.
No, that may be held. The officers in their capacity as officers cannot be liable. Their grievances against you.
No, my
Here-
lord. I have, as such, Jute Corporation of India has not been implemented.
What? For the
District purchasing-
department purchase center.
Departmental Purchase Central in charge, DPC, but is wrongly said, Departmental Purchase Center.
Oh.
Yes, yeah. It belongs to GCI. So respondent number 1 and respondent number 2 and 3 are almost.
It's like implementing the loan division of a bank. Anyway, let us proceed.
No, I'm not-
Give the benefit to them.
No, my lord,
because they are
that
from.
technicality.
Understood.
If 2 and
understood.
3 is liable, then
No, I just
obviously
asked.
1 is liable.
All right. Yes.
Conversely, 1 is not liable, 2 and 3 cannot be liable.
All have to be on the same boat. Either
Same.
all are liable or none is liable. Very well.
Then, my lord, the forum, we can take a picture. My lord, reason of right. The supervising authorities are not directly implementing authority of the vision, mission, but to cause the same implemented and for which the regional manager and others have issued direction guidelines to the department purchase centers. And their involvement does not constitute liability as to compensate as such. Naturally, the complaints, farmers and or the pro forma OP number 6 and 7 have tried to benefit for themselves, not being consumers in the true sense of law. So if the petitioners are not consumers in the true sense of law, how could the district forum proceed further? But for the farmers whom they have backed from behind for every initial stage and is transparent from the record that the pro forma OP number 6, being an assistant teacher of high school, have been running the godown in association with NABARD and other associations besides. And this is the man, Lordship, who has been campaigning, taking forward all the claims of the farmers. The godown owner.
That's good of him, actually.
He's a noble man. Don Quickshot of the modern times.
No, Don Quixote.
The JCL and
These are the
bank-
persons for which the authorities are brought to task by the courts. These are the people.
My lord, what your lordship indicates, he is not a whistleblower. Rather, he is the whistle himself.
No, even then, it does not deserve sarcasm.
It is not sarcasm, it is blunt truth. Where did the Jute go, my lord?
Oh, acha, there are some. Anyway, we'll come to that.
From Godown.
Right. There, you may have something there.
And the bank in granting the bank loans as per welfare legislation also. The bank granting loans.
কি ঠান্ডাটা বাড়িয়ে দিলেন না কমিয়ে দিলেন 28 করে দিন তাহলে তার 28 না হলে 29 করবেন একটু পরে yes please continue bank loan
So, and the bank in granting bank loans as per previous welfare legislation of the government for the poor farmers as well as for themselves. From the conduct of OP, pro forma OP number 6 and 7, it appears that OP number 7 perhaps acted to assist the OP number 6 as the secretary of Jalpaiguri Krishi Gamin Mozdur Sangho and wrote letters as it appears from the record. Hence, considering all aspects, fact, circumstances, nature of the case, role played by the concerned parties, we find it to be just and proper if the opposite parties number 1 and 5 are held liable. Jointly and severally. On the other hand, the complainants are also liable to the extent for not taking proper and adequate steps in respect of payment of loan and selling of the stored jute in time for which they became defaulted to the bank. And by filing the case before the forum, treating the same as lottery center and or jackpot, they cannot be allowed to avail the benefits and or indulge in respect of claim of rupees 5 lakh as compensation, rupees so and so.
I'm already confused.
I got confused. Which way he was selling? Only admitted fact is this: the farmers did not repay the loan. They should be thanking their lucky stars that Mr. Gupta's clients had not held them up under surfacing.
Yeah, anyway, let us just proceed.
And we informed all concerned that as on the date they approached us, they never approached us directly before they went to the post-mortem because our departmental purchase centers are there in every district. They could have directly approached the JCI that you purchase my jute. Whatever they felt right, they had their own wisdom.
Even today, Mr. Mujumdar, if they approach you, your concern.
At that time, we were ready to purchase the MSP level. What is today's MSP? We will purchase it.
Yes, today's MSP of this.
But the jute is nowhere.
What happened to the jute?
We do not know. None of the judgments say that jute has decayed, jute has rotted away, or jute has been destroyed.
Yes, jute is otherwise perishable after a time.
A dry jute takes time to get ready.
Dry jute. This was dry jute, no?
Dry jute.
Dry jute.
আমি গোডাউন ওনার যোগবিন্দ বড়
আপনার হয়ে কোনো লয়ার আছেন আপনার কোনো
না না আমি
আপনি ইনপার শুনবো আপনি
This is the
শুনবো
most
আপনি
difficult part of the whole thing.
শুনবো আপনি yes
To register petitioner in person. So, my lord, the district consumer forum was very much confused. At one place, your lordship will find he has also blamed the godown owner. The godown owner should have taken steps to sell the jute.
very good.
So, upon this confused judgment, an appeal was carried to the state forum, my lord.
No, but what is the other points?
Lordship, say whether the complaints have proved their case with respect to the alleged dispute beyond reasonable doubt. My lord, it is very wrong.
First of all, it need not be proved beyond reasonable doubt also. Preponderance of probability is the test.
No, my lord, I am not on the quality of proof that the.
No, you are not. I mean,
My submission, humble submission, I cannot be featured in within any four corners of the complaint petition in any view of the matter. The farmers went to the bank, they gave a particular rate of jute per quintal. I do not know what were the modalities of the bank. I should not.
no, the farmers entered into a loan agreement with the banks.
Yes.
Now, that loan could not be repaid by them.
No, because they couldn't sell the jute.
Because they couldn't sell the jute. For that, they have now filed this complaint before the forum saying that you are also responsible because you refused to buy at the whatever rate, and the bank also did not. What is the
My
grievance?
lord, the bank did not sell the crop. Their prime allegation against the bank is why the bank did not sell my crop. It is in the order, my lord.
The jute was the security for the loan.
No, it was
Could not be agricultural loan, must be.
yes, it was hypothecation
Pledge.
of the crop, but pledging of the warehouse receipt. So
Achha.
bank was not under any compulsion to sell the loan. I will satisfy once my lord Mr. Mukherjee finishes.
Very well, yes. Yes, Mr. Majumdar, yes.
As your lordship was indicating, the grievance against Jute Corporation is not Jute Corporation, his officers, that they did not buy the jute at the rate that the farmers wanted to sell.
Wait, let us hear Ms. Sarkar on this. Would you like to add anything? Then you can add, because this is the primary consideration.
And the state commission just proceeded on that.
Same score. Did not add anything further. I mean, anything substantial.
Only thing that the farmers had filed a reply in this
Achha.
affidavit.
In this court,
Yes,
achha.
ma'am. Look, if your lordship kindly takes page 86.
Yes, 86.
To the Secretary Jalpaiguri Krishi and Gramin Mazdoor Sangh.
86 of the opposition or
Opposition.
page 86. Decision with reasons. These are part of the judgment. 87. There are two paginations. Oh, there are two sets of paginations. Very well. The other 86 I'll find out.
But, or it may be 49, some annexure B.
Annexure B, all right, we'll just find out.
49.
49, yes. 49.
Mr. Majumdar, one opposition.
49, Mr. Majumdar, yes.
No, my lord, please refer to your letter number deal dated. The Jute Corporation of India Limited is engaged in procurement of raw jute when the market price is equal or to below the minimum support price. There are departmental purchasing centers of the corporation in Kuch Bihar region where the corporation purchases from the jute growers at the DPCs at MSP, which is 2200. So it was not 100% refusal. We asked them to go to our departmental centers and sell the jute at 2200 rupees because that was the MSP at that time.
All right.
Now they want the jute to be procured at a rate that was not prevailing at that time. They want the Jute Corporation to buy the jute at rupees 4,800 to 3,200, which was a rate prevailing before a cut-off date. And that is admitted, madam. That on before 4/11 to 2010, it was that. Even we say so. But the jute price fell. So when the price falls, we go for a lower price. When the price hikes, we go for a higher price. We, the Jute Corporation, doesn't have any enmity with the farmers. But
Mr. Majumdar, this was the MSP which was sought to be taken away by the new statute regarding which those agitation took place.
I am not aware, madam.
Well.
And Lordship, on 14/6/2000, before this, they had written a letter. This was the Jalpaiguri Krishi Gramin Mazdoor Sangh. This was the organization who took up the cause of the farmers, rightly or wrongly, but they were heading the.
So you wrote to them?
So they addressed to us, we wrote to them. And no farmer directly or directly had approached the Jute Corporation of India.
Who are the opposite parties here? Farmers personally?
In our CO, it is the farmers personally.
Personally. So, but how did you get their names then?
From the petition of complaint, madam.
The complaint was lodged by the farmers themselves. Right. The farmers did not approach you personally.
No. Oh, first, no. First, they went to the bank, they placed the, put the produce in the godown, went to the bank, took us 60% or 50% loan. And then they asked us to buy the jute at the rate they had placed them in the bank.
That they had individually asked you to.
My lord, most probably, I don't have any.
Because you were addressing some, their union.
They wrote us letters. With reference to above, we beg to state that we the 38 farmers stored.
What is this? Which page?
This is my lord 84 or 129, either of them, of the opposition. The association that took up the cause of the farmers. Last page of the opposition.
Pagination with Sarkar is very unfortunate.
No, it
Two,
is
three
Mr.
paginations. Two, three paginations, different sort of paginations.
By honorable court.
Very well. Yes, last page, yes. What should be the actual page? Page 119.
129.
It's written 11. There is no 129 written anywhere. As a 129 will like.
Last before the back sheet.
Yes, we've got the page. Yes.
With reference to the above, we beg to state that we, the 38 farmers, stored, I think, my lord, it is the same gentleman who is before us today, before your lordship. He is signing. 38 farmers stored 86.885 MT of jute in Bharatiya Gramin Bhandar from 7/8/2010 to 2/11/2010 and received pledge loans from bank. The market price was 4,200 per quintal up to 7/11/2010. And the Jute Corporation of India Jalpaiguri purchase price was also 4,200 per quintal up to 4/11/2010. Due to fall of price jute after those dates, farmers have been running to ruinous conditions. So we would like to convey you about our distress situation and pray that you would be kind enough to purchase our stored jute with the rate of rupees 4,200 per quintal as existed up to 4/11/2010 and as the maximum and save us all and oblige thereby. So this was written in 2012 asking us to purchase some product that was a price that was in the prevailing in the year 2010.
Did they first approach you before 4/11/2010?
No.
Well,
so our predicament was even if you wanted to purchase their jute, and that always we do, but on the MSP.
Okay.
Even if today they could bring that jute within the MSP, whatever
yes,
today is prevailing.
that is what I asked you. That
we will purchase it. So, my lord, in my humble submission before your lordship would be, Jute Corporation of India cannot be entangled in this consumer, and this is not a consumer dispute at all. If the farmers, my lord, have some right, maybe they are having some right under the law, under the common law, under the constitutional or statutory law. There is different forum for them to enforce it, as your lordship was indicated, but not under the consumer forum. If they want a particular portion of a statute to be activated, the constitutional courts are there. They
yes, we are thinking of that also. There could be a PIL, there could be a writ petition, many things. Anyway.
Finished with there, but not consumer forum.
Very good. Yes, Mr. Sarkar first address his Mr. Mujumdar's arguments, then Mr. Gupta will take your revisions later. Let us hear her on this. Yes. No, what about this Jute Corporation? So then Mr. Gupta, let him complete and then we'll take you together. You are supporting her. Not her, I mean, not the farmers, I mean, but the same interest. Very well. Then we'll hear you together, the farmers and আপনাকে আর ফার্মারদের আমি একসঙ্গে শুনবো আগে বুঝে গেছি হ্যাঁ for the farmers no we'll hear the bank first let us take the arguments of the bank the two sets of petitioners you jointly address some of the arguments will be common for you regarding consumer forum and whether they're consumers yes Mr. Gupta will hear you
take the page CO 127
CO 127 অলরেডি। আচ্ছা এই অনিন্দিতা, আপনি না এইটা এই 142টা আর 127টা বেশ করে শুনছি আমি। এইগুলোর পেপারস গুলোই যাবে যখন যাবে।
Lordship, may I be permitted?
টু লিভ?
No, no. This was a resolution of the can be following.
Whatever, Mr. Mujumdar, what I do in the principal bench also, I continue sitting. If you want to argue, I'll hear you. If both sides don't want to argue, then we'll not hear.
If they should decide whether they should continue.
No problem. Let us continue. Circuit is very limited.
Yes, that's why I mean, if both sides are present, now that is the resolution also. Resolution is not that you go away. I mean, don't pass adverse orders. That's usually. I don't pass adverse orders unless all sides are present.
They should decide what to do.
Yes, yes. Let them continue. Yes. CO 127 din. Yes, Mr. Gupta, let us hear you on CO 127.
Yes, my lord.
Right.
My lord, before beginning, I will just place
Yes.
the actual facts and the basis in which the bank is there.
Please.
My lord comes to page number 34. Annexure P1.
Yes. Yes.
Yeah. My lord, this is the notification of dated 3rd May 2007.
Yes.
Yes. I will just read out a portion.
Mm-hmm.
We have our loan scheme, namely advance against warehouse go down receipts adopted by the bank. The scheme is made for cultivators who are forced to sell their agricultural products at a very low rate just after harvesting crop. The scheme intends to help the helpless farmers, especially who take crop loans from our bank. Now, my lord, comes to C, security. This part is the very important part. Loan will be secured by hypothecation of the produce through pledge of warehouse go down receipts. My lord, we have hypothecated the crops. We have not taken the crops. We have only pledged the warehouse receipts. The crops were entirely with the farmers who were at liberty to sell the crops and pay off the bank debt. So bank, in one sense, has provided a financial assistance. It is not at all a service provider.
All right.
Now, my lord, comes to page number 62 and 63. Only 62, my lord.
Yes.
29, this circular has been exhibited. So the learned forum has definitely taken course of this circular while passing the judgment. Now, my lord, comes to page number 63, the main decision with reason.
Right.
Okay.
This
My
is
lord,
which
I will-
this is which forum, Mr. Gupta?
My lord, district consumer dispute
The
redressal
district
forum.
itself. So we are focusing
Yes.
on the district because that has been repeated basically.
Yes, that is the frame. That is the
Very-
main thing.
very
My
well,
lord,
very-
senior counsel, Mr. Mojumdar has told the entire thing. I will just point out a single part.
Yes.
Point number 2. Whether
Right.
the petitioner of complaint contents consumer dispute, if so, which are the disputes and what for? My lord, the petition of complaint contains so many disputes, but from the materials of record, we find that the prime disputes are that in spite of having provisions and in terms and conditions of the pledge loan. My lord, point number 1, this is not a pledge loan. We have not pledged the crops. We have only pledged the warehouse receipts. The opposite party number 1, 2, and 3, despite their approach, denied to purchase the jute stored at the godown of the opposite party number 6, and the bank, that is the opposite party number 5, which has sanctioned the loan, has not taken any initiative to sell the jute either to the JCIL or in the open market at that existing higher price of jute at the relevant period. My lord, this is the prime allegation and this is the prime reason why the forum has held us guilty.
Yes.
My lord, we are not the person who are bound to sell off the produce. Yes, we do have an option to sell off the produce, but we are not bound to sell off the produce. Now, this is the prime grievance against me, my lord.
All right.
Now, my lord, page number 66.
Yes.
Whether the pro forma opposite parties number 6 and 7 are factually and actually the opposite parties, if so, who's the opposite party? My lord, a little towards the end, opposite party number 1 to 5 at the grassroots level are concerned officers to implement the policy of the government according to the act.
No, I have
laws,
not got that. Which portion?
Page number 66.
66, yes. Under point number 7.
Point number 7 towards the second part.
First paragraph.
Second paragraph, point number 7.
Point number 7. Under point number 7, the very first paragraph. Simultaneously.
Very first paragraph towards the end.
Does it start with simultaneously, that sentence? Simultaneously opposite party number 1 and 2 at the 1 and 5 at the grassroots level.
Yes, my lord. Yes, my lord.
Yes.
Are concerned
Yes,
concerned officers to implement the policy of the government according to acts, laws, regulations, circulars, directives to achieve the goal and for which employees are paid off. From the materials on record, the poor farmers are not in a position to bail the cat, and it has been done by the OP number 6, then what is wrong? The record shows OP number 6 is entitled to get the rent of the godown by keeping the jute at the godown and nothing else. On the other hand, OP number 5 is the beneficiary in respect of providing pledge loan. The moment they are terming the loan as pledge loan, the entire thing is falling on the bank, which we are not at all a part.
Mr.
No, my lord.
Gupta, please just explain the difference between the two concepts.
My lord, pledge and hypothecation are different, two different things, my lord.
Yes.
In hypothecation, we are not holding the crop. But in pledge, the entire crop is to be stored with the bank. Bank will be the entire custodian of the crop, and the bank shall have the liberty and the right to sell off the produce. But like, my lord, if we are hypothecating a vehicle to a bank,
yes,
I have the right over the vehicle. I have the right of the entire vehicle. I can ply the vehicle on the road. The bank is not keeping the vehicle stored. But in pledge, the bank has the entire right.
In hypothecation, the ownership is
with the farmer. Is with the farmer.
Very good. Right. Get your point. Yes, please continue.
Okay. So my lord, my point in short is this much only, that I have neither given a service, I have neither given a defective goods, I have merely extended a financial assistance wherein I have made the payment of the money to the farmer. The crop of the farmer might have gone stale or they have failed to sell, but at the end of the day, the only person who has lost the money is the bank. The farmer has not suffered the loss. Their money did not go. The bank had paid the money, and it is ultimately the bank's money has gone. And now as per the direction of the learned District Consumer Dispute Forum, the bank is again liable to pay the compensation to the farmers. That makes double jeopardy. The bank has not got any single money. This is my humble submission, my lord. Consumer Dispute Forum does not have any
If there was any
jurisdiction.
deficiency regarding if there was a relationship between the farmer and you, yes, definitely, you gave a loan. But if there was any deficiency in such service, you did not give the entire loan or did something regarding the loan, then still it could,
No,
might have been
there,
argued.
my lord, this is
No, then still it might have been argued that in your capacity to supply the loan or
correct.
there
Yes,
some
my lord.
deficiency of service was there.
Yes,
Here,
but
there is no dispute that you have not given the loan amount.
not a
Entire loan
dispute.
was
This
given to
dispute is
you,
not there.
but it's on a different cause of action regarding the Jute,
Their
they're
cause of
not
action
getting the
is why
price.
their cause of action is we might have defaulted in paying the loan, but
Very well.
why did the bank not sell the crop to get the loan?
But then this you say is this hangs on the string of the pledge loan concept, which was
My
the
lord.
premise of the order, which you say it is not because there
No,
was
this
no
is what
pledge
is
regarding. As
that
you've
is
shown.
why I have shown the notification. Mine is
You rely on that
hypothecation
notification
of
for
the
this, right?
my lord.
That notification was page 34, right?
Page 34, my lord. That is the main Bible of the loan. I have made
Very,
it
very well.
specifically that hypothecation of the produce with the pledge of warehouse go down. I need to have some record. So the warehouse receipts, not even the warehouse. I have kept the receipts.
Acha, when you hypothecate, when a car is vehicle is hypothecated, the owner is the person who is driving, who is getting the car. Is
Yes,
that the concept?
yes, my lord. I am buying a vehicle on finance. I get the vehicles because the hypothecation is done on the vehicle.
Ownership is
But
transferred on your name, in your
yes,
name, the
in the
person's name.
blue book, in the registration certificate, it is my name. The registration
Mr.
certificate.
Gupta, we think it's the other way around. A hypothecation, probably the person who buys the vehicle does not become the owner unless the last installment is. That is where my confusion arises actually.
My lord, I will clear it, my lord. The key points in pledge and hypothecation as per the
It's a
Contract
different
Act.
concept.
In pledge, the possession of the good.
So it's not about the ownership of the possession.
Exactly, my lord.
The bank, but the bank that even if it does not give the possession, if it's a hypothecation, then isn't the bank the notional owner?
No, my lord, bank is absolutely not the owner. I will explain it once again.
If it's
In
a vehicle,
pledge,
explain to us with the example of a vehicle first.
with the example of my lord,
Vehicle, car.
my lord, my lord.
Suppose I want to purchase a car. It's hypothecated to the bus. Buses are all hypothecated mostly to the bank.
Yeah, the buses are hypothecated to the bank.
So
But
does the bus owner, so-called bus owner, become the owner before the last installment is
my lord,
paid?
the vehicle owner or the bus owner will definitely be the owner of the vehicle, but
He is entitled to use the bus, utilize it, but doesn't the bank remain the owner?
my lord, if I am purchasing a vehicle or I am purchasing a property, who is the owner of the property? I am the owner of the property. The property is hypothecated to the bank. In case
That's the
I
difference probably between a hire purchase and a hypothecation.
my lord,
If it's a
the
hire purchase,
Hmm.
then you purchase, you become the owner, but you have to repay installments. But in
It is.
hypothecation, it's the other way around. If it's hypothecated, the bank can at any time come and say that it's my vehicle. You are not paying.
My lord, but whatever it is, the bank is not under any compulsion to sell the vehicle. I mean, under no law, the bank is under a bounden duty to sell the vehicle in case I do not sell it.
No, there's a difference in concept because here the loan for purchase of a vehicle and loan for crops, because here the loan is entirely it revolves around the sale of crops. That is the only purpose of the loan. I mean,
Yes,
it's
my lord.
entirely on the sale of crops. But in respect of a vehicle, the user of the vehicle is the important thing. So there's a
My lord.
different notional difference between the two hypothecations.
There is a notional difference, but in this case, my lord, let me come back to the crops. The
Yes.
crops were stored in a godown. The godown
Right.
receipts were placed. The
Now,
crops
Mr.
were
Gupta,
not placed.
they could have sold the crops. So the
Yes,
the loan
they
was
were
given.
always under liberty.
So it was by way of a loan. What was
Yes,
the
my lord.
security for the loan? The warehouse only.
The warehouse receipt, rent receipt.
You did
was
not have
the
any
security.
right on the crops.
No, no. That is why they had approached JCIL to sell the crops. Why else would they go to JCIL to sell the crops? Their prime grievance is against JCIL. Why they did not purchase the crops? If
Very
they
well.
did not have the liberty to purchase the crops, they would not approach JCIL, my lord.
When would your right accrue, Mr. Gupta, to seize those crops and do whatever you like with them? When?
In case
If they fail one
fail to make
installment, if they fail to repay the first installment, doesn't that right arise in your favor in hypothecation?
the right arises, but it is not bound on me to sell the crops. The right obviously arises in case they default in making the payment. The bank had the liberty to sell the crops and make good the losses. But that is not as per law. The bank is not bound to sell the crops, and that cannot become a direction, or that cannot become
So that
something
cannot
against the
be a
bank.
deficiency of service on your part insofar as the loan is
Exactly.
concerned.
That is what I
Period.
wanted
You
to.
had the option, you could take it, yes, definitely, in satisfaction of your loan, but that does not cast a liability on you. If there
On
is no
me,
liability, there is no deficiency also.
my lord had got the entire scene.
Very well, very well, very well. So what else, anything else? So you are
No,
not a
my lord.
consumer in that sense, and this is on merit also, this is your.
This is
Well,
the exact same is with Mr. Mojumdar, whatever he has.
The rest is, yes, regarding consumer, yes, Mr. Mujumdar is probably on a slightly better footing. We'll hear the other side.
My lord, he always is.
No, his client. Yes, what is your role in this entire thing?
My role is here. I am
To give some protection to the farmers.
kindly come which my learned friend said, Mr. Gupta is a Bible. I will take up a Bible on page 30. You said I am multicolor.
Yes. Yes.
Page kindly come page 35.
35.
But kindly see the interest rate. 1, 2, 3. 12%. Lordship got it? Interest rate?
Interest rate,
heading,
yes.
Heading interest rate.
Yes.
Then kindly see the, I think it is I or J.
J. Because
Now-
a tick mark has been put here at J by some predecessor in office. Yes.
Bank will have the right to take possession and sale of goods for recovery of loan at any point of time, depending on position of loan account, falling market price, and or deterioration in the quality of stored goods.
Mr.
Then
Ms. Chaudhary, there is a distinction Mr. Gupta is trying to draw here. He has a right to take possession, but a right does not translate into a liability necessary. That is what he's saying.
My lord.
He had there's a right to take possession, but he has an option not to take possession also. He has a right to take possession and sell off the goods. But if there is no obligation in law, he has to take possession and sell off the goods. There cannot be any deficiency of service. That is his argument.
by virtue of the agreement, it says the power has been conferred upon the bank.
If this was instead of a right, a duty, the bank shall take possession, or the bank has the duty to, or obligation to, or responsibility to, or even shall would do, bank shall take possession or sell off, then we could have understood. Here the bank is given a right to sell, take possession and sell off the goods. If they don't sell off the goods, now that is a right given to the bank against the borrower. Whether the borrower can take advantage of that and say that you have not asserted your own right. Suppose I have a right to, I have a money claim against you. Can you come and say that I have not not done my obligation by not making my claim? It's the bank's right. It has not asserted, and you should be lucky for that you have not taken.
Bank has the obligation. Suppose the borrower has failed to do.
What is the obligation? It has a right to take possession in satisfaction of its loan.
If lordship sees, if they fail to make an installment, then the bank has a right to take possession, and then whatever the right
But in those cases, there is no deficiency of service, Mr. Chaudhary. How can you blame them for not taking it and selling it and not getting you the money?
But Malad, the moment, Malad, the relationship between the Malad, Ms. Sarkar will clarify, and even what we are discussing. Suppose now, Milord, I have obtained a financial assistance from a bank. It's an individual, Milord. And then, Milord, suppose now, Milord, I am giving another example. I am a customer of a bank. I have hired a locker. I have kept whatever the security is there. Then there is a bank robbery.
Full liability on the bank, because bank has the liability and responsibility to protect that.
Yes.
Here there is no such liability. That is the line of distinction he's trying to draw.
Now, Milord,
If it was a bank locker,
consumer within the definition of
you are not a customer of the bank, and this is not a case of a locker. Even if you had an account and the money was swindled off, bank has a liability, NI Act. But here it is not such a scenario. They have a right to take possession if you don't repay the loan. So it's their right. Can you castigate them on their own right, which they have not exerted against you? Isn't it not a double jeopardy?
which by right has been vested on that.
Because they have not taken possession, because as per you, they could have taken possession and sold off the
Yes.
property. Very well. If they don't do it, I mean, how can you then even then can you castigate with the liability to pay you money also? They have given you the loan in the first place.
Right.
Yes.
Or then if I do not pay the interest, then the bank has all the probable the ventures which can be exercised by the bank. Then it will not fall in the meaning of definition of deficiency of service. Then I have not acted upon, because my individual capacity.
That I have not asserted my right to satisfy my loan. I mean, your loan. You have taken a loan. I have a right to take back the property, and I don't assert that. That's a deficiency of service to you.
Then kindly read the next paragraph. What is my role to be played?
Then the bank could say that you are my consumer. You took a loan and did not repay.
Yes, no,
Tomorrow that will be done.
Definitely under the Service Act it can be dealt with.
That's a different.
That bank should recover by way invoking this jurisdiction.
This appears to be.
The question here,
I mean, forgetting for a moment, we are just on the law. Forgetting keeping aside our sentiment for the condition of the poor farmers. Definitely, all of us have that. All of us were here. But keeping that apart on law, then I mean, where is the liability of the bank? Show us the other.
34 আমি 34 পড়ছি আমি পড়ছি আমি দেন ব্যাংকে ওটা দেখেছি then below the next paragraph the duty of the bank branch
Yes,
manager.
yes.
The branch manager should closely monitor such advances including inspection of the pledge stroke hypothecation. There is a pledge stroke hypothecation.
Yes,
Goods has been
he says the
hypothecated.
pledge is in respect of
What
the.
is I can say that it has been hypothecated.
There is a
Why-
pledge regarding the warehouse
pledge regarding the warehouse, but the
and
goods
hypothecation regarding
belong.
the.
The farmer they produces the goods, the produces. The
Yes, whichever of this is applicable, pledged or hypothecated.
Hypothecation. If I take the hypothecation,
Yes, hypothetical. Let us proceed on
yes,
hypothetical.
hypothecated goods. The goods is the raw materials
Yes.
and periodical contact with the warehouse, godown, cold storage authorities. He is the cold storage.
For what purpose? Let us read the entire sentence.
What I am saying, because of this, the role of the bank for inspection and monitoring.
Read the entire sentence. We have to see the purpose of that monitoring.
For recovery of bank advance. Last
You
line.
have not. Please read the entire sentence from
Well,
branch
wait.
to end.
The branch manager should closely monitor such advances, including inspection of pledged hypothecated goods and periodical contacts with the warehouse, godown, cold storage authorities, so that timely actions can be taken by them for recovery of bank advances made this scheme.
It's for them. It's not a liability towards you.
Not me.
If that be so, then you cannot. This is not a deficiency of service. You are turning the concept on its head. It's the bank's right to have a close monitoring, and branch manager should do that for the purpose of recovery of the bank's loan. Then the branch manager could be castigated by the bank, not you.
Bank.
It's not a service given to you. It's the bank's service to itself.
Ask whether I fall within the definition of consumer or not. The individual, the borrower, whether it will come within 2 subclause 1 subclause D or not. This is the crux, Milan.
Only question
Only question.
regarding
Regarding-
jurisdiction.
If it is 2 subclause 1 subclause D, I fall, then the rest.
Then rest follows, then rest. There are other arguments, we'll look into that.
So, Malad, at this juncture, my lord, if your lordship sees the who falls, if you read, Malad, even the statute, my lord, who are the consumer, how the defensive services can be dealt with.
But this heading is interest rate.
Yes.
No, J is a different clause.
Kindly forget.
No, J is a different clause, not
Yes.
interest rate.
This is.
Yes, this is J. J is not interest rate.
J-
I is interest rate.
Yes.
J is a different clause, you're right.
Bank, yes, bank will have the right for sale and recovery of the loans. Inspection. And may not is. Then the inspection that I'm saying, na.
So this is the most important document appears to be. Relied on by both sides. The Bible.
What the? Is the warehouse go down storage should be endorsed. My lord, kindly even my
Yes,
learned
yes.
friend even pointing out. G,
Yes.
Inspection and storage.
G, yes.
Yes, 35 page.
G, yes.
2. Roman 2.
Yes. This is warehouse.
The warehouse go down cold storage receipt should be endorsed in bank's favor.
That is what he's arguing, that warehouse receipts are the pledged.
Kept with a loan document.
They have kept it. Maybe.
There must be a letter of undertaking from the warehouse go down cold storage authority not to deliver goods without authorization from the bank. So bank definitely has given such authorization.
How does it make a difference?
Then Milord, if he has authorized to the Milord, the cold storage to keep it, the raw materials, then the bank has a right to sell.
Roman 3, the next one may be important for you.
Delivery should be made to the borrowers against corresponding payment of loan amount. Suppose now, Milord, the delivery of goods were there, some portion of amount has been paid. I could not repay together with the interest, then what will happen? This is, Milord, this is very interesting even, Milord. We require further, Milord, research, whether it will come within the definition of purview or not. It cannot be in one line, it cannot be, Milord, to some extent.
That is precisely what has been done by the forums. In one line, it has been stated because it comes with it. That is the difficulty. If some reason was given,
Yes, yes.
that
Why
is the.
Why the double Roman 1 D will come?
That is repeatedly, it has been heard by all high courts and Supreme Court. The reason is the soul of judgment. Why? Because the appellate court or the challenge court will have a look into it.
So that
It's absolutely devoid of reason.
Yes, it is devoid of reason.
devoid of reason, but
Let us see even if you can, supply the reasons if the conclusion is correct. They have to satisfy us on that, at least prima facie. Delivery of goods will be made to the borrowers.
Yes.
Made to the borrowers by the bank then. If that be so, then delivery, the goods must be with bank. Bank will
and without authorization, he will not deliver.
deliver, but the goods is in the warehouse. No, authorization is something else. Although whenever you try to, because it's a pledged commodity, they have to take your authorization before selling it.
That's authorized. If it suppose he doesn't authorize.
But authorization here, if they did not authorize, you could have still claimed a deficiency of service. You are right on that. All these are liabilities of the bank.
Suppose he has authorization has given his benefit. Then also deficiency will not come, Malad.
If he has given authorization, what is the deficiency?
Thereafter,
He has given you the loan, he has given you the authorization, you go and sell.
pay. The Miller's kindly the problem arose where JCI, Jute Corporation of India, Millard, under the statute, Millard, all the rules, regulations were
JCI, even if you say it's a statutory violation by the JCI, you have not yet come to JCI.
made. I'm saying that.
How does the consumer concept come in?
JCI will come? What I'm saying, Millard, suppose now the rate fixed by a committee,
X rate has been fixed.
whatever the rate.
Yes.
Because it arose, Millard, this is the obligation that JCI shall purchase that raw product on the rate of whatever the rate they have fixed. They did not purchase. Farmers cannot be held liable also.
They say we are willing to purchase, we were all along willing to purchase at the prevalent rates.
Same, the juncture they did not say, not a single letter.
Where
saying
is there any refusal by them
that
in writing?
maximum sell price?
We told them
No,
we
that-
buy at this price.
No, that maximum sell price. that maximum sale price that time was prevailing, suppose 2,200 something like that, madam.
That Mr. Mujumdar showed that communication
Communication.
where they have agreed to do that.
So this is the reason, that maximum sale price was 2,200, but 2010 maximum sale price was 4,000 something, 4,200. 4,800 in 2010, 200. It was in 2010 prevailing there.
Prevalent, yes.
Then 2011 it has come down. So for
No, at best we can fix liability. We could have fixed liability on the JCI at the rate at the time when the application complaint was filed. Complaint was filed.
Deficiency of service. Rate quoted, I did not buy, despite the rate. It's under the obligation to the JCI, under the obligation to bank. This is the main class, perhaps the consumer forum and the state forums were playing in their mind that this is the reason they are within the purview of the deficiency of service law. Might be, but again I am saying I have not undertaken that extent that is circular.
Let us hear Ms. Sarkar then.
Yes.
Let's hear. Yes, Ms. Sarkar.
I have read the brief of a CO 125 of 2023. If your lordship takes that, my lord, I can show the pages.
The page number, we cannot take so many matters. 127 is just find out the corresponding pages, Mr. Must be similar.
That's the problem.
What you are thinking?
Cannot hear them on one and
Page 17.
Same thing, my lord, the page number is different, my lord.
give us the page numbers of 127, please.
CO, I'm at 125 and 40, so I have marked
Oh.
something, no, my lord.
Acha.
that's
Yes, just check out the corresponding when you just show it to Mr. Chaudhary. He will.
Start with the circular.
CO 127. What is the circular, Mr. Chaudhary?
Mr. Circular, my lord, at
34.
34.
Oh, this circular, acha, yes.
That by.
Yes, yes. Start with that.
Per page is 33. One page.
My lord, the circular clearly states the objective with which the circular was made, my lord. The circular says the scheme is meant for the cultivators who are forced to sell their agricultural produce at a very low rate just after harvesting of crops. This scheme intends to help the helpless farmer, especially who take crops loan from our bank. So with this objective, this circular came. Now, if your lordship sees, my lord, the quantum of loan to be given. So it says 60% of market value or minimum support price declared by government. Whichever is lower may be the quantum of loan subjected to maximum rupees 50,000 per borrower. Now, in this case, these poor farmers, they went to the bank and they pledged their jute. So while pledging their jute, the bank took a letter from the JCI. So what is the market value of the jute? Now, that letter is in page number.
What is the page number of this circular in your copy?
Page number 33.
Well, we'll just reduce one page and we'll get the page number. Yes. What is it? Your page number? We'll minus one, then we'll get the page. 34 is 33.
হয়ে গেছে এখন হচ্ছে আমার যেটা লাগে
ব্যাংকের তো JCI
হ্যাঁ।
undertaking.
undertaking that is in page number 176 of my year.
It starts at page 170.
176, that is only one page.
One page.
Page number is
এই পেজটা
আরে ওই চিঠিটা আমরা
না এখানে নেই আরে 127
Madam, might be 171 of this petition if they are.
Acha. Thank you. (171) 15th May.
15th May.
Thank you very much, Mr. Gupta.
My lord.
It does not mean you win the matter, but
No, not at all, my lord.
no. This should be appreciated. Yes, 171. Yes.
The market value of the jute at the rate of 3,800 to 4,200. JCI. Accordingly, the loan was given on the market value of the jute. And each farmer, there were 10 farmers, they got 50,000 rupees each from the bank as a loan. 50,000, only 50,000.
Oh, so they get the loan on the basis of this, but when they try to sell it, JCI says no, it has come down.
Yes.
What was the time gap between this taking of the loan and trying to sell? Pardon? Very well. Very well.
Within 2.
Within 2-3 months. That's very well.
Data of 15th May 2012, and the loan was, I think in September.
So,
September 2012.
so the loan was
Loan was in September.
kept in warehouse, my lord.
Loan was given when?
Loan was given when? The loan was given on in loan 2010 it was given, my lord.
2010 2010 পর্যন্ত লোন দিয়েছে তারপরে লোন স্যাংশনটা হলো 2010 ওই 11
2010, my lord, the loan was sanctioned, my lord.
10-11 মধ্যেই লোন
This is the Jute Corporation of India writing to one of the farmers.
No.
Writing to whom?
It wrote to the bank.
No, address to the message.
Yes.
Who are these people?
Yes.
I mean,
How that?
Farmer, definitely a farmer. No.
It attacking.
To whom? You have annexed your annexure.
It is.
You cannot take up any document and
এটা ভারতীয় গ্রামীণ ভান্ডার হবে তো জেসিআই মানে এই টাইপটা ভুল আছে এটা জেসিআই দিয়েছিল ভারতীয় গ্রামীণ ভান্ডারকে জেসিআই এর দামটা সেই সময় কি ছিল 2010-11
to whom was it written? I want a clear answer, Mr. Shah. I want a clear answer to whom this is just a document which you could have got it typed anywhere. Could have got it typed anywhere.
by the bank.
My lord, based on.
Bank has
Where is the original? This is a true copy.
My lord, this CO has been filed by the bank, my lord, and based on this only the bank gave the loan, my lord. This
So
document.
this is the bank's CO. This is an admitted document addressed by the bank.
Absolutely, my lord.
All right.
Based on this rate only the loan was given. And it further says that the loan facility under the scheme is for period not exceeding 6 months, only 6 months.
But Mr. Gupta, can you shed some light on this? Who wrote to the JCI wrote to whom? It is your
No, no,
document,
this-
your annexure.
Malad, this entire annexure set was annexed with the main application which was filed to the before the District Consumer Dispute Redressal Forum
Ah.
by the farmers who had approached them.
Ah.
My lord, so that is the main part, my lord. Whatever it is, the loan, giving the loan is not disputed. They receiving the money is also not disputed.
No, it's on a different question. Well, let us see. You have it.
Kindly see the again I will give a little down CO 125
Hello, 125 টা দিন তো কাগজ
page 50 10 of original.
এটা 125 which page
Page 54.
of the opposition
For KPDP of এটা opposition.
আপনি চিৎকার করবেন না সবকিছুর একটা সীমা আছে
KPDP in person, that is his opposition.
আপনাকে আলাদা করে আমি শুনবো আপনি ওনাদের হেল্প করতে পারেন কিন্তু এরকম চিৎকার করে হেল্প করলে their opposition
Yes, Lord. In person.
opposition
Epidemiologist in person 50,
on behalf of
50. In person, there would not 50. Neo in 1, 2, other 2.
yes which page
Page 5.
Lordship, tally, both documents are only the addressing
Right.
JCI's letter.
Bharatiya Gramin Bhandar it should be.
Yes.
And this was your document, the farmer's document.
They gave the letter. The JCI gave the letter.
Farmers produced this document in the complaint. So who gave to whom? What is your pleading in the complaint? See that.
Complaint is in page number.
You take up, don't give the page numbers. You just find out where have you referred to this document. This becomes a very important document then.
Number 2, my lord.
Read it out. Who gave to whom?
Paragraph number 2, my lord, of the.
What have you stated? Just read out who has given to whom. Who is this Messrs. Bharatiya Gramin Bhandar? আপনার কিছু বলার হলে ওনাদের বলুন পাশ থেকে চিৎকার না করে। To the godown owner. Very well.
May I, my lord, in the plaint of the Consumer Protection Act, my lord, the plaint.
How do you refer to this document in that plaint?
Paragraph number 4, the opposite party.
No, paragraphs we don't need. Just read out.
Of the consumer complaint.
Read out the content.
The opposite parties promise to purchase the jute under the instruction of the Government of India with scheduled rate, and in this regard, the regional manager, Jute Corporation of India, Kuch Bihar, issued a letter to the proforma OP number 6.
So this is the proforma OP number 6, which is the who is he? The godown owner. No, don't show him. What is the capacity?
Wide memo number such and such, with which itself depicted that the purchasing and the promising price of the jute was fixed from 16/9/2010 to 4/11/2010 of rupees 3,800 and of rupees 4,200.
Maximum. And the quantity.
My lord. Based on which, and after cultivation of the petitioner kept stored in the following quantities of jute in the godown. And thereafter, my lord,
this was in answer to some query from them.
My lord.
That is not given anyway. So what does this mean? Operated its commercial operation for a short while period from 16/9/2010 to 4/11/2010.
Yes.
In 2010 to 2011. So during this period, that was the rate.
Which the bank gave the loan, my lord.
This is very well. The loan was given from during that period. What was the first date on which the loan was given? First loan, 2010. Which month? During September to 11. September to November. And Ms. Sarkar, just because the bank loan is given on the then prevalent at the time of loan, an MSP was prevailing. Just because the loan is given on that premise, is it bound? Are the JPC bound to JCI bound to give that rate forever? So then it may be that the
Used to buy, my lord.
but the MSP might have been changed.
Yes, my lord. If they
When did you first attempt to sell it?
my lord, first.
Did the farmers at all make any attempt to sell
Yes, my lord. They made an attempt
to them?
sell them. They
When-
refused. Thereafter,
When? Where are the documents? Where are the documents?
6/9/2010. So,
Loan was
6/9/2010.
6/9/2010 till last one in November 2011 probably. No, the godown owner can help you. Probably you can take help from him. Last date, ask from him. Ask him when is the last.
2011. 16/11/2011.
16/11/2011. So this rate was given according to the JCI up to 4/11/2010. So when did you first try to sell off?
thereafter.
When did you get the loan? During 6/9/2010 to 16/11/2011. So this was to cover your sale price. I mean, this loan was given so that you can, some support is given to you to grow the crop and sell. When you first tried to sell,
No, the jute was already
jute was already there.
there, that it was deposited in the godown, and on the godown bill, and there the loan was given, my lord.
Why was the loan required? For what purpose?
My lord, it is so that, my lord, the farmers could survive, my lord, for the survival purpose of the farmers. Only with that concept, this loan was given, my lord. And my lord.
And
further-
they will recover that amount by sale and then repay it to the bank.
Yes, yes.
In the interregnum, before you sell and get that money, your survival.
Thereafter. Now, my lord,
When you tried to sell, that is very important.
Yes.
Mr.
so many.
List
things
of
are there,
dates,
my lord.
comprehensive list of dates, because that would be better.
My lord.
Prepare that and come back.
Comprehensive list of dates, that will be sequential events to come.
At least because the premise of the argument, apart from the consumer forum aspect of it, jurisdiction point is very important. Apart from that, Mr. Mujumdar's plinth of argument is that the MSP changed and they are bound by their statutory body, they are bound to purchase at the MSP.
Their case in hand is that.
So we have to look into the dates, Ms. Sarkar, when these loans were taken,
My lord.
because you have produced this document to show what was the JCI agreed rate at the relevant point of time, that is between 69/2010 to 4/11/2010.
My lord.
So
So
the
during this, bound to buy.
two other things are required. We have got one, that loans given that period, and when you first tried to sell, because you have to make an attempt to sell in the first instance, the farmer.
Farmers tried to sell to the JCI, to which they refused.
When first? Those documents, just go through those documents, give the page numbers, give the dates. That is the only thing we have to consider here.
Then what has happened, my lord, they even told the bank to sell because they couldn't sell. The bank wrote to the JCI to purchase the good, to which the JCI said, no, we will not purchase the good at 4,200 because the MSP was low.
Reduced.
Reduced. They refused to sell, purchase the goods.
So where is the problem in that? If they say that we have to purchase at the current MSP,
Bank would have sold, my lord. Why didn't the bank sell, my lord? Because it is as per this.
if you can't say get a
Circular.
price, the bank,
Yes.
how can the bank get a price?
Because we were not being able to sell, my lord. So it was it was pledged with the objective, my lord. If the farmers couldn't sell, my lord.
Very hard bill to swallow. This is not a liability of the bank.
Selling at 10 rupees.
If you can't sell, yes, to secure your interest for subsistence, bank gave you this loan. Understood?
Yes.
For assuring that you get a minimum price, this MSP concept is there. Very good. But if you can't sell, ultimately, they can only purchase at the MSP. They cannot go beyond that. And if you don't get a price in the market, bank has given you the loan in the first place. What is the liability of the bank?
To sell the.
How can the bank sell if the agriculturist himself does not get a...
Say so. The circular says so. The bank will have the.
Bank cannot do magic. It has to purchase itself and bind itself with the jute and go hanging.
Kind of.
If the agriculturist can't find a purchaser, the bank will take it and sell it. Isn't it utopia?
Circular says so, my lord. I am not.
And my lord, there is also
It's
insurance
circular, my lord.
cost. The warehouse should be insured.
Insured. That was also the duty of the bank, my lord.
So all of you cannot argue together. You collate your arguments, come back Monday prepared in the matter, please.
Monday, your lordship's list is quite heavy, if I am not wrong.
All lawsuits lists are there.
Oh, acha, in the other courts?
No, even the division bench is not a matter.
I mean, I'm talking about the other courts also.
No, but it will be in the list.
Can it be?
Let it remain in the list. If you are in difficult,
I need also.
then I'll not mark parted right now, because if I mark parted and go back, then it's difficult. Then futile hearing.
My Monday, let it be Monday.
Let it be in the list.
But like today also, we'll continue to 4:30 5. Let us finish this one.
Thank you. Fair enough.
Monday.
How much time it takes?
All right, person.
The hearing is commenced but cannot be concluded due to paucity of time. Let the matter stand over till July 28, 2025.
No, sir.
কোনটায় যে নোট রাখবে আমি বুঝতে পারছি না। এটা আলাদা করে একটা ফোল্ডার করে কিছু একটা ছোট করে প্লাস্টিকের ফোল্ডার জ্যাকেট ফ্যাকেট কিসের সঙ্গে সেটা ভুলে যাবেন। 127, 125 আর 142 হ্যাঁ এই তিনটা হ্যাঁ হ্যাঁ এটা পেজ 1 2 ওটা হচ্ছে থার্ড পেজ ওটা 3 Specific time we won't be able to complete within that. We don't know. Let it be in the list as it is. Mr. Bandhavatan, no, can't help you. এই বইটা ফেরত দাও। No, come my PC, no precedence, Mr. Bandhavatan. এটা কার বই? হ্যাঁ আমাদের আনিয়ে নিতে হবে। Sorry couldn't reach it, but yes.
গল্পের গরুকে গাছে চড়িয়ে গালে ঝুলিয়ে দেয় দায়িত্ব
পাল্টেছে না